Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Dr. Amory Brown and Senator Lawrence Hislop, both of whom are out of the country, as well as Senator Damian Lyder and Senator Anil Roberts, both of whom are ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Christine Carla Kangaloo, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Christine Carla Kangaloo, ORTT, President of the Republic of Trinidad and Tobago, Commander-in-Chief of the Armed Forces, to Ms. Yukima Bethelmy. Whereas Senator the Honorable Dr. Amory Brown is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Acting Prime Minister, do hereby appoint you, Yukima Bethelmy, to be a member of the Senate temporarily with effect from the 12th of May 2023 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Dr. Amory Brown. To Mr. Michael Seals, whereas Senator Lawrence Hislop is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Michael Seals, to be a member of the Senate temporarily with effect from the 12th of May 2023 and continuing during the absence from Trinidad and Tobago of Senator Hislop. To Mr. Rishi N.D. Tripathi, whereas Senator Damian Lyder is incapable of performing his duties as a senator by reason of illness, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Rishi N.D. Tripathi, to be a member of the Senate temporarily with effect from the 12th of May 2023 and continuing during the absence of Senator Damian Lyder by reason of illness. To Ms. Karuna J. Bisramsingh, whereas Senator Anil Roberts is incapable of performing his duties as a senator by reason of illness, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Karuna J. Bisram Singh, to be a member of the Senate temporarily with effect from the 12th of May 2023 and continuing during the absence of Senator Anna Roberts by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, this 11th day of May 2023. Honorable Senators, Senators are required to take the oath.
I, Ukima Bethelme, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Michael Sears, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I am about to enter.
I, Rishi Tripathi, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Karuna Bisram Singh, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, we have today with us in the public gallery students from lower 5 class of the Maria Regina Grade School. Please join me in welcoming them to the Senate.
Bills brought from the House of Representatives. On the supplemental order paper, the Finance Supplementation and Variation of Appropriation Financial Year 2023, Bill 2023, in the name of the Minister of Finance.
Acting Leader of Government Business.
President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken on Tuesday, May 16th, 2023.
Honourable Senators, the question is that the next stage of the bill be taken on Tuesday, May 16th, 2023. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The next stage of the bill will be taken on Tuesday, May the 16th, 2023.
Papers.
Acting Leader of Government Business.
The honour to lay on the table the following papers listed on the supplemental order paper in the name of the Minister of Tourism, Culture and the Arts. The ministerial response of the Ministry of Tourism, Culture and the Arts to the fourth report of the Joint Select Committee on Human Rights, Equality and Diversity on an inquiry into the role of the state in preserving the cultural heritage of the indigenous peoples, First Peoples of Trinidad and Tobago. Thank you.
Minister of Digital Transformation.
Mr. President, I have the honour to lay on the table the following paper as listed on the supplemental order paper in the name of the Minister of Digital Transformation. The annual report of the National Information and Communication Technology Company Limited for the period 2021 to 2022. Thank you.
Acting Leader of Government Business.
Mr. President, I have the honour to lay on the table the following papers as listed on the order paper and supplemental order paper in my name and in the names of the Minister of Planning and Development and the Minister of Public Utilities. The ministerial response of the Ministry of Planning and Development to the third report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the management of the Water and Sewage Authority, with specific reference to the 2020 Cabinet Subcommittee report on WASA and related recommendations. The ministerial response of the Ministry of Public Utilities to the third report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the management of the Water and Sewage Authority, WASA, with specific reference to the 2020 Cabinet Subcommittee report on WASA and related recommendations. The Scrap Metal Regulations 2023. The response by the Minister of Trade and Industry pursuant to Standing Order 41 of the Senate on the strategy for the implementation of the Data Protection Act. Thank you.
Reports from committees, urgent questions, questions on notice, questions for oral answer.
Acting Leader of Government Business.
President, the government is in a position to answer all 4 questions on the order paper.
Senator Mark.
Thank you, Mr. President. Question number 47 to the Honourable Minister of Education. Oh, I beg your pardon. Sorry. Mr. President, before I ask this question, is the Minister in a position to answer adequately my supplemental, seeing that she's not the substantive office holder?
Mark, and again, I've repeated this on several occasions, there is a procedure and a precedence that normally happens. You can ask the question as it is on the order paper, and let's go through the procedure as we normally do. So continue to ask the first question on the order paper for oral answer.
I need to have an audience with you under the particular standing order to address this matter. Okay? But thank you very much, Mr. President. Question number 46 to the Prime Minister.
Acting Leader of Government Business.
Thank you, Mr. President. Udicott addressed this specific issue comprehensively by way of a media release issued to all media dated Monday, June 6, 2022, 11 months ago, titled E-Tender Submissions for the Redevelopment of the Central Block at the Port of Spain General Hospital Structural Works. In that media release, Udicott indicated that at 4:05 p.m. on Friday, May 20th, 2022, the e-tender box was opened, and the online e-tender register showed 2 successful tender submissions. That is, York Structures Limited and Steel Structures Limited. However, as Udicott further stated last year, checks at Udicott's e-tender server logs recorded that 3 receipts were issued, one for each of 3 proponents, confirming that 3 tender submissions were successfully uploaded as follows. York Structures Limited at 11:47 a.m. on Friday, May 20th, 2022. Universal Structures Limited at 12:16 a.m. on Friday, May 20th, 2022. And Steel Structures Limited at 2:24 p.m. on Friday, May 20th, 2022. Udicott also said that the owner and manager of the e-tender software telecommunication services of Trinidad and Tobago Limited, by way of email at 6:13 p.m., confirmed that on the said Friday, May 20th, 2022, the e-tender server logs were in fact correct, and that there were in fact 3 tender submissions received at the times previously stated. The June 2022 media release stated that on Monday, May 23, 2022, a meeting was convened with all 3 proponents as part of the tender evaluation process, and these matters were explained to the proponents, and no queries were raised. In addition, the media release stated that Udicott received a written explanation by letter from TSTT dated Thursday, May 26, 2022, indicating that TSTT directly attributes this to a temporary disruption in internet connectivity during the upload process, which led to the online e-tender register showing 2 tender submissions as opposed to the 3 that were in fact successfully uploaded on Friday, May 20th, 2022. Udicott had included in the said media release copies of the 3 electronic receipts referenced above, as well as the letter from TSTT dated Thursday, May 26, 2022. Finally, on May 24th and 25th, 2022, Udicott's Tenders Committee and its Board of Directors, respectively, approved the award of contract for the structural works to the top-ranked proponent, Universal Structures Limited. Universal Structures Limited was engaged on June 23, 2020, and the works are currently in progress. The project is expected to be completed by May 2024. Thank you, Mr. President.
Senator Mark.
Thank you, Mr. President. Can the Honorable Minister indicate what was the initial completion time contractually agreed to by Universal Structures in accordance with the contract?
Acting Leader of Government Business.
That, you will agree, is outside of the question asked today. So if you pose the question, we will indeed respond to it.
Mr. President, the Honorable Minister has just indicated when the project is supposed to be completed, May 2023. I have simply asked...
May 2024.
Members, please allow the question to be asked, the supplemental to then be asked, and then you respond. Do not cross-talk over each other. Continue, Senator Mark.
Yeah. So all I'm asking the Honorable Minister is having regard to the completion date for this project. Can the Minister indicate to this Honorable Senate whether the initial contractual agreement for the completion of phase 1 of the Central Block project was March 2023 and not May 2024? Can the Minister confirm?
Thank you. As I said, The project is expected to be completed by May 2024. What I do not have with me is what was the original date of completion, so I cannot say exactly if this is the original date of completion or whether it's a revised one. But if you pose that question specifically, I will respond to it.
Senator Mark.
Can I ask the minister, sorry, Mr. President.
No.
Can I ask the Honorable Minister, through you, Mr. President, whether there was any breaches to this particular contract which was handed, or which was awarded, I should say, to Universal Structures, particularly in reference to the time period for its completion, that is phase 1. Is the minister aware of any breaches of this said contract?
That question doesn't arise, Senator Mark. Next question.
Mr. President, I'd like to ask the minister whether she's aware that as a result of the breach of this contract by Universal Structures, which was supposed to be completed on May or in May of 2023, whether UDCOT has invoked the $50,000 per day for failure to complete on time.
That question does not arise, Senator Mark. That's the end of supplementals to question 46.
Did I ask 3 or 4 supplemental? Are you robbing me of
Supplementals
one?
just passed, Senator Mark.
You are not robbing me?
That was the 4th supplemental, Senator Mark. You can move on to the next question on the order paper.
Okay. You see why I asked you?
Senator Mark, move on to the next question on the order paper, please.
I have to ask you, but not now. Question number 47 to the Minister of Education. Where's the Minister of Education?
Acting Leader of Government Business.
The Ministry of Education has spearheaded the distribution of over 63,000 devices to students and teachers since March 2020 to the present. 20,000 of these were distributed to those in greatest need according to the means test in academic year 2020-2021 and 21-2022 to students and also to teachers in 578 government and government-assisted schools in Trinidad. An additional 7,000 laptops were procured and are currently being distributed to students and teachers in 578 government and government-assisted schools. Students and teachers in public special schools and CCE teachers have also been provided with devices. Thank you.
The government, can the minister indicate whether the government schools and the government assisted schools, are they strictly secondary or are they both primary and secondary as it relates to the distribution of the laptops?
Acting Leader of Government Business.
To the best of my knowledge, they are both primary and secondary.
Can the minister indicate what is the deficit in completing the distribution of laptops to both students or pupils and pupils at both the primary and secondary level? Can the minister share with us the deficit?
Acting Leader of Government Business.
Thank you. The question of a deficit doesn't arise having regard to the question posed of about on 7,000 laptops to 14 schools. What the Ministry of Education has done is distributed over 63,000 devices, with an additional 7,000 devices being procured in addition to the 63,000 devices. So comparing the question asked and the response given, there is no deficit at all.
Can I ask the minister through you whether it is the intention of the government to acquire more laptops for our pupils at the primary as well as the secondary school levels?
Acting Leader of Government Business.
That matter is always before the Minister of Education, and it's always one under review. So as needed, the Minister of Education will ensure the devices are provided, particularly for those in need.
Senator Mark.
Can the minister outline the means test that was referred by the honorable minister earlier on in distributing these laptops, Mr. President?
That question doesn't arise, Senator Mark.
It arises out of the answer given.
Senator Mark.
Mr. President,
Fourth supplemental. Next question on the order paper, please.
can I go on to the next one?
Yes.
Question number 50 to the Minister of Energy and Energy Industry. Where's the Minister of Energy and Energy Industries?
Acting Leader of Government Business.
Mr. President, the Minister of Energy and Energy Industries did not make any official overseas trips during the period April 18th, 2021 to October 27th, 2021.
Senator Mark. Senator Mark, I didn't hear the question.
No, I was asking the Honorable Minister, I just want to ask the Minister whether she would like to repeat again, because it's a very serious matter, whether she takes ownership, seeing that the Minister is not here, whether the Minister takes
Senator
ownership.
Mark, the Acting Leader of Government Business answered the question. I am asking you now if you have any supplementals in relation to the answer given.
Is the Minister aware that the Minister did travel during that period?
I responded that the Minister of Energy and Energy Industries did not make any official overseas trips during that period.
Can you advise this Honorable Senate whether the Minister made any unofficial trips?
That question does not arise, Senator Mark. Next question.
Yes, I'll deal with that on another level. Thank you very much.
Thank you.
Senator Lachmidial.
Thank you, Mr. President. Mr. President, question number 91 to the Attorney General.
Acting Attorney General, no. Minister of Local Government.
Thank you, Mr. President. Good day to members of the Senate. In response to this question, consequent upon the Honorable Attorney General's recusal from these matters, this question was passed to me for answer. I confirm that I wrote to the Director of Public Prosecutions on May 2nd, 2023, directing the specifics of this question for his attention. The Honorable Director replied acknowledging receipt of the letters on the same day. As at this point, we have not yet received any response from the Office of the Director of Public Prosecutions. I remind that pursuant to Section 90 of the Constitution, the DPP is the independent office holder with sole responsibility with respect to criminal matters of this nature, and therefore it is incumbent upon the government to await the reply of the Honourable DPP.
Senator Lachmidial.
Mr. President, may I proceed to, given the answer, may I proceed to ask the other questions?
Yes, you may proceed to ask the
Thank you,
supplemental.
Mr. President. Can the Honourable Minister then answer the remainder of the questions which are not contingent upon the response from the Director of Public Prosecutions?
Minister of Local Government.
The questions as posed in the three separate parts are all contingent upon the first part being premised upon the Office of the DPP. The representation at the Office of the DPP over the course of 22 years has spanned several spans of attorneys general that have occupied the office, whilst the state does undertake payments at the request of the Office of the DPP. And in fact, since we carved out the expenditure of the DPP as a specific line item since 2017, it is incumbent upon us to have the confirmation of the DPP with respect to who represented the DPP across the span of 22 to 24 years. In those circumstances, it would be irresponsible to provide an answer based upon lack of particulars coming from the Office of the DPP. We do expect the Office of the DPP to write us, to provide us with the information. And surely upon receipt of those things, the information can be provided.
Senator Lachmidial.
Can the Minister give an undertaking when the
answers are received from the Office of the Director of Public Prosecutions to provide those answers in writing to this Parliament, to the Senate?
Minister of Local Government,
I certainly can, yes.
Senator Lakshmi Dayal.
Yes. Can the Minister indicate whether, in light of the number of matters which have arisen in relation to the Piarco matters, the 4 Piarco matters, whether the government is giving further consideration into releasing the report of the Commission of Inquiry into the Piarco construction matter?
That question does not arise, Senator Lakshmi Dayal. You have another supplemental?
Given the length of time that some of these Piarco matters have been before the court and the need to restart matters because of the retirement of magistrates or perhaps their elevation to different positions, has the government given any consideration to legislative provisions which would prevent preliminary inquiries from having to be started over de novo upon the retirement or resignation of a judicial officer who has conduct of the matter?
That question does not arise, Senator Lakshmi Dayal. That's the end of supplementals for that particular question.
Public business, government business, bills second reading.
Attorney General.
Thank you very much, Mr. President. Mr. President, I stand before this honorable Senate today with a sense of solemn duty and supported by a clear line of judicial authority, not least the pronouncements of our own judges of our Court of Appeal, the Honorable Mr. Justice of Appeal Nolan Barrow, in the case of Francis and the state of Trinidad and Tobago, and former deceased...
Attorney General, 1 second before you begin.
Yes.
There's a minuscule...
yes, indeed. I beg your pardon. I beg your pardon, Mr. President, and please accept my apologies. Would you permit me just to return to my desk to get the paper?
It will be brought to you. 1 second.
Thank you. Thank you, Mr. President, and accept my apologies to you and to the Honorable Senate. Mr. President, I beg to move that a bill entitled An Act to Amend the Jury Act, Chapter 6, Number 53, and the Criminal Procedure Act, Chapter 12, Number 2, and 4 related matters be now read a second time. As I was saying, Mr. President, I stand before this honorable Senate today with a sense of solemn duty and supported by a clear line of judicial authority, not least the pronouncements of our own judges of our Court of Appeal, the Honorable Mr. Justice of Appeal Nolan Barrow in the Francis and the state of Trinidad and Tobago, and former Chief Justice, the late Mr. Justice Isaac Hayatali, in the case of the Attorney General of Trinidad and Tobago and Mutu, whose wisdom has been gratefully adopted and affirmed by the Privy Council in the Surat decision reported at 2007-71 West Indian Reports 391 and the Dominic Suraj decision 2022 UK PC page 26. It is therefore for me, Mr. President, a privilege to pilot before this Senate today this crucial piece of legislation entitled A Bill to Amend the Jury Act, Chapter 56, Number 53, and the Criminal Procedure Act, Chapter 1202, and 4 related matters. I begin by acknowledging that we are here today with this bill to amend an historic, important piece of legislation which already stands tall for its innovative significance, the Miscellaneous Provisions Trial by Judge Alone Act 2017. This 2017 Act, Mr. President, was introduced to allow persons accused of indictable offenses to elect a trial with a judge alone instead of a jury. The purpose of this Act, the 2017 Act, was to address the length of time it took for criminal cases to be resolved and the impact this has on victims, the accused, and states' resources. This Act was passed on the 22nd of June 2017 in the Senate and on the 28th of June 2017 in the House of Representatives by a simple majority, and I repeat that, by a simple majority, and was proclaimed on February 1st, 2019, with the intention of expediting the criminal justice processes in our courts. It was piloted by my predecessor, the former Attorney General, Honorable Minister Faris Al-Rari, to whom I pay tribute. Mr. President, as a result of this 2017 amendment, there have been several completed judge-alone trials to date, with others scheduled to commence. Judge-alone trials have been utilized in several trials for murder and other serious indictable matters. I am pleased to report to this House that we now have a proven operational system of judge-only trials. Correspondence from the judiciary tell us that from February 1st, 2019 to January 31st, 2023, there have been 59 completed judge-alone trials, with 35 now pending. On average, during the year 2022, 2 requests per month were made for judge-alone trials, while 13 requests were made for the month of January 2023 alone. These statistics are self-recommending of the success of the 2017 Act, that requests for judge-alone trials are continuing despite the resumption of trials by jury after the diminution of the pandemic in June 2022. Mr. President, clearly we are on the correct path to continuing the necessary important improvements to our criminal justice system. Acknowledging then the success of the 2017 Act, and for the record of the increasing number of defendants who are electing this mode of trial, it is the legitimate progression that we build further on this success and continue to improve our criminal trial processes, our criminal justice system, with the aim to reduce the length and cost of criminal trials at the High Court, to improve the system for the benefit of accused persons, of victims, of witnesses, and overall to enhance the confidence of the citizens of our proud country that we are continuing to improve the time frame within which all persons impacted are getting justice and experiencing and seeing justice being done in a fair and expedited process, with the aim of reducing our current criminal trial backlog. Mr. President, this bill seeks to amend, therefore, both the Jury Act, Chapter 6, number 53, and the Criminal Procedure Act, Chapter 1202. It is essentially aimed at reducing the backlog of cases in the criminal justice system by introducing jury trials as the default position for all capital and non-capital indictable matters, with the option for the accused to make an application to the court to be tried by a judge and jury. The bill also seeks, Mr. President, to introduce the utilization of lay assessors whilst repealing the law on special juries and utilizing reduced jury sizes. As most of us are aware, Mr. President, due to the COVID-19 pandemic, many courts in Trinidad and Tobago were necessarily required to cease face-to-face proceedings with certain exceptions. Our situation was not a unique one, as the temporary suspension of criminal jury trials took effect in numerous countries, England and Wales, the United States, South Africa, just to name a few. The unfortunate corollary of this situation was an increase in the backlog of criminal cases waiting to be heard. Mr. President, this government has implemented significant reforms in the criminal justice sector over the past several years in an effort to address the issue of criminal trial backlogs. These efforts have been successful in providing significant relief during the pandemic. The requirements for social distancing and stay-at-home measures were easily facilitated by the creation of divisions of court, electronic payments, electronic transactions, and virtual functioning of our nation's courts. This government now acknowledges that on May 5, 2023, the World Health Organization declared that the COVID-19 pandemic no longer constitutes a public health emergency of international concern. And yet the pandemic provided us with challenges and therefore opportunities to rise to the occasion to implement measures in the criminal justice system which have contributed to improved efficiencies and justify their continued utilization and improvements, such as judge-only trials, which has the tremendous potential to reduce the case backlogs. Mr. President, despite these noteworthy efforts, there has not, regrettably, been a total relief to our judicial system, our criminal justice system, so that we all, members of the citizenry of this country, members of this Honorable Senate, must continue our collective efforts. The statistics obtained from the judiciary show that the criminal case backlog has continued to increase. Data supplied from the judiciary indicates that for the period August 1, 2021 to July 31, 2022, there were 15,152 criminal cases filed at the district courts, including 160 capital matters, 207 criminal cases filed at the high courts in Port of Spain, San Fernando, and Tobago, and 232 criminal cases filed at the Family and Children Division. As of July 31, 2022, there were 885 criminal matters pending at the high courts in Port of Spain, San Fernando, and Tobago. 389 criminal matters pending at the Family and Children Division. The data obtained from the judiciary, Mr. President, has also indicated that there are 1,119 defendants in jail awaiting trials. Mr. President, these statistics are concerning. The government of Trinidad and Tobago has implemented significant reforms to address the criminal case backlog, and we recognize that there is more that needs to be done on a continuing basis. Our aim, which we are asking this Senate to join us in, is to continue with all efforts to improve the efficiencies of our criminal justice sector. I take this opportunity to advise that I will be coming back to this Parliament with other measures very shortly. And so, with our commitment to working assiduously to reduce these backlogs, we are here today to introduce and to present this bill. Mr. President, I wish to inform this House that when this bill was being drafted, my office wrote to stakeholders, including the judiciary, the Office of the Director of Public Prosecutions, the ODPP, and the Law Association of Trinidad and Tobago, seeking feedback on the above. The Public Defender's Department itself took its own initiative and provided submissions to my office. All stakeholder feedback, including those parties and entities who I have just named, which were received, has contributed to the quality of the bill before us today. Mr. President, it is important to remind this House that the conduct of jury trials require 12 or 18 persons to participate in a trial for weeks, sometimes up to months, with the possibility of disagreement, a hung jury, and a retrial sometimes being needed. By way of background, jury trials are provided for, Mr. President, in statute by virtue of Section 37 of the Criminal Procedure Act, Chapter 12, Number 2, which provides that if the accused person pleads not guilty, he shall, by such plea without any further form, be deemed to have put himself upon the country for trial, and the court shall order a trial for a jury for the trial of the accused person accordingly. Mr. President, we are reassured that previous concerns that the prospect of the removal of jury trials is not an infringement on the individual's constitutional rights. In the Jamaican case of Trevor Stone and the Queen, Privy Council Decision Number 11 of 1978, the appellant there argued that the right of an accused person to be tried by a jury in the case of grave crimes is entrenched in the Constitution.
B, I don't know if the Honorable Attorney General would want to elucidate or clarify a point that he has made.
45(1)B, you said, Senator Mark?
Yes, 45(1)B.
Okay. Honorable Attorney General, he's invoking Standing Order 45(1)B, which asks if the member speaking would give way. Senator Mark, you don't really need to raise the standing order. The precedence is you would just raise and ask if the member would give way, just for efficiency. Member, are you willing to give way to Senator Mark?
I am prepared to give way, Mr. President.
Senator Mark, you may.
Honorable President, through you to the Honorable Attorney General. Honorable Attorney General, can you inform this Senate when these letters were issued to the various stakeholders, and when did you receive responses from them to assist in the final formulation of the bill that is currently before us? And you mentioned a number of them: the Judiciary, DPP, Law Association, Public Defender, among others. Can you share with this Honorable Senate the dates that you sent and the date that you received that helped this bill in the way that it is before us? Thank you, Mr. President.
Thank you very much, Honorable Senator. In a perfect world, I will one day be able to claim being one with a perfect memory and fingertip recall. But it's not a perfect world. I do not have those dates at my fingertips, but I certainly can make inquiries and provide them. May I continue, Mr. President? Thank you very much. Mr. President, I was saying when the member rose for clarification that we are reassured that previous concerns at the prospect of the removal of jury trials is not an infringement on the individual's constitutional rights. And that reassurance has been settled by the case out of Jamaica of Trevor Stone and the Queen, a Privy Council decision number 11 of 1978. In that case, the appellant had argued, among other things, that the right of an accused person to be tried by a jury in the case of grave crimes is entrenched in the Constitution of Jamaica, and it can only be removed by the special procedure prescribed by Section 49 of Jamaica's Constitution, and that a Supreme Court judge sitting in a gun court without a jury was inconsistent with the Constitution and therefore void. In that decision, Mr. President, the Privy Council dismissed the appeal and affirmed that a Supreme Court judge, such as our judges under our Constitution and our Supreme Court of Judicature legislation in Trinidad, sitting without a jury is simply a matter of practice and procedure and does not involve a fundamental right to a jury trial by a judge and jury under the Constitution of Trinidad and of Jamaica, which settled principle of law equally applies to Trinidad and Tobago. The current procedure, Mr. President, under the Criminal Procedure Act is as follows. At the first hearing, after an indictment has been filed, a judge informs the accused person that he may elect to be tried by a judge and jury or by a judge alone, unless the accused person indicates an intention to enter a plea of guilty. Where the accused person does not make such an election at that hearing, he must file his election with the Registrar of the Supreme Court and serve a copy on the prosecution within 60 days of the adjournment of that matter, or before such later date as the court may order. The court then makes the order that an accused will be tried by a judge alone if it is satisfied, the court is satisfied, that the accused has sought legal advice in relation to a trial by judge alone and has filed the necessary certificate with the Registrar of the Supreme Court. That is the current law which exists in Trinidad and Tobago by reason of the amendment to the Criminal Procedure Act by Act number 17 of 2017, which was passed back in 2017, the Trial by Judge Alone Act. Mr. President, if an accused chooses to be tried by a judge alone without representation by an attorney at law, the court makes the order only in circumstances where the court is satisfied that the accused is competent and has waived his right to legal representation in relation to trial by judge alone and has filed the necessary certificate with the Registrar of the Supreme Court. The court shall not grant an order for a judge alone trial unless it is satisfied, 1, in the case of a joint trial, all other accused persons have elected to be tried by a judge alone, and each such accused person has filed a certificate in the appropriate forms set out in the first schedule to the Criminal Procedure Act. And secondly, where 2 or more charges are to be tried together, the judge must be satisfied that the accused person has elected to be tried by a judge alone in respect of all of the charges. Mr. President, I wish to inform this House that the accused person may subsequently apply to the court for a trial before a judge and jury or vice versa within a stipulated time. One of the main benefits, Mr. President, of a judge-alone trial is that as soon as reasonably practicable and in any event, before the expiry of 14 days, the judge must deliver his verdict. May I repeat that? As soon as reasonably practicable under the legislation which exists now, the Trial by Judge Alone Act, which we are seeking to amend in limited respects, as soon as reasonably practicable and in any event before the expiry of 14 days, the judge must deliver his verdict. And in the case of a conviction, give a written judgment stating the reasons for his verdict at the time of conviction. The prosecution, in the case of an acquittal, may make a request for the judge to provide reasons for same, in which event the judge may give reasons within 14 days of that request. This is not the case in a trial held before a jury and is of substantial benefit to the accused, to the victims, and the entire criminal justice system. Because what this piece of legislation is seeking to do and is serving to do and demonstrably has been doing since it became part of our law is to provide for a more expeditious criminal justice system, something which I do not think that a single woman or man on the streets of this republic would suggest is not a desired objective. Mr. President, I wish to highlight some additional benefits to the use of judge-alone trials. It reduces the length of time a person has to wait for a trial to begin, as there is no jury selection to be done. This process can be quite lengthy and challenging, as oftentimes persons do not come to the courts willing to be called as a juror, but rather a greater percentage of persons present reasons to support why they cannot serve as a juror. I recall, Mr. President, when I was a very young practitioner, and I was being led then by one of the most able practitioners that this country has ever produced, Mr. Frank Solomon, Senior Counsel. I was deviling work for him in a matter, I won't call names, that involved some very heinous criminal offenses in this country. And it took several months in which to empanel a jury because jurors were scared. The respective public officials commissioned by order of the judge literally found jurors on the beaches in Chagaramas to come to the trial which was taking place in a specially constructed court in Chagaramas for that particular murder trial, one of the most heinous murders that this country has ever had the misfortune to experience. The trial itself, Mr. President, can be concluded in a shorter time frame. I've just given an example of those time frames. And additionally, the state is able to save the resources which would otherwise have to be spent on empaneling a jury, including their alternates. Based on the successes, Mr. President, of the 2017 legislation then, this bill before us today proposes judge-only trials as the default option for all indictable matters. The bill further provides for the utilization of lay assessors with special expertise and qualifications from a pool of assessors inclusive of attorneys at law, and the repeal of special jurors provisions in the Jury Act, which has never been used in Trinidad and Tobago. And a summary, Mr. President, without belaboring the point, of the benefits which will be obtained from the amendments that we are seeking to produce today if this chamber were to endorse the government's efforts, is the amendments to the Jury Act and the Criminal Procedure Act. A, the utilization of judge-only trials as the default option for all capital and non-capital indictable matters, with the option for an accused person to make an application to the judge to be tried by a judge and jury, with the judge always being reserved the discretion to determine how that trial shall proceed. That jury trials be conducted with a reduced jury size. C, the utilization of lay assessors with special expertise and qualifications from a pool inclusive of attorneys at law where the accused person elects lay assessors or where the judge deems it necessary for any indictable offense except an offense punishable with death, and in particular, any indictable offense involving fraud. One can think of trials coming under the Proceeds of Crime Act, trials coming under the Anti-Terrorism Act, trials under the Economic Sanctions Act, orders made under the Securities Act, and any other written law in relation to the prevention of money laundering, combating the financing of terrorism, and the proliferation of financing. This amendment that we are bringing to the House today, to this chamber today, will enable the judge to appoint lay assessors where the accused has opted for a trial without a jury, so that those lay assessors in specialized fields of endeavor can assist the judge in coming to a proper and fair trial. And of course, lastly, the amendments that we seek to bring will involve the repeal of all provisions relating to special juries, a facility which has never been used in this country. Mr. President, I will not belabor the point. We will be going through the clause, the bill, clause by clause. I take this opportunity to thank you and to place on record this government's commitment to reducing the backlog of cases that are currently plaguing the criminal justice system. The passage of this bill will be used as another critical mechanism through which matters can be disposed of quickly and without any compromise to the accused. Are you
willing to give way? AJ?
Are you willing to give way, AJ?
I am willing to give way to Senator Mark.
Through the Honorable President, may I ask the Honorable Attorney General, can you explain and offer a rationale for the inclusion of a provision or a clause to allow the Attorney General to add to the list of offenses, indictable offenses, that are outlined in the said legislation? Can you share with us, Senate, what is the rationale for the insertion of the Attorney General in this particular piece of legislation?
I would ask you to particularize that in greater detail, Mr. Senator Mark, and I'm quite prepared to address it in my wind-up.
That you have inserted. So all I'm asking the President, for you as the Attorney General, to explain to this Senate and to Trinidad and Tobago, why have you inserted the Attorney General to add to the list of offenses subject to an affirmative resolution? You must have a rationale.
Can you point me to the section that you are referring to in that case, please? I would rather be specific as opposed to being generalized.
Are you about to wind up?
I am about to wind up.
Yeah, can I see the legislation so I can just point out to the can I see?
So just
no,
one second. Take a seat, Senator Mark. Members on my right, please. Attorney General. So this process is all normal. and it's all allowed as per the standing orders. The Attorney General has more time in his contribution before he has to end and utter the words that need to be uttered in order
Yes.
to move this procedure along. Senator Mark, if you're
Yes.
ready for him,
Yes, I'm
you may
ready.
raise and indicate to the Attorney General what it is you're referring to.
Honorable Attorney General, if you go to page 8 of the bill that I have before me, it is subsection 3. It comes before clause 6D on page 8. It reads, the Attorney General may by order, subject to affirmative resolution of Parliament, amend the list of offences referred to in subsection 2. So you have a list of offences, including misbehavior in public office, gambling and commission, all of these things are here. But this particular section, where the Attorney General has inserted himself, I'm just trying to get a justification and rationale for that particular insertion. Can you share with us, Honorable Senate?
Thank you very much, Senator Mark. And I, of course, benefit from your precision by pointing me to the particular subsection. So I understand you to be pointing to the amendment that will be brought in under lay assessors, and you are referring to the new proposed section 6C, subsection 3. It would not be correct, Mr. Senator, to say that the Attorney General has inserted that to allow himself, because in the first instance, this legislation, as I have sought to indicate, has been drafted through a very careful process that has involved consultation with stakeholders. It has been drafted through the office of, in the first instance, Law Revision Commission setting out the policy, drafted through the office of the Chief Parliamentary Counsel, and then went through a detailed process before the Legislative Review Committee, taking contributions from relevant stakeholders. Yes, it is correct that there is provision made in section 6C3 that the Attorney General may, by order, subject to affirmative resolution of Parliament, amend the list of offences referred to in subsection 2. The rationale for that stems in the first instance from the function, the constitutional function of the Attorney General pursuant to the provisions of the Constitution, in particular section 76, where the Attorney General is responsible for the administration of justice. The rationale for that, secondly, and I think that this bill is a good example of precisely that rationale, in which we have to keep our laws under constant review as our society evolves and as circumstances develop. And if, in the review of the society's evolution and the occurrence of circumstances arising from time to time, it is, in the opinion of the Attorney General, a circumstance that needs to be added as an offense, the Attorney General would send a question in that regard to the Law Reform Commission, proposing a particular offense, ask for a policy report on that, which will then be discussed in Cabinet. It may or may not be accepted. After, assuming it is accepted as a policy decision that the Cabinet has approved, it will be taken to the Chief Parliamentary Counsel, who will draft the requisite piece of legislation to introduce that particular offense. It may have to do with a particular aspect of cybercrime, which is a fast evolving area of our reality that we have to keep pace with. And if at the end of the process, a detailed, careful process, the Attorney General is satisfied by the advice that he receives that this offense needs to be added to the schedule of offenses, then that is added to the schedule of offenses in an attempt to keep our laws under review. And very critically, and you, have no doubt, with your experience, would recognize this, very critically, that proposed amendment by way of an offense added to the schedule will come to this Parliament for debate by way of an affirmative resolution, so that the Parliament is satisfied that what is being done is proportionate and satisfies a legitimate aim. I hope that I have sufficiently addressed such concerns as you might have, Senator Mark. Thank you, Mr. President. I was in the process of saying that I take this opportunity to thank this chamber and to place on record this government's commitment to reducing the backlog of cases that are currently plaguing the criminal justice system. We have before us the bill, which we will be going through clause by clause, and I will endeavor to assist members as we make and undertake that exercise. It is a critical piece of legislation to improve our criminal justice system so that matters may be disposed of quickly and without any compromise to the accused's constitutional right to a fair trial. I wish to express my gratitude for the submissions and contributions which we have so far received to this bill, both in writing and orally, and these contributions have helped to ensure that as a government we have produced a bill that is constitutionally sound and which seeks to improve the criminal justice system in Trinidad and Tobago. Mr. President, with those remarks, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Jury Act, Chapter 653, and the Criminal Procedure Act, Chapter 1202, and for related matters be now read a second time. Senator Lakshmi Dayal.
Thank you, Mr. President, for the opportunity to join in this debate and to speak on this very important matter that has come before us today as a House, as a Senate, to address and issue many issues that impact upon our criminal justice system. Mr. President, the slow pace of justice is something that has been discussed for many years, and as crime continues to plague our society, the discussion about the pace of justice and the measures being taken to improve the delivery of justice to both those who are affected in terms of being victims, family members, and wider society who have a desire to see punishment inflicted upon those who offend the law, as well as persons who may be awaiting trial and would like the opportunity to mount a defense against accusations brought against them. It is very important that we carefully consider the provisions, being any provision, but particularly these, which are being introduced to supposedly improve the delivery of justice to all citizens of Trinidad and Tobago. On that note, and perhaps this is what we would call a housekeeping sort of comment, Mr. President, I have to complain, which I have, as I have complained in the past, that not just parliamentarians, but even wider citizens of Trinidad and Tobago do not have proper access to consolidated laws from the Office of the Attorney General. In preparation for today's debate, we were given consolidated, unofficial consolidated laws. This morning, I was en route to the Parliament when that email popped up on my phone. If the government is interested in a healthy debate on matters like this, which brings a number of amendments to two pieces of legislation, fully well knowing that there are previous amendments which have not yet been consolidated into the parent acts, then this sort of information should have been provided well in advance. But more than that, it is not just for us to have access to be able to come here and have this debate today. The entire population of Trinidad and Tobago, for those who pay attention, knowing that a bill is going to be debated today that brings amendments, should have access. So I don't know if that is something that, and again, I just use the opportunity to bring it to the attention of the government that it's really not in the interest of anyone that the consolidated laws since I think 2016 have not been provided to the public, but particularly to parliamentarians who wish to prepare. And if it is that unofficial consolidations are going to be provided, it ought to be done well in advance of a debate. We are given notice well in advance that we are coming here to debate this piece of legislation, and so we should have that material be made available to us. That being said, it is also a bit inconvenient that on today's date we receive the comments being put out by very important stakeholders in this process, including the Law Association. I think that is what prompted Senator Mark to ask the question about when the request for comments would have been gone out. And of course, the Attorney General says he cannot recall. He recalls his activities and trials way back when he was I think a junior, I'm not sure if it was junior senior counsel or junior counsel, but back in the day, but he cannot recall when this matter was sent out. But Mr. President, I think it is really not in the best interest of the public, again, that parliamentarians are provided this material today. I don't even know if it has come through any official channel, but we received the comments from the Law Association, and I have only been had it in my hand for about the last 10 minutes, and I'm looking it over. Thankfully, much of what they have said accords with my own analysis of the bill, and so I can speak today to some of the provisions that have been brought here. I usually prepare very detailed notes and then I don't use them, and that is because I prefer to take a practical approach to analyzing any piece of legislation. And in this case, I can speak to the fact that I know firsthand of the challenges with juries. My memory is also quite good, and I remember the first ever murder trial that I did on my own. And the number of witnesses in that matter, I think it crossed 25. And so that trial went on for almost a month. And at the end of that, or coming very close to the end of the month, the marshal of the court brought it to the attention of the judge that a juror in the lunchroom where they meet or whatever had been having a discussion with other jurors saying that, look, you know, I know the victim in this matter, and you see that area where he's from? It's what we would call a hotspot in today's terms, but it's a bad area, gangster area, bad boys. And the accused person who's before the court, the area that he is from a far more decent type area and so on. And the marshal picked up on that conversation about whether or not, because of course the defense of self-defense was being raised in the trial, and the marshal picked up on it and brought it to the attention of the judge. By the time an inquiry had been conducted, more than half the jurors said that that conversation had impacted upon them, and the entire trial was squashed, and an entire month of work basically went down the drain, and we had to start over. So I understand jurors. I have sat through many, the first day of the month when they ask all these persons who are called to serve as jurors. They come bearing letters from employers. They have all sorts of excuses. They do not want to serve at various points in time. There's also the challenge that a number of exemptions already exist in the Jury Act. And so we have a very, the pool of persons who are eligible to serve as jurors is already narrowed down by these exemptions. And then you have other persons coming to seek exemptions. So jury trials do, in fact, pose some challenges. But that does not take away from the fact that the right to trial, there's no constitutionally protected right. But a person's right to be tried and to be judged by a jury of his peers is very important. Because you see, what a jury brings to a trial is something that I would say I don't believe a judge alone can bring. And that is the practical, everyday experience of the average man and woman in this country. How the average man or woman would react to a certain situation. How the average man or woman would be expected to respond to questions posed to them by the police in cases where you're dealing with confessions. Those are issues which someone who lives a very cloistered and a life that is sort of, limits their interaction with, I think the UK expression is the man on the Clapham omnibus. I've West Indianized it to the man on the priority bus route. But if you don't interact with the man on the priority bus route every day, the man standing up down at City Gate, the man walking around High Street in San Fernando, can you really judge the average person and their reaction? And when you are dealing particularly with crimes of passion, when you are dealing with crimes that
require, that are based, as I said before, the evidence of the state is primarily based on a confession. And that confession is being challenged, the validity of it and so on. There are legal issues which a judge will treat with in what we call the voir dire, but on the weight you want to put on that evidence, when an average person is permitted to examine the evidence that is brought against an accused person, their human experience is what they bring to bear on that trial. And that is something that no amount of lay assessors or anybody else could replace in this situation. So I start off by saying that we have to balance that requirement for expeditious trials, for more cost-effective trials, for to rid the system of all of the challenges that we may have when juries perhaps have prejudice, and sometimes it is more difficult for the average citizen to disabuse their minds of certain prejudices, like where a person is from, et cetera, as opposed to a judicial officer. But we have to balance it against that desire by the person who is accused and whatever benefit they believe they may gain by having their actions and reactions and all of those things judged by someone who is just like them. And that's what it boils down to, You are accused and you are brought before the court. You want someone who is just like you, an average person who understands your story, your background, your history, your thought process, to be the ones who will determine whether or not you should be convicted of an offense. How do we balance those things? And that's what we're here to discuss today. So we are dealing with two situations here. We are dealing with situations where we will still have juries, and one of the things I want to discuss really is the reduction in numbers for the juries, and then we're also dealing with situations where we have no juries at all, and I think that's the more concerning part of this bill because of those amendments that are brought now to the Criminal Procedure Act. So very quickly, I will deal with the numbers. By reducing the numbers for non-capital offenses from 9 to 6 and for capital offenses from 12 to 9, you're limiting the amount of experience that is brought to bear on that process. So if I were to elect, and I were to now, if this bill were to become law, as an accused person, request a jury trial, when this offense was committed and up to today, a person who is facing a trial and who is given who was elected to have a trial by a jury would have 9 people of different experiences coming to deliberate on his guilt or innocence. This bill proposes to reduce that. So you will now have 6 people. And again, this is a fundamental concept in the jury process and the trial process, is that you want the widest range of experience because, and I'll give you the example of why we have peremptory challenges. Sometimes, for example, you want more diversity on a jury. If I recall, particularly with crimes dealing with sexual offenses, you would always have peremptory challenges and even challenges for cause sometimes in order to improve the gender composition of a jury. Because when the numbers are called, you might end up with 9 women or 8 women and 1 man on a jury, and it is for a sexual offense matter. And most people believe that you need a little more gender balance in that particular, in those types of matters, and so you would have challenges being brought. So are we really considering, when you limit these numbers, I assume that the reason for doing so is because it makes it easier to impanel the jury when you have fewer people to find. It would have less cost attached because, of course, jurors are given stipends and so on, and certain facilities are provided during the course of the trial, and it'll just be easier to get the jury going and get the trial started. But can we sacrifice that amount of participation by a wider range of, again, men and women from our society in order to have an expeditious trial? You want to have people of different socioeconomic backgrounds, gender, ethnicity, religion. We are a multicultural society. And so, and everybody's experiences are different, and you don't want people, again, when you have a wider pool, you eliminate the risk, or you mitigate against the risk of all persons sitting on a jury perhaps thinking one particular way. You increase your chances of having diversity and diverse opinions coming together to debate the guilt or innocence of a person. So the reduction in these numbers, I believe, requires some serious consideration, and I don't think it is something to be treated so lightly, simply to say that it will make trials easier for us to have. I noticed that the Law Association made a recommendation that they should, since it may have, and these are their words, may have an adverse effect on the fairness of deliberation, it is suggested that an amendment be considered to increase the number of preemptory challenges from 3 to 5. I don't know whether or not that may also, again, have an adverse effect on the speed at which we can impanel the jury. I think the example being brought by the Attorney General with how long it takes to impanel a jury is an exaggerated case and a one-off case. That's an outlying case. The average time taken to impanel a jury, in my experience, has usually been a morning. It usually takes about an entire morning in the first day of your trial. And so if this reduction in numbers is simply to get this process done quicker, I think that the government should look at that again. I think that not enough consideration has been given to the fairness to the accused person, and not just the accused person, to the victim as well. Because remember, a jury is not just judging an accused, a jury is also judging a victim. A jury is judging every single eyewitness that comes forward on behalf of the prosecution, and that will come forward in an effort to assess the veracity of that witness. And you want the most diverse and widest range of experience in that regard. So I would ask and at committee stage I would raise it, that the government consider raising those numbers, even if they want a reduction. I don't know that perhaps they should consider it to be a little bit more. The problem with 6 as well, you stand the risk, and with even numbers, you stand the risk of having a divided jury. So perhaps they should consider increasing 6 to 7, and 9 maybe to 11, and so on. I know you have alternates and you have different situations, but it may be worth considering as an option here, so that we bring back a few more people into the process. You see, juries rarely represent public participation in justice. It is one of the ways that the public really gets to participate in the process of criminal justice. So we should encourage it. I understand the challenges, but we should encourage public participation in justice, not try to find ways to eliminate it. So those are my concerns with respect to the numbers. With respect to the repeal of special juries, the Attorney General has said that this has never been used. We've never impaneled a special jury. Well, then, is it really necessary for us to introduce the concept of a lay assessor? Because that was, I think, the thinking behind having a special jury, where you would have persons of particular expertise and experience and so on impaneled to hear a matter that is complex in nature. And if we've never had cause to resort to that particular, using that particular feature in our Juries Act, well then, is it necessary for us to have lay assessors? I understand that lay assessors are used in other countries, in other jurisdictions, and I don't know what type of success rate they have had. I could see, however, that we may, from time to time, have complex matters involving securities, involving, I know attorneys who don't even understand securities law properly. And you may have, for example, things dealing with proceeds of crime, and they need to understand the complexity of the offense. But are you going to put someone who is trained or who has knowledge in that regard as a lay assessor to make the prosecution's job easier of explaining the evidence? If you want persons who have expertise in these areas to be able to explain it, then that is somehow taking away from the prosecution's role. It is the prosecution's role, for example, if you have a complex fraud matter, to bring a forensic accountant as a witness. And that forensic accountant should be able to convince a jury of ordinary men and women, beyond reasonable doubt, of their findings and what they say are the criminal acts committed by the person before the court. So if you are going to have a lay assessor who has expertise in a particular area and can then contribute and judge the facts, are you then making it and making it, relieving the prosecution of some of their duties to meet the standard of proof that is required? And that, I think, is very dangerous. I really do believe that that is dangerous and it ought not to be embarked upon. So when you look at the types of offenses that specifically they wish to have lay assessors appointed in, that is a concern that is raised to me. Of concern again as well, and they put it in here, is that for the avoidance of doubt, that attorneys at law could be appointed as lay assessors. Why is it necessary to have another legal mind assisting with the determination of facts and law? Well, facts, sorry. When you have a trained judicial mind to do that, I am very concerned about that provision there for attorneys. They say attorney at law or his clerk as a lay assessor. I do not. You are essentially turning a criminal first instance trial into something like a panel of people who could be judged, because you could have a judge and you may have somebody who is qualified to serve as a judge, but coming there with some sort of expertise to assist the judge in determining facts. I really do hope that another speaker can perhaps give us an indication as to why it is this particular clause is inserted here, and in section 6G of the proposal, that a person can be excused if they are the spouse of a judge, a judicial officer, justice of the peace, and attorney at law. So they can opt to be excused, but these persons, attorneys at law, can opt to be excused if they are called upon, but they are allowed to serve. And if it is that attorneys, their spouses, and their clerks cannot serve as jurors, why are we now inserting them into this process as lay assessors? I'm very perturbed by that particular provision. Mr. Vice President, let us get to the, Mr. President, sorry, let us get to the crux of this amendment being brought here now by this bill, and that is really what we would call the flipping of the process where you can select to be tried by a judge and a jury or a judge alone. As the law stands right now, you elect. And the statistics provided today, not made public to us, but the Attorney General has said he received correspondence from the court that 59 judge-alone trials were completed. I agree that jury trials were halted during the COVID period, and that's an anomaly. That caused us to have a reduction in the number of trials. But let us look over the years, and since we have resumed our sittings and so on, how many persons have been on the court's docket coming before the court to have their trials done, and how many of them are electing? Saying that it's 59 since 2017 doesn't put that into, we need some context to that figure. So we need some context as to how many persons had the option and were given the opportunity to exercise the option and opted for the judge-alone trial. Because that will tell us whether it is really working or not. That will tell us whether accused persons actually do want to go down the road of having a judge-alone trial. Just saying that we've done 59, so if it was 69, if it was 79, if it was 29, that means nothing. These numbers mean absolutely nothing in isolation. How many persons have had their indictments filed? How many of them have come up on causeless hearings? How many of them have indicated that they are ready for trial? And out of that number, how many of them have elected the judge-alone trials? That will tell us whether or not this concept of the judge-alone trial introduced in 2017 is really working, because that's how we know it is successful. if it is, though, that it is so successful, that so many people want it, as is being touted here today by the government, and they are saying that it is so great and wonderful, and it is working so well, that so many people want it, that we've done our whole 59, well, why are you changing it? If so many people want it, and so many people are selecting it, and you think 59 is a great number to report in terms of judge-alone trials, well, then why are you changing it? Leave it as the default position to be that you try by a judge and jury, and if the person selects to be tried that way, they make the selection. What is the thinking behind making the default position that you are tried by a judge alone, and then putting the burden on the accused person to say, no, I want to have a judge and a jury? And then the most dangerous part of all of this, which I vehemently oppose, is the addition of, and the court so directs in the interest of justice. It means that I, as an accused person, and every person accused of crime waiting 10 years and 12 years and 15 years, and I think the first person for the judge-alone trial was waiting 18 years for their day in court, I will come and say that I would like to have a jury. And a judge will then say, no, I don't think it's in the interest of justice. I am ready to proceed and hear this matter alone. How could that be fair? You don't have a constitutional right to trial by jury, but you have a right enshrined in Section 5 of our Constitution to a fair public trial before an independent and impartial independent and impartial tribunal. So when I come before the court and say that I don't want to be heard, have my matter heard by a judge alone, you are telling me now that that judge, that same judge, is being given the opportunity now to tell me, too bad. No. I believe it to be in the interest of justice that we proceed, that I hear this matter alone. Mr. President, I do not agree that this is the proper way for us to embark upon a more efficient justice system. I, more than anybody else, would like to see the backlog of criminal matters cleared from our courts. But if we are doing so at the expense of whether it is actual or perceived fairness, then it is not worth it. It is not worth it, because fairness in a criminal setting, in the criminal justice system, is of paramount importance. At the end of the day, these are people's lives that we are talking about. This is the life, this is about justice for victims who themselves may feel that a panel of laypersons might be better equipped to understand their experience. I did a significant amount, too many, of sexual offense matters. That was my sort of niche for some reason, not by choice. But I got a lot of those matters to do before the High Court. And I would always remember how victims would give me feedback in terms of when they were giving their evidence, and how jurors looked at them. You know, they felt sometimes that the way that they wanted to explain themselves, that the jury would understand, and so on. Where in this process is it built in that the prosecution, on behalf of the victim, or on behalf of the eyewitnesses, or on behalf of anybody who has to give evidence, can come and say, well, no, we don't want a judge-alone trial. We think a jury will better understand what this victim went through. Where is that? Where is the fairness for the victim as well? Because I could tell you, in my experience, there will be a lot of victims of crimes who would feel better understood, much better understood, by a panel of ordinary persons than a judge. Because, again, and this is not a criticism, it is the reality, judges don't live and don't experience life the way average people experience it. That is quite simply a fact that nobody can debate. So I do not agree at all that this process should be the default position of eliminating a jury. And I have noted in the comments of the Law Association that they see this bill as a step towards a stated position of this government to eliminate jury trials in their entirety. and that they oppose this move. When the Law Association, and with your permission, Mr. President, I would read that what they say here, the flipping of the election process for an accused person and the change in the primary option makes it clear that this amendment is intended to be part of a legislative agenda to abolish jury trials entirely. LAT is opposed to this. If the body representing attorneys, practitioners for the entire country are opposed to the elimination of juries, that tells us something.
Mr.
And
President,
we as a Senate,
would the member give way? Just for one question.
I'd give way.
Could you just share the date of the LAT correspondence, please?
The date of this is today's date, the 12th of May 2023.
It's today's date.
Today's date.
We're not in receipt. Okay, thank you.
Okay. Well, as I indicated at the start as well, Mr. President, we are also disappointed that consultations that the Attorney General said he had with all different stakeholders and so on, the results weren't shared with us, and that we have only now received some feedback from the Law Association. And I think the Criminal Bar Association yesterday also put out some comments on this bill. It really does not bode well for a healthy debate. And so we are equally as upset about it. But if the Law Association is saying that, and I believe the Criminal Bar Association has also advocated that this debate be adjourned so that there could be further consultation, that tells you something. It tells you something about the importance of this matter, about how those who work in the system and who experience the system, how they feel about it, and some of the concerns that they have and how we are to treat with them. Mr. President, getting back to the point now of the qualifications that a person may have to be a lay assessor, we are hampered because the qualifications contained in this bill only really contain the basics: over 18, not bankrupt, mentally fit, and so on. But it is the Rules Committee who will then come out, have the work of providing rules to generally regulate lay assessors, and in particular provide for selection, appointment, qualification, exemption, and training of the lay assessors. So we're just flying blind. When we have to determine whether or not we want to encourage or approve this inclusion of lay assessors, we are flying blind and we really don't know what to expect. I would have appreciated if some more detail on the qualifications for lay assessors in specific types of matters, particularly with the matters set out at clause 6C2, that if it is that in terms of these types of matters where they are asking for, in particular, these types of indictable offenses that lay assessors may be appointed, then some more qualifications should have been set out in this bill, because again, it helps us to judge the validity of such a policy position for the introduction of lay assessors here. Mr. Vice President, Mr. President, I'm so sorry. Mr. President, one of the things that judge-alone trials hinge upon is confidence in our judiciary. We must have confidence in judicial officers because you are placing not just the requirement that they adjudicate upon the law, but that they also assess facts in a situation upon judicial officers. In the civil arena, we have medical negligence claims. A lot of them come forward, and judges are asked to deliberate on the facts and the law. Those matters are not oftentimes easy because there's quite a bit of medical information and knowledge which the judge is required to assimilate and determine who's right, who's wrong, where there were errors, and so on. And he relies on expert witnesses. You have applications in the civil court to bring expert witnesses who will submit, and under the civil proceedings rules, those are experts of the court and they are there to assist the court. In this case, what you are introducing by way of a lay assessor, sometimes in particularly these types of matters here involving fraud and other financial crimes and so on, is that you're bringing a person who should be an expert witness into the position of a judge, to judge the matter. And I wonder if sufficient consideration has been given to the introduction instead of expert witnesses who can assist the court and give evidence and be tested. Because you see, the expert, the so-called expert, the person who is selected to be the lay assessor in one of these types of matters, nobody gets to test them. If I, as a judge, decide that I am bringing Mr. X because I believe he has certain experience in money laundering, and I have a proceeds of crime matter before me, and Mr. X is an attorney at law who has perhaps done proceeds of crimes matters, money laundering matters, and so on. That person must now sit down and determine the facts. They are bringing to bear their professional experience on this particular situation. The defense has no opportunity to test that person, to ask them questions. The prosecution is now able to bring their own witnesses, or may not have to bring as many witnesses to explain a matter in the way that they may have had to do so were they before a panel of ordinary men and women. So the concept of this lay assessor and their expertise in this particular area raises questions, Mr. President, and I think that if we are to see that this is something that is required, it requires a little more explanation and details for us to make that determination. You go down here now to what they talk about, someone who possesses experience in the administration of justice. What is experience in the administration of justice? Is it that you sat as a judicial officer? Is it that you're an attorney? Is it that you are the court clerk, the note taker, the marshal, the bailiff, the tea lady that serves, the jury? What is the experience in the administration of justice? How do we judge, really, that a person is qualified? And qualifications, and it doesn't say, it says or qualifications, experience, or skill in any matter which may be considered at the trial. So it is at the point in time when the judge is seized of the evidence and the issues. Criminal trials are not like civil trials where you have statements of agreed facts and issues and so on being put out there. At what stage will this lay assessor be selected? At what stage will the defendant be given an option perhaps to object to the particular lay assessor? And that, to me, again, it introduces a process where that could be fraught with difficulty. If I raise an objection now to a judge's decision to not introduce or to not grant me my request for a jury trial, can I appeal that decision? I think there's case law that says, coming out of the Nankisoon Bujra matter, about decisions with respect to a jury, that those are not matters which can be appealed. And I think a constitutional motion eventually was filed and made its way to the Privy Council in that matter. But are you introducing more problems that could engage our courts here? If a lay assessor is then selected and appointed by the judge, and I object, and the judge determines that no, there is no prejudice, there is no, there is no conflict of interest and so on, what recourse does the defendant have at this point forward? And I raise these questions as legitimate questions that I think all practitioners, all accused persons may wish to have clarified.
Senator, you have 3 more minutes.
3 more minutes, okay. So, as I said, Mr. President, I am not blind to the realities of the difficulties that are faced by our judicial officers. I want to raise one point, and I think it is a policy position that perhaps the government should consider. When the government are so anti the granting of bail by judicial officers, it is the opposition that has advocated strongly that our judicial officers are capable and competent to determine those matters. You are now bringing a bill to Parliament that says that judicial officers by themselves, without the participation of the public, are capable, fully capable and competent and should be the default position to determine the guilt and innocence of people. Well, I think those two positions conflict a bit, because it's either we have confidence in our judiciary or we don't. And I would urge the government to take it upon themselves that instead of making public statements that would diminish confidence in our judicial officers, which they have done a lot of in the past couple of months, that they should try to build the confidence that the public will have in the judiciary, and maybe then you would have more people opting to go via the way of trial by judge alone, and you would not have to bring an amendment that imposes a trial by a judge alone upon the citizen of Trinidad and Tobago who is before the court. You see, that element of confidence that a judge sitting alone can determine a matter is something which has to be built amongst the population. And I cannot say that many people in my experience who are accused feel that that would actually be the case and that they would be fairly judged by a judge alone in many matters. They want that input of the average citizen. And it is for the persons who are promoting this bill and promoting this policy to build that confidence. Not by saying judges have friends who are criminals. Not by saying that judges make errors. Not by...
Okay, so Senator, you're wrapping up.
I'm wrapping up.
1 minute, so just continue and bring it to an end.
Yes, I'm wrapping up, and I'm dealing with issues in the public domain because this is a public issue and it has to deal with public confidence in the judiciary. And no government has done more damage to confidence in the judiciary than this particular government that have come here today to promote this piece of legislation, Mr. President. And so I urge them to take that under consideration. And when they are objecting to judges exercising their core judicial function to determine issues like bail, they must consider how that conflicts with the position that they are now adopting today. Make up your mind. It's either we have competent judges who could determine all judicial issues or not. My time is up. Thank you very much.
Senator Welch.
Mr. President, thank you for giving me the opportunity to speak on this bill which seeks to amend the Jury Act and the Criminal Procedure Ordinance. Let me say from the onset, I do not support this bill. It's, to use an American expression, it's, unless I can be persuaded otherwise, it's dead on arrival. When it comes to my vote, I am prepared to say nay. But I am nevertheless prepared to listen to further contributions to see if I can be persuaded otherwise. The reason for my position on this is that there's a common theme behind these proposed amendments. And that common theme, the features of it are, one, it involves an erosion of the rights of an accused person, not the constitutional rights, but the long-established rights that have been established by way of custom in the criminal justice system. It removes the checks and balances to ensure that convictions are safe and that verdicts are fair and are the correct ones. It undermines, if passed, it undermines confidence of those most affected by it in the criminal justice system. The rationale of backlog, which has been advanced for it, blaming jurors for the jury system for backlogs, is ill-conceived and not a correct representation. And the only explanation and rationale I see for it is administrative convenience and cost. And those matters cannot take precedence over fairness and justice. And I would go through it as quickly as I can because I'm a little under the weather, Mr. President. Let's deal with the Jury Act first of all. The proposed amendment is that on trials for indictment for murder, the 12 jurors that currently exist in the present law as it is, those numbers should be reduced to 9. Let me remind the proposals of this bill that when it comes to the offense of murder, the penalty that is involved is the death penalty. You are condemned to death and one goes on death row. Therefore, having regard to the consequence and the highest possible penalty, it is far safer to use the expression, there's an expression, 2 heads are better than 1. Well, let's convert that into 12 heads are better than anything less if the consequence is so serious. 12 persons sharing their views, exchanging their views, etc., it is more likely that a correct verdict would be arrived at than any less. Any reduction in the numbers from 12 to 9 is a 25% reduction. That constitutes a 25% increase in the possibility of a wrong verdict. And therefore, once we have the death penalty in place, 12 jurors should be maintained. There is no rationale given for reduction from 12 to 9. So is it legislation by VAPs? What is rationale from 12 to 9 to the extent that jury trials are still possible? I have looked at other jurisdictions in which, I've looked at other jurisdictions in the Caribbean where the death penalty still prevails. Barbados, St. Vincent, Grenada, Jamaica, the numbers are all 12. And that is a reflection of how serious the penalty is. In Anguilla and the British Virgin Islands, for instance, where it is 9 jurors for a capital offense, for murder, there is no death penalty. So why are we departing from the standard and simply reducing it while we still have a death penalty? And the reason why I spent some time on this is to illustrate the general point which I made at the beginning of it seems as though one is sacrificing fairness and ensuring confidence in the system and correct verdicts for expediency. It is easier to manage 9 jurors. Less food, I don't know. Less time it takes to select them. Maybe those are the considerations. But those are not as important as the requirement to ensure justice is done and a correct verdict is arrived at and confidence is reposed in the system. Mr. President, I now look at the proposed amendment to the Criminal Procedure Ordinance. The best way I find to deal with this is to look at it from the historical perspective. In 2016, the law that existed then is that every person committed for trial on an indictment every such trial shall be held by and before a judge and jury. So up to 2016, our law was such that judge and jury was the only method of trial. There are several advantages to a jury system. Because when you have 12 persons exchanging their views, sharing their different perspectives, the role of a jury is to determine guilt or innocence. It's to determine facts. It's to determine where the truth lies. It is to determine what weight to attach to a particular evidence. And when you have 12 persons of various backgrounds exchanging their views, and one say, look, this is what we should believe, and another one say, no, you may have forgotten this. Let's take this into account. And eventually, after that sifting and exchange of ideas, they come up with a verdict that is far safer than one man alone. Especially in death penalty cases. And that is the advantage of the jury system. You can have greater confidence in the correctness of a verdict. But not only that, as Senator Lakshmi-Dayal pointed out, it also involves the whole concept of being judged by your peers. A person can feel more confident and that he has passed through a fairer process if he is judged by his peers. It also allows, again as Senator Lakshmi-Dayal pointed out, for participation of the community in the administration of justice. So for several reasons, jury trials should be regarded as the gold standard. And that is what prevailed in 2016. Now let's look at the amendment which occurred in 2017. And the effect of that amendment, Mr. President, the effect of that amendment was that every person against whom an indictment has been filed shall be tried by a judge and jury unless he elects to be tried by a judge alone. So we have introduced judge-alone trials, but the gold standard still remained as the default position, and the accused is given a choice. So it's a hybrid system. And I have absolutely no difficulty with that. A hybrid system. And the Honorable Attorney General has pointed out that since the introduction of this system, many persons have used judge-alone trials. So it's not like if the 2017 amendment has been rendered useless. But the importance of this hybrid system is that there are circumstances in which, although a person would prefer a jury trial, having that option, that other option available to you may be advantageous. For instance, in 2017, no one anticipated the COVID pandemic. So when that law was passed in 2017 and we come to 2020 and you have the COVID pandemic, a lot of persons, once virtual trials started taking place, a lot of persons opted for judge alone because they were not certain when jury trials would resume. So I don't have a difficulty with the 2017 amendment, which remains the law up to today. There are other circumstances in which an accused advised by his attorney may seek a judge-alone trial. For instance, if it is a ghastly crime, a brutal situation, a brutal murder that's generated a lot of emotion among the population and a certain amount of acrimony to those whom are accused, you may say, an attorney may advise a person, look, the way how society is feeling about this, the jurors might reflect the general feeling of society. In those circumstances, you may want to select a judge-alone trial. Another situation in which it can occur is pre-trial publicity. If all the newspapers are reporting on the CCTV footage suggesting a person is guilty and the whole public is seeing that, an attorney may advise, go with a judge alone trial because the whole public would have already seen the evidence, etc., etc., etc. And that works. It's an introduction in 2017 which allows the gold standard to be the default position where a man can select his right to trial by jury, but flexibility where there is a perceived disadvantage, he may resort to judge alone. But it is entirely his choice. Do not take away or abrogate and replace it, is my position. And this is why I am saying this bill is dead on arrival when it comes. Sorry? I'm not sure. Oh. Yes. Now, it's always convenient to be guided by the approach in other jurisdictions. Where jury trials, where judge-alone trials have been introduced. And you would see that that approach is consistent with our present law, the 2017 amendment, where the gold standard of jury trials is treated as the default, and in certain circumstances, judge-alone trials would be allowed. That is what prevails in other jurisdictions. Not a single jurisdiction, which I am going to refer this Senate to, Mr. President, has sought to take away and make judge-alone trials the default position. It is consistent with our present law. Let me refer you, first of all, to the position in the Cayman Islands, where judge-alone trials have also been introduced. And it reads, Mr. President, if an accused person is of the opinion that due to the nature of the case or of the surrounding circumstances, a fair trial with a jury may not be possible, the accused person may elect to be tried by a judge alone. So in the Cayman Islands, it's a right to jury trial, but if you think the circumstances are such as the gravity of the crime, the brutal nature, public sentiment, then you may elect to be tried by a judge alone. At least the difference is they specify the circumstances. That's the only difference with our current legislation. But it's the same effect. You have a right to be tried by judge and jury unless you elect to be tried by judge alone. Let's look at the position in Jamaica. And I would only look at the position for major indictable matters, such as murder and rape in the High Court. It is to be tried by a judge and jury unless the prosecution and the defense consent to a judge-alone trial. So here we are again with judge and jury being the default, judge alone being if the prosecutor and the defense consent. What is their thinking that is not in our thinking that we now want to go a step ahead, and none of these places have any such proposal to change the law as it currently is? So what is our thinking? Innovation? We are innovative. We are the first. Well, we would be the first to be going backwards if this bill becomes law. And in the Turks and Caicos Islands, very interesting, you have a right, either the prosecutor or the accused can apply for a judge alone trial if it is in the interest of justice. But the default position is that you are to be tried by a judge and jury. And if you wish to be tried by a judge alone, you have to make an application to the judge and demonstrate why it is in the interest of justice for you to be tried by a judge alone. And what the Turks and Caicos Islands have done, very careful in their drafting, they have gone on to explain what are the factors a judge must take into account in deciding whether it is in the interest of justice to be tried by a judge alone. And that is the nature of the charge. If it is a very serious charge, attracted a lot of publicity, the complexity of the issues, the possibility of jury tampering, all such matters will be taken into account for the judge to decide. In the Turks and Caicos, the judge also has the right of his own volition to say, I am going to try it by judge alone if it is in the interest of justice. But where the judge does that, the parties can make submissions to the judge that you are wrong in your determination and I want a jury trial. And the judge has to give reasons why he wants to do a judge alone trial. And those reasons are appealable. So every jurisdiction that I have referred you to, Mr. President, continues with the gold standard and specifies the circumstances in which judge alone trials would be allowed. If this bill is passed, our present legislation is consistent with those provisions in other jurisdictions. If, however, this bill is passed, our legislation would be sticking out like a sore thumb in the English-speaking Caribbean, whereby we would be the only person to have denied a person the right to trial by jury, by default. It is totally unacceptable. And I have seen it work. I've seen it work in the Turks and Caicos Islands. Fortunately, I've had the privilege and honor to prosecute two of their most high-profile murder trials within the last 3 years, and one was a judge alone trial, and one was a jury trial. So I have been in that system, and I have seen how it worked. And the one that was a judge alone trial was decided upon because the accused in that particular matter had been accused by the general population of having killed about 1 or 2 people already, and it was time to deal with him. And in those circumstances, he was fearful of public sentiment against him. And in those circumstances, the interests of justice required that. So that is how it works in other jurisdictions. So our new radical provision reads, unlike everywhere else, which I've just illustrated to you, this is how this new bill would read, if it becomes law. A person against whom an indictment has been filed shall be tried by a judge alone unless he elects to be tried before a judge and jury. That makes it sound nice, like if he has a right to elect to be tried before a judge and jury. But no, that isn't true. Because that is followed by unless he elects to be tried by a judge and jury, and the court so directs in the interest of justice. So the default position is, if this bill becomes law, the default position would be he has to be tried by a judge. alone. And he could apply to be tried by a judge and jury, but he has to demonstrate it is in the interest of justice. How does he demonstrate that it's in the interest of justice? The law does not even specify what are the factors to be taken into account in deciding whether it is in the interest of justice. Mr. President, you would remember when I referred you to the provisions in the Turks and Caicos, those provisions specify what you take into account in deciding whether it is in the interest of justice. This bill does not specify a loophole. What is in the interest of justice? So a man must now argue before a court, it's in the interest of justice for me to be tried by a judge and jury, but no factors as to what is in the interest of justice. So what is he going to argue? How is he going to convince a judge? This is a case of abolition, masquerading, and hiding behind a suggestion of preservation. Trial by jury would still be on the law after this bill, but as a matter of practicality, it will not exist. Because an accused would have to demonstrate to a judge, it's not in the interest of justice for you, judge, to try me. Which judge is going to rule? I'm going to order a jury trial here because it's not in the interest of justice for me to try the matter. Which judge is going to make such a ruling? That is an admission by a judge that he cannot do justice in the matter. That is an admission by a judge that he cannot bring a fair mind to the matter. Which judge is going to self-critique himself in that kind of a way and order a jury trial? I dare say none. And that is why I say you have it on the books till after this bill becomes law, but it's just on the book. It's just academic. It's just theory. It's deceptive. It is abolition of jury trials, hiding behind a facade of preservation. And my difficulty, Mr. President, with that my difficulties with that are many. A judge alone for a possible murder conviction, whereas jurors can exchange their views and their different perspectives, and one could correct one on his view of the evidence or interpretation of the evidence. And they sift through, and after the end of how many hours, they come up with a verdict. Who is a judge exchanging ideas with and double-checking but himself? He has no one to exchange ideas with. His opinion is his opinion. It's not like a, if I may draw reference to a movie, it's not like that Jim Carrey movie, Me, Myself, and Irene, where he could split himself into three and discuss different views. It is him and him alone. And if he has a bias, there is nothing to counteract that bias. Whereas if you have a number of jurors sitting, they can counteract each other. Checks and balances. With a judge alone, there is no check and balance. A criminal trial is about finding of facts. As the saying goes, book sense made before common sense. Sorry, common sense made before book sense. And therefore, not because a judge has a law degree and legal qualifications, he's better able to pronounce on facts than jurors who are in the society every day, who are taking the priority bus route every day, who are mixing with others and knowing how people think every day. They don't live in clustered environments. And in chauffeur-driven cars. They have the opportunity to apply their common sense. And that is what facts are about. That is what determining whether somebody is lying to you or the defense is speaking the truth or an accused is speaking the truth. That is what that is about. Assessment of fact. And that is the advantage. If the judge has a bias, subconscious or otherwise, there's nothing to correct it. Mr. President, when a judge directs a jury in a trial, the judge is entitled to tell the jury his opinion about the facts. But he must tell that jury, you are not bound by my opinion on the facts. So they can now assess his opinion on the facts and either reject it or not reject it because they may not find it carries much weight. That check and balance is not available with a judge alone. He can't reject his own opinion on the facts. And if he was flawed in arriving at it, then that flaw remains. Another situation, sometimes you have the most graphic of confessions. In a jury trial, if a judge excludes a confession, the jury never hears about it. Under our system, if a judge presiding alone excludes a confession, he excludes it in theory. But he would have already read all the details about what the accused said, how I did the crime, or whatever. There is a risk that he may not be able to divorce his mind from what he has read, even though it is excluded in the evidence. So why are we seeking to abandon the present system and replace it? The Attorney General has lauded the present system. How many judge and jury trials have taken place under it? So then what's the philosophy for it? That is why in my opening I said it appears as though fairness in the administration of justice is being compromised by expediency. Well, let me deal with the misconception that jury trials are responsible for the backlog in the system. A jury comes at the tail end of the process. When a jury is selected, Mr. President, I know not everybody in here are attorneys, but when a jury is finally selected, the trial is ready to begin. You start the trial when the jury is selected. The trial begins. You see, however long and how many years it takes before it reaches that stage, that is our problem in this criminal justice system. That is where the backlog lies. You've heard the exchanges between senior judicial officers and prosecutors, and even the Attorney General has joined in the fray over who is to blame for what and where and what is happening. At no point in time I've heard any of them mention jury trials are to blame. Mr. President, the length of time it takes for an indictable matter to be completed in the magistrate's court have nothing to do with juries. The length of time it takes after the matter is completed for the committal papers to be sent to the DPP's office have nothing to do with jurors, the jury system. The length of time it takes for the DPP to draft and file an indictment after it finally arrives at his office after how many years has nothing to do with the jury system. The short staffing of the DPP in taking however long, as he says it's short staffing, I don't know what it is, in taking however long to put the matter before the court has nothing to do with the jury system. The length of time the matter spends being case managed before a trial date is set, this is after it reached the High Court under case management conferences, and the length of time it takes for disclosure, the prosecution to make its disclosure and all of these things, and all the years that have passed have nothing to do with the jury system. And when we are talking about backlog, that is where the problem lies. The various stages which I have just identified. The jury comes in at a final stage. You select a jury.
Senator, you have 5 more minutes.
The jury comes in at a final stage. You select them. I have been in trials, and quite often it takes not more than half a day. The example given by the Honorable Attorney General sticks out as the greatest exception rather than the rule, where it took months and you had to go and pick people off the beach and so on. That is not typical. And no one must be led into thinking that that is how jury selection typically goes. Yes, things happen from time to time with juries. A jury may fall sick once the trial starts. They may have the child to pick up and have to leave early and so on and so on. That is par for the course. The trial is still in progress. And these are minor, occasional delays that could happen to anyone. The marshal, not just the jury, the marshal may not be able to turn up. The judge may fall sick for a few days, etc., etc., etc. So it is misplaced to suggest and to give the impression that the problem of backlog, chronic backlog with which we are faced, is due to the jury system. Because when I listen to the Honorable Attorney General, to those who may not be in the know, may have come to that conclusion. Wait, Mr. President, I know I'm almost out of time, but there is lay assessors. And the first thing that struck me, and I'm glad to have heard a senator repeat it before me, is that lay assessors are replacing special juries. And I was about to say, so I'm glad the Attorney General said it, in my 36 years of practice, a special jury. I do not know that a special jury has ever been selected for any matter before the court. But that was just my 36 years of practice, so I was glad when I heard the Attorney General say it has never happened. It's the same thing with lay assessors. It is an impractical approach. It is only sounding nice on the books, but practically it is not going to happen. And it affords no protection or no compensation for the loss of jury trials. Because for one, lay assessors are not going to be had in matters involving murder. It would be the judge alone. So he has no recourse to any assistance from any lay assessors. Secondly, the judge is under no compulsion to elect any lay assessor. According to this bill, he may select 1 or 5, or he may choose to select none at all. People are overawed by the court system from the time they turn up and they see people in robes and this and that and the other. Does one really expect some lay assessors to be sitting with a judge and not be given to influence by the judge? Or to oppose a judge? And say, no, you're wrong, I disagree with you, etc., etc., etc.? That's just the psychological aspect. And this bit of legislation with lay assessors is totally flawed. There are several anomalies with respect to it. According to this, the lay assessor is part of the court. And the judge gives the decision of the court. So if the lay assessor is part of the court and the judge gives the decision of the court, why is this bill requiring the lay assessor to give reasons for his decision too? According to this bill, the judge isn't bound by the opinion of the lay assessor. But it doesn't say whether the lay assessor is bound by the opinion of the judge. So maybe he is, because the proposed legislation doesn't specify he is not bound by it. It says the judge isn't bound by it, by his own. And then he may appoint 1 lay assessor. So if it's 1 lay assessor, he and the lay assessor alone, and they disagree, don't we end up in the same position that the Attorney General has identified and complained of? Mistrials? I am curious myself to hear about consultation. I know the Attorney General has touched on it. I am curious myself to hear and see and read what was the feedback from...
Senator, your speaking time has ended. Minister in the Office of the Attorney General.
Thank you very much, Mr. President, for the opportunity to join in this debate. Mr. President, I want to just immediately start by saying certainly I have to probably have a conversation with Senator Lakshmi Dayal after this. Clearly, the Senator has a link that the government doesn't have, because sitting in the Office of the Attorney General and Ministry of Legal Affairs, it baffles me that the opposition had a copy of LAT's comments and the criminal bar comments to date, which was issued today, and up until now, the office in which I sit in, we have not received those comments. So maybe the Senator and I can have a conversation. Maybe the opposition clearly has a link that is unbeknown to us. But I will leave that there, Mr. President, because, of course, the bill which we're about to debate today, especially coming from my experience and my practice and the chambers in which I came from, of course, I understand the importance of, some of the concerns, even raised by Senator Lakshmi Dayal, and I'm sure it may probably be some of the concerns that would probably be operating in the mind of especially the independent senators, who, of course, many of them are not legally trained. And as a consequence of recognizing that, Mr. President, I believe that this debate requires a very sober, a very, very sober approach, an intellectual discussion as best as I can to, take the honorable senators through what the amendment that the government is bringing here today, what it intends to do. Now, Senator Lakshmi Dayal, Mr. President, in her presentation would have, to my mind, I would have itemized 3 concerns that the senator would have raised. Of course, one of those concerns being the statement, my interpretation of the senator's concern is that the accused, and also it's a concern that was raised by Senator Welsh, that the accused is being denied a jury trial by the amendment that is proposed, I believe, in Clause 4 of the bill that appears before us. So that's one of the concerns. Another concern, of course, raised by Senator Welsh and also Senator Lakshmi Dayal was that concern of the downsizing of the jury, suggesting to my mind that justice in some ways being compromised in the interest of cost, or the reason why this downsizing is happening is as a cost-effective measure that this government is engaging in. And the third point that, of course, Senator Welsh would have gotten into in his contribution was relative to that whole structure of lay assessors. And it's predicated on these 3 major points, Mr. President. And as I said, I'm sure it may be also concerns that other members of the Senate may have. It's predicated on those 3 points. I'm going to more or less steer my presentation and my contribution, again recognizing the need for us to have a sober debate, an intellectual discourse and discussion on what the amendments here are proposing to do, recognizing based on the background that I come from, the criminal background in which I come from, recognizing how critical it is for us to be able to safeguard and to protect even the rights of the accused. And of course, balancing that, the protection of the rights of the accused with protecting our society from the infiltration of crime and criminal activity that occurs. Now, Mr. President, so that is the context in which I intend to make my presentation and, make my contribution. Now, Mr. President, I want to jump into immediately Clause 4 of the bill, and it reads, a person against whom an indictment has been filed shall, subject to the provisions of this act, be tried by a judge alone, unless he elects to be tried before a judge and jury, and the court so directs in the interest of justice. And I could understand that the fear or the concern can very well be that, and Senator Welsh would have made mention to it, that part of the clause that says, so direct, and the court so directs in the interest of justice. Because what it appears is as if, we start from the point where it's trial by judge alone. The accused elects whether or not he wants to be heard before a jury. And then, of course, in the interest of justice, the court so directs. And I can see the concern being raised there. And, of course, this is drafting. It's a matter of the expression and how it's expressed in the clause and the bill that appears before us. And I am most certain that when it comes to the semantics of the way in which the clause is stated, I am sure that perhaps the Attorney General, after consultation with the drafters, if that seems to be a critical concern of this Senate, that part that indicates the court so directs in the interest of justice, that suggests that a court can then say no. Accused say, I want a trial by jury, and the court says, nah, this is not going to happen. I'm sure because this is an issue of semantics, that is something that we could probably address our mind to when it comes to the expression in this particular clause. But notwithstanding that, Mr. President, I have to place on the record that the policy behind this clause was never intended and is not intended to deny the accused who elects to be heard before a jury from having that done. And I need to place that on the record. And that's why I'm mentioning that if it is a matter of semantics and it's a matter of expression, it's a matter of how this is drafted, I am most certain we on this side will hear, of course, some of the concerns by the honorable senators. And that is something, even at the committee stage, the Attorney General may very well be minded after consultation with his drafters to readdress his mind too. Now, what I must also place on the record, Mr. President, is the interpretation of the clause again is not to give the court the discretion to deny trial by jury if elected, but rather, Mr. President, is for the court to direct the jury trial in the interests of justice. And that was the intention and the interpretation and what operated in our minds and the policy that drove this particular clause. But again, if the semantics and the structure of the clause is an issue, again, it's an issue of drafting, and it is something that can be revisited. But it must be understood by all those in the Senate, and especially members of the public, that the intention of this clause was that the court to direct a jury trial in the interests of justice, not for the court to say yea or nay when the accused exercises his rights and say, I want to be heard by a jury, as opposed to being heard by a judge alone. Now, the court has to direct once the accused elects, and the judge is, of course, and the judge then gives the necessary direction.
Senator would ask to give way, if
Right.
you would allow.
Can I?
Of course.
Right. I just want to ask a question. Right now, the law as it stands right now is that the default position is judge and jury, with the choice of choosing judge alone. I need to understand why there is the need for the change. I'm not yet getting that.
So if I may understand the senator's question, you're asking that why we are starting now with judge alone, and then the accused will then make that decision as to whether or not he elects a jury. And my simple answer to that, you see, to my mind, especially coming from a criminal background, I am seeing that the accused still has the option, even though, yes, we are starting with a judge alone trial. The very fact that the accused is still given the option to decide whether he wants to be heard by a jury, that has not been taken away from the accused. You understand? So even though it has been switched around, where we start from the position, and I will get into, and why I will get into when I look at the downsizing part of the jury in particular, I will get into some of the other considerations. And of course, it's not, I don't want, when I get into that point, Honorable Senator, I will be touching on some of the realities of the selection of a jury, all right? And of course, I will have to traverse the point of cost and the process involved. It's not just simply, I heard Senator Welch mention whether we are downsizing because, of course, it's less food. Honestly, when I get into that part of my submission, Senator, you'd realize it's beyond just simply food for selecting a jury. So to answer your question, in considering, of course, a resourcing issue as well, to my mind, it is best to start from the judge alone structure, and I'm not seeing the rights of the accused being taken away, because even though we start at this level, the accused still has the right and the option to say, well, I want to be heard before a jury, as opposed to, and I think that is what our focus has to be. Our focus has to be, is the rights of the accused to have a fair trial. Now remember, constitutionally, an accused does not have a right to be heard before a jury. The constitutional right of the accused is to have a fair trial. And the mindset that we ought to have in looking at this clause is whether or not this clause seeks to take away that right from the accused. And my suggestion is, even if we are starting from the point of where this is a trial, we are starting from the point where it's a trial by judge, and we give the accused the option to elect whether he wants to be heard by a jury or not, that is clear enough to show that that right, that constitutional right that this accused is entitled to, that right has not been abrogated. We are not taking away from that right. We're giving the accused, we're giving the accused the option to decide. And you see, this must also be taken, and to answer your question too, why are we starting? Why have we flipped the position? That is where, when I get into my submissions and going through in detail the process in electing a jury, the financial cost attached to electing a jury, hopefully you'll be able to understand why it's our policy position at this point. Let's start from the point of the jury, from the judge alone. Give that accused, the right to decide whether he wants to be heard before a jury or not. And then, of course, because in that instance, we're not taking away his constitutional rights to a fair trial. Now, clause, so that was just to place on the record, Mr. President, relative to what our mindset and what our intention was relative to that particular clause. And I'm sure, of course, the semantics, I want to reiterate the way in which the clause is structured. Perhaps that may be the cause of the concern, whereby it appears as if the judge can then decide yea or nay to whether or not we will proceed with a jury trial. And because it's a matter of drafting, as I said, I'm most certain the Honorable Attorney General will be minded to hear some of the concerns and readdress his mind to that, of course, after, consultation with his drafters. Now, I want to immediately jump into the discussion that we have had this morning relative to the reduction in the size of the jury. Historically, if I may get into a little bit of history, brief history about the composition of a jury. The number 12 and 12 juries, the jurors that sit, there is no empirical data. There is absolutely no evidence that suggests in any jurisdiction and any reading that I have done that 12 is better than 6 or 12 is better than 9. As a matter of fact, when we look at the history of the 12, Mr. President, I may go back, and it's surprising Senator Welsh brought the issue because it was actually the Welsh King Morgan of Glamorgan who established jury trials in 1725 AD. And in 1725 AD, to be very honest, the reason why 12 was selected was because at that time, it was because of Jesus Christ and his 12 apostles. And when that 12 was selected as a jury, that is where the emergence of that 12 jury came from. And the reason why I bring that up, it's of course because it was not that mathematical figure 12. It was not as if that there was data to drive to believe that for some reason an accused had a better opportunity or better chance or fair trial by being heard by 12 jurors. Now, added to that, Mr. President, in Trinidad and Tobago, there is the Privy Council case of Trevor Stone versus the Queen. And it's ruled that a Supreme Court judge sitting without a jury is simply a matter of practice or procedure, and there is no infringement of the entrenched constitutional rights. So I just want to put on the record that particular case, which also bolsters the position that I earlier stated, where I spoke about, the issue here should be whether or not the amendments we are bringing here today, whether or not it's going to deny the accused of a fair trial. And I'm saying that in this Privy Council case, what the learning, some of the dicta that comes out of the case is, of course, that is not a judge sitting without a jury is simply a matter of practice and procedure. And the Privy Council is saying that there is no infringement on the entrenched constitutional rights of the accused. Now, I also got into, Mr. President, the constitutional rights of the accused, which is really that right of a fair trial. Coming now, jumping up into the dance of the reduction of the size of the jury, Mr. President, I respectfully submit to the Senate, which I have already done, is that it will not infringe the right of an accused to a fair trial. Because, of course, we must balance the right of the accused persons, of course, and the practical benefits, Mr. President, the practical benefits of a smaller jury. And this is where now I will jump into some of my personal experiences, because I know Senator Lakshmi Dayal would have spoken at length about some of her personal experiences, and I want to join the senator in also sharing with some of my personal experiences. Now, we are looking at, even if we reduce the size of a jury from 12 to 6, I want this Honorable Senate to be reminded that this jury is still going to be selected from a cross-section of society. So we are looking at persons who sit there are going to be persons who have varied social backgrounds. These are persons from various economic structures. These are persons who are bringing their own experiences to, of course, their deliberations. So let's understand that. By reducing the size, we are not, even though we are reducing the size, the amendment proposes to reduce the size, we are not reducing the fact, that does not take away from the fact that it's still going to represent a cross-section of different persons who sit, the regular man on the street, the PTS, the priority bus route person, I think Senator Lakshmi Dayal talked about in her presentation. That 6 is still going to be very much representative of our society. Now, added to that, Mr. President, I believe what is also critical in looking at the 6 jurors that we are proposing in the law today, I have personally, and I agree with Senator Lakshmi Dayal, the impaneling of a jury sometimes just takes place in the morning of the selection of your trial. And yes, it's not that it will go days on end in selecting a jury. I agree with that. But I also agree, but I also have to state that I have sat into those sessions in which you have juror after juror giving excuses for why they do not want to serve. And the point is that so sometimes it may seem as if we may have 72 people who is called upon for jury duty. But I have sat in where sometimes you can't even get 5 people who are willing to be able to serve as jurors, and some of them have legitimate concerns, and as a consequence of that, the court they cannot be bound to serve as jurors. And that has been my experience. And I am here representing an accused person whose matter is now finally for trial, who has been probably in remand for X amount of years, well, of course, depending on the matter that is before the court, and I now have to wait and pray to God that I can have a properly constituted jury before my client, who has already faced the wrath of being in prison for an extended period of time, before I could even get 5 men, much less 12 men, to sit and adjudicate over this, to listen and to, for this matter to proceed. So I want to also remind the Honorable Senate that it is not as easy as it appears. And I see Senator Bisram Singh, and I know Senator Bisram Singh comes with a wealth of experience at the criminal bar. And it's nice to see you here, Senator, and let me recognize you. And I'm sure the Senator, if she is fair to this debate, which I'm sure she will be able to draw on her experiences and some of the trials and tribulations that you often face, even in impaneling that jury. And from a defense perspective, I am saying, and this is not simply because I'm sitting in government now, I believe that there is merit to the reduction, even and more so in the interest of justice and in the interest of your client's matter being expedited and not having to be further derailed because we are waiting to have a properly empaneled jury. Now, Mr. President, with that being said, I want to get into, again, making reference most respectfully to a submission that was made by Senator Welsh. Of course, when the Senator spoke about the reduction and asked the question whether or not, if we are just looking at, whether we're going to reduce our food bill if we have less juries. And at this stage, I must place on the record, Mr. President, and at least for the benefit of my colleagues in the Senate, to understand understand the behind the scenes now of the judiciary being able to create a pool of persons who can then be put forward before the prosecution and before the defense, before a jury is impaneled. And I believe that conversation and that understanding is critical, because then I'm hopeful that once this is placed on the record, members of this Senate will understand why the policy position now, we have had to, as a responsible government, we have to take the real woes and concerns that sometimes will face the judiciary and the cost factor that it entails in creating that pool of juries. I'm not talking about 12, because remember, people, we are looking at 12 juries. That's not where it starts. It don't start with 12. It starts with about 72 or 75 persons who come before you, prosecution and defense, and then you choose 12 from that. So I need to go not just to the 12. It starts the process, and the money and the expenditure that goes into a jury is not from the point of where you have 12 impaneled person. It is beyond that. And that is what I need to remind this Honorable Senate about. Now, Mr. President, the average cost for a jury trial, if I may respectfully place, and I must say, and I want to reiterate, this is not in any way my attempt to say the rights of the accused is not important. This is in no way to say that cost trumps the interests of justice. This is not my intention. But my intention is simply for this Honorable Senate to understand the process that goes into and the cost factor that goes into to even getting that 72 odd men and women to stand before the prosecution and defense before you could even dream to impanel them. The cost that goes into that. So we are talking about feeding the 12 during the course of the trial yet. We haven't reached there yet. We're talking about just to get a group who's impaneled, right? Mr. President, so for example, the first thing that has to happen is jurors. You have to serve jurors, potential jurors, right? At least 72 summonses, if I'm using 72 as the figure, has to be sent out by the judiciary. Mr. President, if I may place on the record, a team of staff is sent out countrywide from the judiciary to find these persons. Mr. President, this requires the marshal's assistance in order to be able to go throughout Trinidad and Tobago in order to get these 72 persons. So mind you, I'm saying again, we are reached where the 12 men sitting in a jury to listen to a trial letter. We're talking about, we're just trying to get together 72 people who could come before a prosecution and a defense for us to choose. So we're looking at you're serving, the court has to expend money for marshals. The court has to get travel cost. The court has to, sometimes you go back to one person, a potential person on that list, you have to go 3-4 times to find them because man ducking jury when they hear the court looking for them and marshal looking for them. That's the reality. That's a cost factor attached to that. Mr. President, the system to send out the summons to these 72 persons, there's a cost attached to that. Mr. President, the system to create a national jury list requires the assistance of EBC. It requires the assistance of the magistrates court to get that countrywide 72 persons. There is a cost attached to that. Mr. President, the jury call takes 1 full day. A full day sometimes, as Senator Lashmidial alluded to. The cost attached to that full day of hearing excuses after excuses, for you to even dream to get 5 man, much less 12 man. There is a cost, a real life cost, Mr. President, attached to that. Mr. President, if I may also go into the arraignment and impaneling of a jury, Mr. President, is another day. That is a cost attached to that because you're talking about you're preparing refreshments for them. You're talking about you have them there waiting. That is a cost. So respectfully, I do not want this Senate to believe that we are trivializing or we're putting cost over or cost in any ways to trump. Of course, it's not that cost is trumping the rights of the accused. But certainly, as a responsible government, one, we have ensured by the amendments, we are not infringing upon the constitutional rights of the accused to have a fair trial. So that is the reality of the amendments that we have brought here. But the reality is that in the interest of the administration of justice, in the interest of resources and resourcing issues, we have to bear in mind the realities of the cost that is attached to being able to have 72 men in the first instance appear before you can even decide who is the 12 you're going to select to appear before to listen to this trial. And it goes further, Mr. President. You have food for juries. Yes, that is what Senator Welch would have alluded to. That is a cost. It is not a trivial cost. We have court buildings have to be bigger to accommodate jury deliberations. That is a cost. If it is, we have 72 persons. I have often seen where sometimes, well, of course, mainly is the criminal courts, which are the larger courts often, at least at our High Court. Excuse me, Mr. President, here. That is a cost attached. There is a cost attached to that. Mr. President, there's a security cost when you bring the 72 persons there. Because we have to also bear in mind the safety of these potential jurors. And security is a real issue that the judiciary, of course, it's an expenditure that will have to be footed by the judiciary, and resources will have to be to be allocated for that particular cost. Mr. President, there is also a cost of assisting jurors' families, which is something we have to bear in mind in getting that 72 persons ready. And that, Mr. President, of course, the cost attached to that is in instances where you have a single parent or you have single families who now have to come on down to serve as juries. Now, of course, all of these things, and mind you, even Forget the 7. So I spoke about the 72. Some of these costs that I'm referring to, Mr. President, will also apply when we have the 12 jurors sitting there. You understand? So yes, I've spoken about there is a significant cost prior to getting them to the court, but everything that I've made mention to, where you have to cater especially for a juror's family, where there is a single parent, and accommodation, Mr. President, has to be made for children. School transportation. This is so the juror could focus on the case and not be otherwise concerned about, okay, well, I'm a single mother, my child is home, who's going to take? That is a cost that the judiciary bears. And I need this honorable Senate, I need this country respectfully through you, Mr. President, to understand that this is not just a matter of food. This is not just a matter of 6 lunches instead of 12. This is a significant cost that we have had to consider. And even if it is that 6 persons could help and reduce that cost, Mr. President, it is something that we have considered. We understand that the amendments that we are bringing here today, that it is in no way at all intended to affect or abrogate the right of the accused to have a fair trial. But certainly, if we could maintain the interest of justice and at the same time balance that properly with saving the state and saving expenditure, then what is criminal about that? What is wrong about that? To my mind, Mr. President, that is responsible leadership. Mr. President, if I may also say another cost, and I'm going through the cost because I know because this is one of my submissions relative to the reduction in the size of the jury. Mr. President, we must ensure that all jurors are up to date with technology. That is also and we saw that, well, of course, the pandemic would have spun, that things would have just gone out of whack during the pandemic, where we realized how critically the technology, how even more critical it was back then during that time. But that also bears a cost to it, Mr. President. Where there are late night deliberations, Mr. President, we must provide, the judiciary must provide transport for jurors from the court to their homes. That is a real life cost attached to it. And respectfully, I've gone through in some detail, Mr. President, the list of the issue of cost, and with the expectation or the hope, Mr. President, that this honorable Senate understands that this is simply not a matter of food. This is not a trivial matter. all of these factors would have had to have been considered. And certainly, we are of the view that if it is the reduction, we believe that the reduction can certainly assist in the reduction of some of that expenditure that I would have gone to length on deliberating in bringing forward to the Senate today. Mr. President, what I also want to say, Mr. President, is that we must remember, if we have a reduction from 12 jurors to 6 jurors, so yes, we are proposing the reduction. Please remember, it is both the prosecution and both the defense who they both stand on equal footing in trying to convince these 6 persons as to whether or not they believe the prosecution's case or the accused's case. The reduction from 12 to 6 does not put one party in a more advantageous position than another party. Because it's the same 6 that both the prosecution, both the defense is going to have to appear before, and both the prosecution, both the defense is going to have to convince as per the merits of their particular case. And I just needed to respectfully remind the Senate about that. And one thing I know Senator Lakshmi Dayal made mention to in her presentation, but it was, she didn't get into it. It's something that I want to remind the public and, of course, members of the Senate of, is Section 23 of the Jury Act, and that speaks to the whole challenge of the empaneling of a jury. And what that Section 23 of the Jury Act speaks to is, and the reason why I'm mentioning it, why I want to get into this, is because, of course, that is to remind honorable senators that even though we have a reduction in size, Section 23 of the Jury Act still stands, and that is a section in the Act that contributes significantly to both the defense and the prosecution having some level of control over the persons who are impaneled to sit as jurors. And of course, operating in both the prosecution and the defense mind will be, let me impanel a jury. Once the jury is being impaneled, let me look at the court, let me make a decision as to who I'm going to object against or not in the interest of my client. And I'll give you a perfect example. I'll be very honest. In practice, if you're doing a matter, a rape matter, for example, I noticed, if it's my colleague and I, usually we did those matters together, and one of us, our strategy was, once you're doing the impaneling of the jury, my responsibility was to kind of assess these jurors. And if I find somebody looking too churchy or too prayy or in a rape matter, I can evoke my Section 23 right under the Jury Act, which is I'm allowed 3 challenges, and I can reject 3 persons based on just the mere fact of how they look. And I have to not, Section 23 says, it requires no prosecution or defense to give a reason for the rejection of that particular juror from sitting in the panel. And that Section 23 right is also further. So in other words, both the prosecution and the defense, once you're impaneling a jury, you have that option to deny 3, to say to the court, I am not in agreement with these 3 jurors. Both the prosecution and the defense has that option. Section 23A, of course, of the Jury Act then goes on now to speak about with cause. And those are the instances where now both the prosecution and the accused can then advocate and make a submission to the court as to why they do not want, of course, certain jurors to be impaneled. Of course, they have the Section 23, big A in the Act, spells out the parameters in which you can make said submissions. One example, for one scenario is, for example, if the accused says to you, well, I know that man. He live in my village, or he and I had some run-in some time ago, whatever. Then, based on Section 23A, you can raise a with cause objection to this jury being impaneled. Now, why am I going through this Section 23 of the Jury Act? So that persons understand that even though we are reducing the jury from 12 to 6, the accused and the defense and the prosecution still have the provisions of Section 23 Section 23 and Section 23 Big A, the provisions provided there to determine to a great extent the persons that forms part of that jury. And I believe that we cannot look at the reduction in the size of the jury without reminding ourselves of Section 23 of the Jury Act. And the fact that Section 20...
Senator, you have 5 more minutes.
Yes, and the fact that Section 23 of the Act, of course, allows for that. Mr. President, well, time surely flies. I wish I had 2 days to debate this bill, but time surely flies. Mr. President, if I may now, well, with the limited time I have, get into the issue of lay assessors. Now, you know, I want to also place on the record, and especially for my colleagues in the Senate, please, who are not legally trained, let us please understand when we speak about judge alone trial is not a new phenomenon to our jurisdiction. Certainly, it is new relative. It was new to our jurisdiction in criminal matters. But if we look at the civil courts, for example, in the civil courts, it's a judge alone trial. And a judge is required to both assess the facts and the law and come to a determination. If we look at family matters, it's judge alone trial. Those matters go before a family judge who in his discretion makes a determination on the evidence and the facts of the case. In magisterial matters, for example, when we have magisterial matters, granted it's not a judge, but it's a judicial officer nonetheless, we have magistrates determining matters on their own. So I just wanted to respectfully remind the public, and of course, members of this Honorable Senate, which I'm sure they are aware of, that this judge alone is in no way an attempt for us to stifle something new and it's out of this world and it is exception. No, it's not. Even in our local jurisdiction, yes, albeit it's in the civil court, albeit it's in the family court, in the magisterial districts that exist, but we have the existence of where the judge alone sits on these matters. Now, Mr. President, again, well, time certainly is against me. If I may respectfully get into, if I can, section clause 6H2, of the bill that appears before us. It's just one of the parts that speaks primarily to the interest of justice. And it says, where the judge is of the opinion that it would be in the interest of justice that the assessor or assessors assisting him do not take part in any decision upon the question of evidence, whether evidence, of any confession or other statement made by an accused is admissible as evidence against him, the judge alone shall decide upon such question, and he may for this purpose sit alone. Mr. President, this particular clause, Mr. President, I believe that it is critical because, of course, this is where, of course, you give a judge, where a judge who uses the assistance of lay assessors could then decide, of course, in the interest of justice, what weight, if any, I'm attaching to the assessment of the evidence made by lay assessors. And, of course, certainly, again, because of time, I'm not going to have the opportunity to get into this. And as a consequence of that, Mr. President, I just want to simply reiterate certain points, very, very briefly, as per why I support the lay assessor structure. You know, in the civil courts, for example, Mr. President, and granted the structures are very different, so please, I hope I'm not misquoted where I'm making where I'm saying it's similar. The structures are very different, but I need to mention what happens in the civil court with expert witnesses. In the civil court, oftentimes expert witnesses are called upon to assist the court when the evidence is of such a technical and an intricate nature that even the most learned judge cannot comprehend and understand the severeness and the technicality of the evidence. And in the civil arena, we have seen the benefit that these expert witnesses prove to the understanding and assessment of evidence. Again, because time is against me, very Simply put, Mr. President, the intention of these lay assessors and the structure of these lay assessors is to lend that judicial officer that support that he may require, of course, in the understanding of complex matters. And of course, yes, there are a list of matters in which the bill, of course, identifies in which lay assessors can be used. And so, for example, let's say you're dealing with an intricate financial matter with the creation of shell companies. And a judge, for example, albeit he's a very specialist judge, he understands the law, he may need the assistance of these specialists to guide him in understanding of that assessment of evidence. So, Mr. President, again, time is always my enemy in this most respectful place. I thank you most sincerely for the opportunity to make a contribution in this debate.
Senator Mark.
Thank you, Mr. President. Mr. President, we have before us today a bill which seeks to amend the Jury Act and, of course, the Criminal Procedure Act. Mr. President, this bill that we are debating today follows on the heels of a bill which was introduced and passed in 2017. And it was proclaimed, according to the Attorney General, sometime in February of 2018 or thereabouts. That was famously captured under the title Judge Alone Trials. Mr. President, I want to say that I've listened to the Honorable Senator in the Ministry of the Attorney General and a minister, attempt to convince us of the authenticity of her case and that of the government. But the arguments were very weak, feeble, at times convoluted, as she sought to try to convince us of the soundness of the government's argument for this policy that they have introduced in this bill today. I think the members sought to defend the indefensible. But I want to say from the outset that all this question about cost that we have been hearing as it relates to juries, I want to say, Mr. President, that democracy is a messy subject. It's a very expensive mode of government. Churchill once said that to date, the majority of humankind is yet to find a better mode of governance. So it is very expensive. And therefore, we have to appreciate its value. Because the alternative, Mr. President, is tyranny and naked despotism. That is the alternative. So why, for instance, are we trying to push the society into that direction? This is what this bill represents today. Mr. President, let me tell you what Lord Devlin, at a lecture in 1956, told the world on the subject matter of trial by jury. I think it's important for us to pay attention because, Mr. President, I keep reminding this Honorable Senate that dictatorship, tyranny, despotism do not arise overnight. It is brought about incrementally in small degrees. And what Lord Devlin told us at this lecture in 1956, and I want to quote, "The first object of any tyrant in Whitehall would be to make Parliament utterly subservient to his will, and the next to overthrow or diminish trial by jury. For no tyrant could afford to leave a subject's freedom in the hands of 12 of his countrymen." Mr. President, that is what Lord Devlin told the world. And we are now witnessing today an attempt by a tyrannical, despotic regime that is on the course of abolishing, through this piece of legislation, your right to be tried by your peers. That is what is at stake here. And they put it in a nice flowery way, Mr. President, that the trial judge, the judge in question, will determine through an application by my attorney if I'm the accused. You putting that in the hands of a judge who the Minister of National Security and the government has yet to condemn. He told the whole world, and I'll tell you about that later, not now. So we have to be clear what we are about. Mr. President, I want to indicate, before I contextualize what I want to advance, this bill represents an affront to the intelligence of the people of our nation. It is a brazen assault on our democracy. This bill is a brazen assault on our democracy in Trinidad and Tobago. I will show how it is a brazen attack on our Constitution, particularly in its preamble and Section 5, F, subsection F, subsection 2, which deals with a fair trial by an independent and impartial tribunal. Mr. President, this bill is also attacking the principle of the separation of powers. And I will demonstrate why and how. That is why I asked the question of the Attorney General. Why did you insert yourself here? You're a member of the executive. This is a judicial function. What you're doing here, it reminds me of the Firearms Amendment Act, when the minister inserted himself to grant you permission to extend through him your firearms license. And when the Senate revolted against that, they had to withdraw it. And that is what we are seeing in this piece of legislation in terms of this attack on the separation of powers. Mr. President, it is also an attack on the grassroots of our nation. Mr. President, may I remind you, if you are not aware, that this conversation started in earnest at the opening of the 2016-2017 law term, when our Honorable Chief Justice at that opening of the law term called for the abolition of jury trials in Trinidad and Tobago. And the Chief Justice at that time, who is the current Chief Justice, said that contributed to the delay in the criminal justice system, and said that it was a systematic failure. That is the trial by jury, judge and jury. That is where it started. And then a couple months later, it was brought to the Parliament. It was brought to the Parliament in the form of a miscellaneous provision, trial by judge alone 2017 bill, which is now an act. And Mr. President, you know what happened? The Attorney General then, Honorable Faris Alwari, Member of Parliament for San Fernando South, San Fernando West, I should say, he indicated on page 40 of the Hansard of his contribution, according to the information I have, and I quote, "This bill allows us, by taking a partial step towards judge-only issues, partial step towards the removal of trial by jury." That is what the former Attorney General Faris Alwari has on the Hansard record in 2017. He told us the bill that we were debating was the first step, a partial step towards the removal of trial by judge and jury. So when the minister brought the bill today, and that is what we are debating, it is to conclude that particular objective. And they used nice, flowery language in order to mamagai and to fool and to mislead and to misguide the people of Trinidad and Tobago. Mr. President, how can we support a measure that is going to undermine our democracy? We cannot. Mr. President, if you don't know, let me inform you. There are two fundamental rights that the ordinary people enjoy under our Republican Constitution that allow them to participate in the democracy in our country. The first is the right to vote in general elections. That is a fundamental right that the ordinary man enjoys in our country. Mr. President, if you read the preamble to our Constitution, it talks about the participation and involvement of the ordinary people in our country in civil matters, in civil life. When you translate that, it means your right to participate in judging a person who has been accused of a criminal offense. Meaning, Mr. President, you have a right to sit and to judge and accuse. It is your peers that judge you, that judge us, who may end up on an indictable charge in the courts. That is the way that the ordinary man participates in the criminal justice system. But we have an elitist government, a bourgeoisie government that wants to remove that right and put it into the hands of judges. I have no problem with judges. But how can you put me, Mr. President, if they accuse me of misbehavior in public office, and that is an indictable offense, and this thing takes effect, my lawyer who is defending me, I say I want to be tried by a judge and jury. You know what my lawyer have to do under this piece of legislation? He has to make an application to the judge who is trying me, and the judge will decide. The judge will decide if my lawyer's application for judge and jury trial will be permitted. How can that be real in Trinidad and Tobago in 2023? I must have that entitlement. I must have that right. You cannot take away that right from me. There are certain endowed rights that are given to us by our Creator, the Almighty God, that no man, no living man can tamper with. None. I am entitled to that. So you want to take away my right to be judged and to be tried by my peers for them to determine if I'm guilty or innocent? Are we serious? You can't do that. That is impermissible. And how can you bring that kind of peace legislation to our attention today? I think Senator Welch said it well. You look at 2017, Mr. President. Look at what we had in 2017. And you will see, Mr. President, what we had in 2017 was a piece of legislation that offered the people of Trinidad and Tobago choice. You had choice. There was an election of choice. I have it here. Right? It is in the legislation of 2017, Mr. President, right? Where you are entitled, right, to make a decision through your lawyer to elect to be tried by a judge and jury. But the government says no. That is a default option now. The real modus operandi going forward, if this bill becomes law, is trial by judge, I should say, alone. That is the modus operandi. That is the status, the new status. And the default position is that if you want to be tried by a judge and jury, then I make an application. Mr. President, I raised the matter with the Honorable Attorney General as to whether he had any consultation with the various stakeholders. He said he will provide that with us, provide us with the information in due course.
No,
because he didn't have
please.
it at the time. Right? I haven't seen any information.
Senator Mark, a senator would ask to give way, if you would allow.
Just on a point of correction, Mr. President, the question that was asked of me is whether I could recall the dates. And I said I could not recall the dates, but I have named the entities with whom the government consulted, the AG consulted.
Well, if that is true, and you indicated that that helped in the formulation of your bill, it meant that those stakeholders would have told you that they are not in support of that piece of legislation, especially Clause 4. I have before me a statement from the Law Association issued today, which was sent to Mr. Brian Caesar, the Clerk of the House, to circulate to all members of Parliament. I have it in my possession. I got it. Mr. Caesar sent it to me. So don't tell me about I have it. I have it, yes. And what I'm saying, Mr. President, the Law Association is telling us in no uncertain terms that they are not in support of this particular measure. And throughout their statement, the operating word is fairness. 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 This is an unfair approach that the government is taking. And I have in my possession, and I'll pass it on to my colleague, that is Senator Sagram Singh Suklal, on the whole concept of the numbers. Why reduce it from 12 to 9? The more people who sit on a jury with their different cultural backgrounds and given the diversity of the country, is the better they will be able to arrive at a decision one way or the other. So why are we reducing the number from 12 in the case of murder and treason to 9? And then, Mr. President, for all other indictable offenses, it is gone from 9 to 6. Why did the government choose to reduce our peers, the ordinary man and woman, from 9 to 6 and from 12 to 9? Mr. President, we do not support any reduction in the number of jurors in Trinidad and Tobago. If you want to deal with that, go and have open public consultation with the people of Trinidad and Tobago. Mr. President, may I remind you? I have something called the Jury Act. The Jury Act, which is before us for amendment. Mr. President, the Jury Act came into being in 1922. Over 100 years ago. And the Criminal Procedure Act, which entitles me, if I plead not guilty, in Section 37, and Section 6, respectively, I am automatically entitled to a trial by judge and jury. So both in the Jury Act and in the Criminal Procedure Act, that is a right, literally, that I enjoy, or the people enjoy in this country. So the British colonialists brought that into being. Eric Williams allowed it to continue. Robinson allowed it to continue. Basdio, Pandey, and Chambers allowed it to continue. Patrick Manning, who is dead, and may his soul rest in peace, allowed it to continue. The Honorable Kamla Prasad Bisasa allowed it to continue. Dr. Keith Christopher Rowley, our Prime Minister, wants to abolish trial by judge and jury. As Israel Khan said, only a fool or a dictator would want to go down that route. Why would you want to go down that route? Why? So, Mr. President, we are saying that when we look at this legislation before us, we are very clear. We are calling on the government to withdraw this bill from the Senate today. Withdraw this bill. This is an affront to the country. This is an affront to our country's constitution and democracy. And it cannot be entertained. It cannot even be amended, Mr. President. The structure of it is so inherently flawed that you cannot even amend it. So it has to be withdrawn from us today. Mr. President, let me just explain to you some of the areas of this piece of legislation that is extremely disturbing and worrying to us in the opposition. Mr. President, if you go, let me just get that piece of legislation. Mr. President, if you go to the legislation that is before us, you are going to see, among other things, what I describe as an incursion into the rights of the people. You know what the government has done, Mr. President? It's like double injury. Not only has the government sought to reduce the number of ordinary people who will sit in judgment of an accused, and that is what you talk about, being tried by your peers. You know what they have done also, Mr. President? They have abolished special jurors, and they have also exempted more categories of persons who will not be able to serve as jurors. So what they have done, Mr. President, they have narrowed the pool of men and women who can come forward to serve as jurors, while simultaneously abolishing special jurors and bringing in lay assessors. Lay assessors. And of course, the Honorable Attorney General gave us an idea of what he meant in terms of the personnel that would be targeted to make up this pool called lay assessors, inclusive of attorneys at law. And they are going to be paid directly from the consolidated fund. So you are increasing, or you are establishing a new layer called lay assessors, but you are seeking on the other hand, to abolish the jury system in Trinidad and Tobago. And we heard Senator Sagram Singh at length trying to refute Senator Welch's contribution on the matter of cost. But she did concede that it costs the taxpayers, and therefore that must be factored into this equation that has brought us here today. Mr. President, democracy is an expensive business. You have to pay for democracy if it is to survive and to be sustained. Mr. President, let's go to this bill, and I want to look at the section that is of concern to me and to the opposition. Let's go to page 8 of the bill. Page 8 of the bill, Mr. President. Subsection 3 of clause 4, I believe, Mr. President. And that says the following. The Attorney General may, by order, subject to affirmative resolution of Parliament, amend the list of offences referred to in subsection 2. And when you go to subsection 2, Mr. President, you are seeing a list of offences under this particular piece of legislation. Fraud, proceeds of crime, misbehavior in public office, perverting the course of justice, anti-terrorism, anti-gang, trafficking in persons, and the list goes on. Integrity in public life, the public procurement. Mr. President, all of these offenses are criminal and indictable. We have a lawmaking body called the Parliament. If the government wishes to add offenses to the list, bring a piece of legislation to the Parliament and allow us to debate it. Because when you come with a resolution, even though it is affirmative, Mr. President, the government has the majority. So the ayes have it at the end of the day. But we are not prepared to allow the Attorney General to insert himself on this particular matter that is supposed to be properly either before the Parliament of Trinidad and Tobago properly as a substantive bill, or maybe you can think about another way, but I don't know about any other way except the Parliament as a lawmaking body. So we reject completely this provision in the bill that addresses that issue. Now, Mr. President, go to the section called negative resolution, and that deals with, that's on page 16, and that is 78, I'm seeing you. And it reads, the Attorney General may make regulations subject to negative resolution of the Parliament to give effect to the purposes of the Act, of this Act. But there's a Rules Committee in the Supreme Court of the Judicature that also has a responsibility for rule making. At least the Chief Justice is the chairman of that particular agency or Rules Committee. Why not allow the Rules Committee to make those rules? And if you're saying you want to make it, because from a parliamentary point of view, and as the Office of the Attorney General, that is your responsibility, Mr. President, I'm saying, meet with the stakeholders on these rules and don't just bring it to Parliament and then look for a simple majority. So we are saying, if you're going that route, Mr. President, this is an area that requires consultation with the stakeholders, and not only consultation, it requires an affirmative resolution. Mr. President, if you go to clause 5, they say this act does not apply to any indictment for which the trial has not begun under the Criminal Procedure Act. So it is not applicable to any trial that has not begun. Mr. President, if I am in remand for 15 years, I have been charged for a serious indictable offense.
Senator, you have 5 more minutes.
I am in charge for, yes, ma'am, yes, sir. What happens to me when this bill, if it becomes law? I will now be subject to this. But under Section 37 of the Criminal Procedure Act, I am entitled to be tried once I plead not guilty by a judge and jury. But the government is now abolishing that. They are deleting that, Mr. President. And what are they doing? They are replacing it with judge alone. So judge alone is the standard. That is the gold standard that they are putting forward. Mr. President, I know I have a few moments left. But in the few moments I have left, I want to indicate to this honorable House. The Attorney General spoke. He talked about the efficiency of the judge alone trials. 59 of them so far being successful, as far as we were told, if I'm correct. So whilst we are praising the judge alone trials, and we are praising our judges, I am reading in the Newsday newspaper just recently a headline on page 5 entitled, "Judge, Dark Cloud Over Judiciary." Dark cloud over judiciary. So we are here talking about judge alone trial. We are praising our judges. But the executive and the cabinet of Trinidad and Tobago, who are yet to condemn the Minister of National Security, who has done, Mr. President? He told Trinidad and Tobago that the judges of this country have criminals as friends.
Mr. President, 46.
How can?
46.8.
Senator Mark, so members, so a standing order has been raised. Again, Senator Mark, you are well aware of that standing order and how we treat the judiciary. This particular bill speaks to processes within the judiciary as it relates to trial by judge and judge only. You only have a few more minutes, so wrap up.
Mr. President, I am saying you cannot be abolishing trial by judge and jury and saying go judge alone, and you have the cabinet of Trinidad and Tobago attacking the judiciary.
Mr. President, 46.6, please.
So Senator Mark, again, just be mindful of the phrases that you're using and continue towards the end of your contribution.
Thank you, Mr. President. So, Mr. President, I'm very clear in my mind that the United National Congress cannot and will not support this bill in its current form. This government has to withdraw this bill, take it to the garbage heap where it belongs, and if it wants to come with something more appropriate, we are able and we are willing to meet with the government and consult with the government and meet with it. But the bill in its current form, Mr. Vice President, is unacceptable, indefensible, and cannot be supported. The government of Trinidad and Tobago is taking Trinidad and Tobago down a slippery road of tyranny, despotism, and dictatorship. And we will have no part of that arrangement. And in those circumstances, we call on the Attorney General to withdraw this bill and wheel back and come again. You will not be getting our support. And if this bill is passed, I can give you the guarantee it will be challenged in the courts of Trinidad and Tobago. It will be challenged. If you take God out of your thoughts and do not withdraw this bill, it will be challenged in the courts of Trinidad and Tobago. So we call on the government, Mr. President, withdraw this bill and let us preserve trial by judge and jury and allow our peers to judge us. Mr. President, I thank you.
Senator Vera.
Senator Ma, members on both sides, please avoid crosstalk and allow Senator Vera to start his contribution. Senator Ma, you had your time to speak. Thank you.
Senator Vera, SC.
Thank you, Mr. Vice President. Today we are called upon to consider the good, the bad, and the ugly of jury trials, and as an alternative or substitute, the use of judge-alone trials. Now, there is an interesting phenomenon where people complain and cry out for change, but when change comes, they get cold feet. They become mistrustful, and they want to hold on to the old ways. Today, we are faced with a situation of escalating crime, a situation caused in part by a ponderous criminal justice system, a system crying out for change. Now, the right of trial by jury, as you all know, is of ancient heritage. And in Trinidad and Tobago, the Jury Act is over 100 years old, having come into effect in 1922. And the Criminal Procedure Act is also of considerable vintage, having come into effect in 1925. So we have grown up with a tradition of trial by jury, a tradition romanticized, sentimentalized in books and in movies, films such as 12 Angry Men and The Witness for the Prosecution. But unfortunately, that tradition is also partly responsible for some of the delays relating to the trial of serious offenses. Now, don't get me wrong. I am not calling for the abolition of juries, nor is that one of the objectives of this legislation. My own view is that even though there are challenges, and notwithstanding their bad reputation in some quarters where jurors are seen as incompetent, biased, and unpredictable, there is still a place for jury trials. Now, that's one side of the coin. The other side harkens back to a time when some of the greatest trials exhibited the highest standards of advocacy before juries. When I practiced at the criminal bar, there were few things as exhilarating as a jury trial. where the courtroom's intense enclosed theater created unparalleled moments of drama, conflict, and resolution. When one feels a connection with a jury, and you know they're with you, that's the closest thing to a natural high in the legal profession. In jury trials, the jurors listen to the skillful interweaving of testimony, facts, storytelling, and analogy. Oftentimes, you could see the jurors getting swept up in the words of the advocate's arguments. It's in jury trials that lawyers get to be at their most dramatic. Just consider the gladiatorial skills and the legal exploits of the great Marshall Hall, Norman Burkett. And closer home, consider Vernon de Lima, Dana Sitahal, and Justice Gillian Luckey when she was a prosecutor. Advocates who could build and maintain rapport with jurors. It's easy to see how why jury trials have always captured headlines in the press and the imagination of the public. But as we have heard, jury trials can be expensive undertakings, especially when jury sequestration is necessary. Jury trials can be heavy, slow, and time-consuming. And jury trials can be flawed, even abused. In a scholarly article entitled "The Jury Problem," published in volume 37, issue 1 of the Journal of Criminal Law and Criminology in 1946, the author, a judge, Julius Milner, focused on the acquittal of notorious criminals, where the proof clearly indicated their guilt. He bemoans frequent miscarriages of justice because of the lack of ability on the part of the average juror adequately to discharge the duties that devolve upon them in the fact-finding process. Judge Milner considered the practice of dumbing down juries, where any juror who discloses intelligence and competency, or as if we've heard, may look churchy, is promptly excused by the defense. He makes the wry observation that the highest achievement of the defense lawyer in a criminal case with a guilty client rests in his successful effort to confuse and befuddle inexperienced and sentimental jurors with issues entirely foreign to the merits of the case. In Judge Milner's opinion, the best remedy for all this lies in the improvement of the method of selecting persons for jury service. Incidentally, one of the very things that this legislation seeks to do under the provision for lay assessors, among other things, by requiring that they can read, write, and understand the English language, and they have qualifications, experience, or skill in any matter which may be considered at the trial. But even where jurors are qualified to serve as lay assessors, there is still a risk. There is still a risk where jurors may have a culture favorable or unfavorable to one's client, and where jurors can be baffled by the legal techniques and procedures used by skillful lawyers designed to create confusion rather than understanding amongst them. Where, for example, the defense hammers away at reasonable doubt and the presumption of innocence, the exact content of which can never be defined with mathematical accuracy. Now, just as the rain falls on the just and the unjust, it is trite, but nevertheless worth emphasizing, that criminal defense attorneys have a legal, moral obligation to defend the heinous as well as the innocent. And it's also hard for laymen to understand that under our system, it's not the job of defense counsel to get to the truth. Their job is to defend their client. And as long as they're not suborning perjury or hiding evidence, they have every right to try and keep the prosecution from meeting the burden of proof requirements. So by chipping at the law, chipping at procedure, and in presenting emotional arguments, defense counsel are oftentimes able to gain better advantage with a jury than with a judge. But that's the prerogative of defense counsel. They're just doing their job. The solution to the problem doesn't lie in denigrating defense counsel or the presumption of innocence, which is the golden thread of justice under our system, where everyone deserves a defense. The remedy lies in guarding against trial by a jury of incompetence and by ensuring that jurors properly understand their duties and responsibilities. Conversely, the idea that the accused must be dangerous, the accused must be guilty because he wouldn't have been charged in the first place if he wasn't, can be challenging for jurors to understand. And here is where there is a definite advantage in having a judge who understands the presumption of innocence and the burden of proof requirements. So it cuts both ways. Sometimes an accused may be better off electing for a jury trial. And there are times when an accused may stand a better chance going with a judge alone trial, especially in a situation, for example, where there's been a lot of pre-trial publicity, or the nature of the alleged crime arouses public indignation, such as sexual abuse of a child. Another shortcoming in the current jury system, and we've heard a bit about this, is that many of those who are best suited to serve prefer to shirk their civic duty by seeking undeserved exemptions from jury service, not recognizing that when they forego their duty to serve on juries, they also forfeit the right to complain about the crime situation when less than satisfactory verdicts are rendered. Besides the challenge of getting suitable people to serve on juries, there is also the risk of jurors being influenced by outside factors, including, as we have heard from Senator Lachmidial, conversations with other jurors, conversations with friends, reading articles in the press, and posts on social media. Now, it's true, jurors are instructed not to discuss the case with anyone until final deliberations in the jury room. They're advised not to make up their minds until they've heard all the evidence, all of the arguments, all of the judge's instructions. They're supposed to set aside preconceived notions and be guided solely by the law and the evidence in the case. But whether this corresponds to what obtains in practice, I leave as an open question. Further, jurors must not, by their verdict, desire to please anyone or fear to please anyone. Now, it's easy to say that anyone trying to influence a juror's decision, whether by conversation, threat, or bribe, should be reported to the judge promptly. But is it reasonable, is it realistic to suppose that the person who is open to taking a bribe will likely report it? Or that the juror who has been threatened or whose family members are being threatened can rest assured that the state will provide adequate protection, not just during the trial, but afterwards? In such situations, trial by judge alone may be the preferable option in the interest of justice. So our responsibility when considering this legislation is to be alive to the upsides and to the downsides inherent within the jury system and the judge alone option. This bill is about institutional building and strengthening. And it is my hope and belief that it represents a good faith attempt to shore up the criminal justice system, to streamline processes, and to provide a faster and safer alternative using trials by judge alone. This bill does not seek to abolish the use of juries because it implicitly recognizes that where there is a good jury, justice can be well served. That's why the provisions are there. Now, all of us have prejudices, our biases, we have psychological traits, and these can seep into the courtroom unconsciously. So, as we have heard, both Senators Welch and Senators Lachmidial talked about it, there is a real benefit. There is a real benefit where there is a mix of different persons with different backgrounds and different psychological traits interacting in a jury room, counteracting each other's biases and prejudices, sifting the evidence, and bringing their collective wisdom and experience to bear. I wholeheartedly agree. Trial by jury assures a freshness of approach that even the best judges can find difficult to maintain. And juries can bring the standards of the community to play in the matter under consideration. Again, Senators Lachmidial and Welch spoke about this. So the bottom line is that there are both pros and cons in jury trials and judge-alone trials. But whether trial by jury or judge alone, the purpose of the court system is to adjudicate controversies in the calmness and solemnity of the courtroom, according to legal procedures as are necessary for giving effect to the fundamental rights and freedoms enshrined in the Constitution. And that is the trajectory being taken by this legislation. Where, notwithstanding the imperfections which have endured through the years, reform and improvement of the jury system is preferred over abolition. Accordingly, under this legislation, jury trials will remain an important part of the criminal justice process where serious offenses are concerned. However, if an accused wants a jury to consider his case, he must now elect for it expressly. Now, I share similar concerns with Senators Lachmidial and Welch about the additional requirement of the court directing in the interest of justice. My recommendation would be that this phrase be completely deleted from clause 4A1. The section should end, unless he elects to be tried before a judge and jury, full stop. Now, although the bill is entitled Trial by Judge Alone, its scope is wider than the title suggests, in that it reclassifies what would previously have been special juries, it expands the category of persons exempt from serving as jurors, and it requires judges to provide reasons for their decisions. However, as the focus of my contribution is more on the policy questions involving complex and nuanced issues, I don't propose going through the bill clause by clause. Consideration of the minutiae will be dealt with at committee stage. But I can foreshadow a few concerns. First, I share Senator Welch's concern about reducing the number of jurors from 12 to 9 where the death penalty is involved. Now, I have no problem with the number of 9, There are 9 of us on the independent bench. My recommendation would be to do away with the death penalty. It's not being enforced anyway, and that would negate that concern and argument. Secondly, I agree with the recommendation of increasing the number of preemptory challenges from 3 to 5 and doing away with even numbers in favor of odd numbers, because that would avoid the risk of having a hung or divided jury. Thirdly, I like the idea of lay assessors, but I think we need to flesh it out a bit more, and I think further consideration may be necessary. Fourthly, flipping the election by making trial by judge alone as the default position, well, I think that needs to be better justified by the bringers of the motion. For the record, I have no problem with Clause 6C3, which enables the Attorney General, subject to affirmative resolution of Parliament, to amend the list of offences where lay assessors are eligible to serve. Clearly, when new serious offences arise, it is not unreasonable to want to be able to update the law as may be necessary or appropriate. So, for example, we may have new forms of financial offenses, cybercrimes, trafficking in body parts. The Attorney General should be able to amend the section. Given the importance of this legislation and the need for buy-in by the legal profession, buy-in by the public at large, it may be useful for this bill to be interrogated before a select committee. I'm just throwing that out there for consideration. In a nutshell, this legislation seeks to clear court congestion and to remedy some of the failings in our jury system. Undoubtedly, this legislation will alter long-established traditions and procedures in relation to the trial of serious offenses by making single-judge trials a starting point instead of juries, by reducing the size of juries, and by improving the method of selecting jurors for jury service. But these, I think, are necessary. They are good changes which can lead to big results. In closing, I should just like to emphasize that there is nothing in the Constitution which supports the argument that trial without jury is repugnant, unconstitutional, or an affront to the Constitution. The procedures under this legislation are not contrary to fundamental principles of our Constitution. Section 5(2)(e) provides that Parliament may not deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of its rights and obligations. I see nothing in this legislation that will deprive a person of his rights in this regard. Section 5(2)(f) provides that Parliament may not deprive a person charged with a criminal offence of the right to be presumed innocent until proven guilty according to law. Again, as far as I could tell, the presumption of innocence remains intact under this proposed legislation. The section also provides that a person charged with a criminal offence has the right to a fair and public hearing by an independent and impartial tribunal. Yet again, I see nothing in the proposed legislation which abridges or abrogates this right. We have a fair and impartial judiciary. Indeed, our judges are qualified, if not better qualified, as jurors, as juries of lay people. I think a lot of thought and research has gone into this legislation. I believe it offers an opportunity to reduce caseload and delay. I believe it will have an important effect in the administration of justice. And I believe that an improved criminal justice system can and will play an important role in de-escalating the current crime crisis. it is time to recognize that our institutions and systems need to be changed because the existing conditions aren't working as they should. Mr. Vice President, I thank you.
Senator Chapati.
Thank you, Mr. Vice President. Mr. Vice President, I would first like to take the opportunity to thank the Leader of the Opposition and my party, the United National Congress, for giving me the opportunity to present on this very important bill today. Mr. Vice President, the bill before us today, the Miscellaneous Provisions Trial by Jury Alone Bill 2023, this bill seeks to amend the Jury Act, Chapter 553, and the Criminal Procedure Act, Chapter 1202, significant pieces of legislation which touch and concerns the right of the accused. Now, Mr. Vice President, it is noteworthy that most of us in this House may never appear before a jury or before a judge on criminal offenses or capital offenses. At least I would hope not. So we must take into consideration that the people that this bill affects would be the common man, the everyday citizen. And should you find yourself in that position, Mr. Vice President, and you ask yourself the question, would you prefer to be judged by a panel of your peers? The answer to me would always be yes. Now, Mr. Vice President, with the gradual moving away from juries, firstly, the Miscellaneous Provisions Trial by Judge Alone 2017 amendment, and then now this, we see that the direction of our justice system is taking, and with such moves, a right-thinking citizen would expect a wide array of consultations would have taken place prior to this hearing today. And by consultations, I don't mean simply writing a letter and sending it out. We need detailed consultations. I was going to ask the question to the Attorney General. Have the Law Association and the Criminal Bar Association and other interested parties been consulted? And we learned earlier today in the sitting that merely a letter was sent out. Now, I would like to put on the record, Mr. Vice President, a scathing letter from the Law Association of Trinidad and Tobago dated 12 May 2023, addressing the Miscellaneous Provisions Trial by Judge Alone Bill. Now, Mr. Vice President, there are several elements of the bill that the Law Association found issue with, and that I share with that concern. The reduction in the number of jurors was one of the issues they looked at, and the fact that it may have an adverse effect on the fairness of deliberation. It is a basic, they looked at the statutory interpretation of the legislation. They looked at what constitutes experience in administration of justice, qualifications or skill, as it relates to lay assessors. I would ask and urge every single member of this upper house to have a read of this letter. I know it's dated today, but it's available online, I believe. Have a read of this letter prior to deciding which way you would vote on this bill. Mr. Vice President, I could only hope that the level of consultations was more significant than the alleged silk discussions that took place with the Law Association and has been dismissed as untrue by their media release 9th of May 2023. It is abundantly clear that by the media releases of the Law Association and the Criminal Bar Association that one of my colleagues will address in a few moments, there is no support for the bill. When the government brings bills of this magnitude especially, those affecting the judiciary and the administration of justice, I immediately am on high alert. And the reason why, it wasn't always like this, Mr. Vice President. The actions or inactions over the last 8 years have sown a seed of distrust. And I simply have no confidence in the way that the government does things anymore. Mr. Vice President, today we are asked to move one step further towards the eventual abolition of juries, a point raised in the letter by the Law Association as well. But what faith has the government shown to the judiciary in recent times? It is noteworthy that the reckless, dangerous, and termination-worthy attack on the judiciary by the Minister of National Security, Fitzgerald Hines, attracted heavy criticism.
And also 53B, repetition.
Senator, 2 points of order have been raised.
Mr. Vice President, if I could be afforded a moment to title.
Proceed with questions.
Thank you. You see, Mr. Vice President, I know it's a touchy subject, but the importance of it is we are being asked today, and the public is being asked today, to put more faith in the judiciary. And I want to ask the question today, does the government have faith in the judiciary? So respectfully, Mr. Vice President, the point is very relevant to this debate and to the national landscape at this point in time. Mr. Vice President, going further, in the recently held CARICOM Crime Symposium held at the Hyatt, which the cost seems to be rising higher than our murder rate by the day, regional leaders attacked judicial officers on their supposed soft approach on crime. This is also relevant to the debate today. There's a narrative brewing, and it's a dangerous one in our society, Mr. Vice President. It wasn't that long ago that the Prime Minister, on platforms across the country, made suggestive comments about members of the judiciary. This reckless and dangerous attack, Mr. Vice President, on the judiciary and the constant...
46.6, please, and 46.8.
Senator, the matter of 46.6, as it applies to implying improper motives, I ask you to err on the side of caution of how you wish to express your view today.
I'm guided, Mr. Vice President. Thank you. Mr. Vice President, these things are in the public domain, and the record is there. Mr. President, it is on public record the government's interaction with the Office of the DPP, the Office of the Commissioner, the attacks on the judiciary, and the list goes on. What about the doctrine of separation of powers? I would like to ask the Honorable Attorney General, Senior Counsel, I would ask other members of this House to remember, as attorneys, we swore on oath to uphold the Constitution, to protect our democracy, and to protect our judicial officers from unwarranted attacks. And Mr. Vice President, while the politics of the day may chew us out and spit us out at some point, we must always have honor, and we must always act in accordance with the oath that we swore to the people of Trinidad and Tobago. Mr. Vice President, during this process, as I mentioned previously, the unsuspecting public, for the most part, have no idea what is happening with this bill. They rely on us as guardians, to be their guardians, so that the day they are arrested and charged, due process is afforded to them. Fairness is afforded to them. The opportunity to be heard without bias is offered to them. And in such a case, we must always tread carefully on important matters such as these. Now, Mr. Vice President, going into the bill, the amendments to the Jury Act, it is important to know where we came from. And jury trials have been around since roughly the 11th century, under the reign of Henry II. Mr. Vice President, it's noteworthy that this would have happened at a time when the monarchy would have determined liability, guilt, and everything else under the sun, and the need for an impartial, rather more equitable process was required. That is, one man or one woman, albeit royal, had the decision, the power, to decide on someone's fate. I see a similar parallel being drawn right now. Mr. Vice President, over the years and the development of the common law, There have been many advocates for a trial by jury system, including law lords who sat on numerous cases with judges. Some of those would be the revered opinions of Lord Halsbury and Lord Salmon in the courts of the United Kingdom. And since the landmark case of Windsor in 1866, there's been significant development of the common law. And the general cornerstone, Mr. Vice President, has been that judges determine law and juries determine fact. We all know this. This raises a further conflicting role, in my opinion, of lay assessors, which I will discuss as we go further. One of the features, Mr. Vice President, of the jury system has also been the proverbial line in the sand, preventing judges from seeking to usurp the function of a jury by seeking to persuade them to his point of view in relation to the credibility of witnesses or that of the accused. That has always been something that has been frowned upon. This bill also seeks to remove the category of special jurors, which I know several members would have spoken about. And this is a point that the Law Association in their release also seems to disagree with. I also share that sentiment. Additionally, Mr. Vice President, noteworthy, a point under the Jury Act amendments would be the reduction of the jury size from 12 to 9 under Section 19(1) of the current law, and from 9 to 6 for all offences outside of murder and treason, which currently is Section 19(2). Mr. Vice President, the 12-person jury is a tradition that traces back to 1066, the year of 1066 when William the Conqueror brought the practice of trial by jury in civil and criminal cases to England. This is how long this has been the tradition. By 1500s, jurors no longer decided cases based on their own knowledge, but based on information they received in court. Over time, jury service in England came to be viewed as the most representative institution available to the English people. Mr. Vice President, it is noteworthy that throughout the evolution of the English civil jury, the traditional number of jurors held constant at 12. In fact, legal luminary William Blackstone summarized the importance of trials by 12 jurors in his commentaries. A competent number of sensible, upright jurymen chosen by lot from among those of middle rank will be found to be the best investigators of truth and the surest guardians of public justice. For the most powerful individual in the state will be cautious of committing any flagrant invasion of another's right when he knows that the fact of his oppression must be examined and decided by 12 indifferent men. Mr. Vice President, going further, I would like to quote a study that was done on the efficacy of larger juries. A case study was done by Duke University in the United States, and it is titled Better by the Dozen, Bringing Back the 12-Person Jury. And it examined the efficacy of smaller juries. Now, Mr. Vice President, it's noteworthy that in the United States, they have jury trials for civil matters as well. So what this study demonstrated, Mr. Vice President, is historically, the origins of jury trials started at 12, and due to a Supreme Court decision in Williams and Florida, 1973, which is also incidentally quoted in the Law Association research, their letter, that the court saw no loss of functionality and therefore no reason to prevent states from pursuing cost savings many claimed smaller juries would deliver. However, despite the best efforts of the Supreme Court to defend this, the average jury composition in the US across state lines ranges from 6 to 8, and the results are alarming. This is the study. Mr. Vice President, as a leading jury expert, Professor Hans Zeisel showed, the items the court cited in defense of smaller juries were not empirical studies, but rather conclusory statements by authors, supported at best by limited experience and anecdote. Now, Mr. Vice President, the fact remains that larger juries are more predictable and less likely to render outlier awards as seen in the US system. 6-person juries are 4 times more likely to return extremely high or low damage awards compared to the average. If a juror has an extreme view on damages, that view can pull the group's award in that direction. The smaller the jury, the greater the force of a single juror's pull, and the greater the chance that the juror will return an outlier award on both high and low ends. In contrast, damage awards by larger juries are more likely to cluster towards the middle range of awards. If you apply this to criminal cases, there is more predictability and stability in the verdicts of larger juries. Mr. Vice President, larger juries aren't just more predictable. They likely make better decisions. Social science shows that many kinds of decision tasks, the larger a workable decision-making group, the better the decisions will be because of the increased resources more group members provide. As members said earlier, if 6 heads are better than 1, then 12 are in most respects better than 6 or 8, or 9 in our case here. Larger juries recall evidence more accurately, recall more probative information, and rely less on conclusory statements and non-probative evidence. Mr. Vice President, additionally, larger juries tend to be more inclusive and more representative of the society, which is really a key feature in jury trials in itself, a trial before your peers. Mr. Vice President, we all know the difficulties in pulling juries together due to the large list of exempted persons, which seems to be even wider than our regional counterparts. In my research, I realized that our list for exemptions is quite wider than some of our CARICOM neighbors. And in some jurisdictions, fines are actually applied where persons frivolously shirk their civil duty. Is it that we need to look at our jury pools, perhaps look at the exemptions to the jury pool and first fix that element instead? Mr. Vice President, moving along to the Criminal Procedure Act amendments. Now, Mr. Vice President, Section 4 of the Miscellaneous Provisions Bill seeks to amend Section 6 of the Criminal Procedure Act. Firstly, what jumps out at me is the inclusion of judicial discretion in allowing a person to opt for jury trial. In every sense, the current 2017 bill is more adequate than this bill before us today. Mr. Vice President, as I mentioned earlier, it is a gradual distancing from jury trials, and I respectfully submit that the people should retain that choice. Let us not force our citizens one way or the other. Let the system allow for an accused person to have the choice based on legal advice. Let justice not only be done, but seen to be done, a maxim that we have all heard before, emanating from our and Sussex magistrates, the ex parte McCarthy case. Mr. Vice President, when examining the 2017 legislation, the trial by judge amendment, and comparing it to the bill before us, it almost seems as though we went from judge and jury to judge only, and then now back to judge and jury, but at the judge's discretion. It seems as though we are spinning in mud. With a gradual goal of abolition of jury trials, that seems to be our trajectory. Mr. Vice President, the 2017 amendment added the option of judge-only trials, but upon the request of the accused. Now we have gone further and seek to force judge-only trials by leaving the discretion to the judge. I came across some research, Mr. Vice President. In September of 2021, the Caribbean Association of Judicial Officers met. A panel including judges from the Caribbean Court of Justice, Jamaica, Bermuda, Guyana, Cayman Islands, and our very own Justice Carla Brown-Antoine from Trinidad and Tobago, to examine judge-alone trials. Views from the bench, that was what the title was. With 100 participants, Mr. Vice President, the discussion entailed a wider implementation of judge-alone trials, with 72% strongly agreeing, 22% agreeing, 6% being neutral, and none against. Mr. Vice President, I put it to this House today. Given the overwhelming sentiment, the stresses of jury selection, the management and securing a jury during the course of trial, would a judge really opt for a jury trial? With almost 94% opting for judge-alone trials. And these are judicial officers, Mr. Vice President. Mr. Vice President, moving over to the position of lay assessors, who have been included to sit in on indictable offenses outside of those punishable by death, and more so with reference to offenses including fraud, misbehavior in public office, human trafficking, financial crime, etc. The introduction of lay assessors to try cases along with professional judges as a right to have the public participate, not the right to be tried by one's peers. Mr. Vice President, I want to ask the Attorney General today, what research has been done with regard to the success of lay assessors? Have we actually seen a successful system? Because I submit today, Mr. Vice President, my research has suggested that China, one of the largest countries in the world, they have implemented this lay assessor system since the early 2000s. And the lay assessor system, as they say, plays a weak and almost non-existent role in their judicial system. Even when they have differing opinions, judges often try to convince them with their own knowledge. This happens even when lay assessors are a majority on the panel. And Mr. Vice President, I heard murmurs when I mentioned China. But the reality is, when you look at France, Germany, they're called Skoffen in Germany, lay jurists. Even Russia, the Soviet Union. The research suggests that lay assessors have been always convinced by judges, which means that what is the actual purpose that they bring to the table? What benefit will we achieve in our justice system? And I would like to ask the Attorney General, maybe in his wind-up, maybe he has some research that says otherwise, but I would really like to know, where have we seen this succeed, and what is the benefit that our people will derive from this? You know, Mr. Vice President, going back to China, you know, it's a common assessment of the lay assessor system. They say, in China, they say they are the heirs of the deaf, like furniture or decoration. Their impact to me sometimes is reminiscent of the performance of this government. Mr. Vice President, a new Section D would provide, under the Criminal Procedure Act, would provide the criteria for lay assessors, which is identical to the qualifications to be a juror, save and except for the experience or qualification in the administration of justice, or possess skills relevant to trials. Now, Mr. Vice President, the Law Association has also spoken about that. So like I said, I would urge everyone to take a read of that. When we looked at the history of juries, Mr. Vice President, it has been well rooted in law that juries adjudicate on matters of fact, whereas judges adjudicate on law. What is the actual relevance or need for lay assessors when their only advantage seems to be legal? Part of the rationale for non-legal persons sitting on juries to begin with would have been so that their view or perspective on the case would not be guided by law and legal principle, but rather factual circumstances. Mr. Vice President, I also note the fact that under this proposed law, the court may appoint at least one lay successor, but no more than 5 lay assessors. In what circumstances would necessitate a decision of 1, 2, 3, 4, or maybe 5? What would determine the need of situations when this becomes relevant? Are we just leaving it up in the air? Mr. Vice President, a new Section 6E would also provide disqualification criteria, which is parallel to the disqualification criteria of juries. 6F lists those exempt, and again, it's a quite wide array of persons, even wider than those exempt from jury duty. This is arguably an issue faced in recruiting appropriate jurors as is. Why make the same mistake twice? Why not just fix the criteria for jurors instead of adding a whole new criteria of judicial support? Mr. Vice President, under proposed 6H2 of this bill, a lay assessor can take an oath and be a member of the court, but the judge reserves the right in the interest of justice to allow him to hear evidence, to participate, and to decide on questions of law, questions of fact, or in some cases, if the judge can just sit alone. So, Mr. Vice President, you can go through the entire process of getting a lay assessor, only for a judge to sit and say, I don't need you, I'll do it by myself. So what is really the point, given to the fact that a judge, the law says a judge shall not be bound to conform to the opinion of a lay assessor, as laid out in 6I, number 2. So are we saying that the lay assessor is important, but not really important to the process? Mr. Vice President, the funding of lay assessors shall be charged on the consolidated fund. To me, is this really worth the time and effort and expense? Can't we find other ways to improve our criminal justice system? We just recently saw in the other place $3.4 billion of a financial supplement. Are we hiring more staff and judges? Are we training more persons? Are we bettering the staff at the DPP's office? Are we hiring investigators? Are we training experts in the field? These things will improve our criminal justice system, not this bill, Mr. Vice President. Mr. Vice President, I also strongly disagree with Section 77 and the Attorney General's making of regulations subject to negative resolution. I also note the fact that the Attorney General put the list of offences under affirmative resolution, and I think those matters need to be brought before the court, as the simple majority would obviously rule in a case like that. Now, Mr. Vice President, in winding up, I would like to say that the 2017 the existing law before us is adequate. What we need to do to fix the criminal justice system, we need to provide the resources. We need to maintain our faith and confidence in the judiciary, and our public sentiments must also reflect that, because it is the people who are listening to us, they are the ones who rely on that criminal justice system. Mr. Vice President, I submit that in looking at this bill, it is very difficult to find ways to support it. And Mr. Vice President, in closing, I would like to say that I recommend to the Honorable Attorney General and to members of the government to remember the reason why you're doing this. What is the mischief in society you are attempting to achieve? And I honestly do not see this piece of legislation improving anything. With those words, Mr. Vice President, I thank you.
Senator Hazel Thompson, aye.
Thank you, Mr. Vice President, for this opportunity to speak on this bill. Plus ça change. The more things change, the more they remain the same. Most people, including lawyers like myself, may not be au courant with the history of jury trials. I myself, having studied the English legal system so many moons ago, had forgotten that up until 2 centuries ago, trial by jury was a normal procedure in both criminal and civil trials in England. I had to scrounge around in my home library for my copy of the English legal system by Walker and Walker to recall Lord Camden's words. Trial by jury is indeed the foundation of our free constitution. Take that away, and the whole fabric will soon molder into dust. It was Walker and Walker, too, that reminded me that Lord Camden's view of trial by jury being sacrosanct has been eroded over the years. Radical changes have been effected to the earlier widespread use of jury trials, to the rules regarding eligibility, excusal, disqualification, and even the composition of juries, which Lord Devlin had described in his book, Jury Trials, as being predominantly male, middle-aged, middle-minded, and middle class. In the olden days, if you were young, poor, and female, chances of your serving on a jury were beyond the pale. Where property and race were aligned, if you were of a darker hue, poor you. Your chance of serving on a jury was akin to that of a snowball surviving in hell. Today, jury trials are used in the UK in a limited number of criminal and civil cases, but are the norm in our serious criminal cases. Then came the pandemic, with its concomitant restrictions on in-person trials. This heightened the debate on the need for review of our criminal justice system. I say heightened because judge-only trials had entered into our criminal justice system, as in so many jurisdictions, in pre-pandemic times. In 2017, we passed the Miscellaneous Provisions Trial by Judge Alone Act, which entered into force on February 1, 2019. Today, we debate the Miscellaneous Provisions Trial by Judge Alone Bill 2023. Its stated purpose is to amend the Jury Act, Chapter 653, and the Criminal Procedure Act, Chapter 1202, and for related purposes. The bill has 5 clauses. Do good things come in small packages? Clause 1 of the bill gives the short title of the act, the Miscellaneous Provisions Trial by Judge Alone Act 2023, while Clause 2 provides for its commencement, namely on such date as is fixed by the President by proclamation. Nothing controversial in these 2 initial clauses. Clause 3 has more meat in the payload of amendments to the Jury Act. Clause 3A amends Section 2 of that act by repealing the definition of special juror. It is rather circumlocutory, as it then refers you to Section 29. As gleaned from Section 29, special jurors constitute a special jury struck before the marshal in any case triable by jury except indictments for any offense punishable with death, and in particular, in any case concerning complex fraud, offenses under the Proceeds of Crime Act, financing of terrorism, and offenses under Part A of the Securities Act. Clause 3B amends Section 7 of the Act by deleting the words magistrates and their clerks and substituting the words judicial officers referred to in the second schedule to the Judicial and Legal Services Act and their clerks. Clause 3B2 is expunged as is captured by the change to Section 7.1. Clause 3C and 3B deletes the reference to the spouse of magistrate or his clerk who may be excused from jury service and delineates such person as spouse of judicial officer or clerk as referred to in the second schedule to the Judicial and Legal Services Act. It is noteworthy that these changes are being made because at times the legislature fails to recognize that consequential changes need to be made if it is affected by an earlier change effected in another place. Clause 3C also amends Section 7A of the Jury Act. It provides that persons who are qualified to be jurors to be excused from jury service if he or she is the spouse of certain categories of persons, including an attorney at law or his clerk. Now that sounds simple enough, but it can be challenging. I suggest that once someone in that category has indicated unwillingness to serve, that person be taken off the list. I once wrote a letter after letter on behalf of my spouse who was repeatedly being called for jury service. Finally, I wrote the registrar that he was the spouse of an attorney at law, me, and unless and until our marriage was dissolved by death or divorce, which will be on the 12th of never, he must not be summoned again. He went to court. He gave the letter to the clerk and was called into the judge's private chambers to be told he was excused. He was puzzled as to why that was not announced in open court as was the usual practice. As he was leaving the court, an official whispered to him, the judge wanted to see who was Mr. Ahi. Our judges are so human. Fortunately, we regard them as special and do not treat them as some other jurisdictions do. At the recent Commonwealth Law Conference in Goa, India, international jurists were surprised, and I dare say jealous to learn our judges are relieved from paying taxes and do not come under the purview of the Integrity Commission. Clause 3D repeals Section 8, which outlined the required qualification and experience for special jurors. Since special jurors are no longer a feature of our legal landscape, it's a logical change. Clause 3E, which strikes out the reference to special jurors, is so well worded that I must specially congratulate the draftsman. I feel it's a draft woman, though. I hope you observe I do not only share both for bad grammar and poor language construction, but I give congratulations when they are due. Clause 3F repeals Section 11.2, which refers to special jurors. Clause 3G amends Section 15.2 for the same reason, and the same applies to Clause 3H, which amends Section 18.1. Clause 3I, 1 and 2 effect a substantial change to our criminal law as it pertains to numbers of members on a jury. It amends Section 19 by deleting the words 12 jurors and substituting the words 9 jurors, and in subsection 2 by deleting the words 9 jurors and substituting the words 6 jurors. Lizzie Dearden, the independent paper house Affairs correspondent reported on January 26, 2021, that legal associations had accused the Labour government of undermining the ancient and fundamental right of jury trial with proposal to cut the number of jurors to combat a growing backlog of court cases. They felt the right to be judged by 12 jurors should not be undermined during the pandemic. David Lammy, the Shadow Justice Secretary, called for the government to temporarily allow panels of 7 people rather than the current 12 to decide innocent or guilt in trials. The chair of the Criminal Bar Association, James Mulholland, said reducing jury numbers would be a convenient way to avoid the proper solution of investing in more courtrooms. We must retain faith in the processes that have made our criminal justice system one of the fairest in the world. The backlog was not a basis for dismantling of an institution which determines who we are and for what we stand as a society. He said the findings of the Lammy Review into the treatment of Black and minority people in the justice system found juries essential to preventing discrimination. In times of increasing inequality, we need to protect our jury system, he said. Legal Director Jody Blackstock told Independent, "We have 12 jurors because it's a number which reflects a good discussion. It enables any biases to be balanced and meted out." Derek Sweden QC, chair of the Bar Council, said more Nightingale courts and staff were needed, but changes to the jury should be a last resort. He continued, "It is the collective life experience and diversity of members of a jury that ensures evidence is tested robustly and the public can be confident justice is delivered fairly. Reducing the size of juries risks diluting that experience and denting confidence in our justice system." The Bar Council of the UK published an article on July 10, 2020, titled, "How Will Restricting Trial and Reducing Jury Numbers Affect the Delivery of Justice?" And it revealed the Law Commission of Canada consulted on juries and considered reducing the number from 12, but concluded that the development of the jury had resulted in its size being workable, manageable, and able to discharge its functions, and it was decided that the jury should continue to be 12, as those who would reduce the jury size from 12 had failed to prove it would increase effectiveness or efficiency of trials. The author found that studies in America and Scotland reached the same conclusion, namely that when it comes to juries, size does matter, that a 12-member jury was likely to be more representative of the society it serves and therefore have available a wider range of experience and judgment in terms of age, gender, race, and culture with which to evaluate the evidence. I, therefore, do not agree that we should reduce the size of our juries. Clauses 3, J, K, and L, and M seek to repeal Section 29 to 35, and in the schedule insofar as they deal with or make reference to special juries. Section 29 was discussed earlier. Section 30 provided that special juries were to consist of 9 jurors whose verdict was to be taken, as in the case of a common jury, to be selected, and Section 31, which instructs the marshal regarding the preparation of the list of special juries, and also 33 to Section 35, all of which refer to special jurors. Clause 3, by limiting special jurors, paves the way for the entry of a new creature of statute, lay assessors. More of that anon. Clause 4 seeks to amend Section 6 of the Criminal Procedure Act. Section 6 originally read, "Every person committed for trial shall be tried on an indictment, and subject to the provisions of this Act, every such trial shall be held by and before judge and jury." This was amended by the miscellaneous provision Trial by Judge Alone Act 2017 to read, "Every person against whom an indictment has been filed shall, subject to the provision of this Act, be tried by a judge and jury unless he elects to be tried by a judge alone." The amendment seeks to repeal the above and substitute the following subsection. A person against whom an indictment had been filed, it will read, shall, subject to the provision of this Act, be tried by judge alone unless he elects to be tried before a judge and jury and the court so directs in the interest of justice. And I agree with what has been said before about reversing the trend of things that we had before, and we should in fact, keep what we had in the 2017 legislation. Notwithstanding subsection 1, it says a person against whom an indictment has been filed may be tried by a judge and lay assessors to be appointed in accordance with section 6C if the court considers it necessary in the interest of justice. So by repealing subsection 2 and substituting the following subsection, subject to subsection 1, at the first hearing after the indictment has been filed, a judge shall inform the accused person that he may elect to be tried by a judge and jury unless the accused person indicates an intention to enter a plea of guilty. And in subsection 4, by deleting the words "a judge" alone wherever they occur and substituting the words "a judge and jury." But there is no indication about lay assessors and whether there's a choice, if you can choose, if you can object to any lay assessors. I think that more work should be done into this legislation. So in subsection 5, you delete the word "a judge" alone wherever they occur and substitute the words "a judge and jury." Subsection 6, deleting a word "a judge" alone whenever and substituting the words "a judge and jury." By repealing subsection 7, you substitute the following subsection: where the court makes an order under subsection 4 or 5, the accused person may subsequently apply to the court for a trial by a judge alone, or where the first hearing after the filing of an indictment against an accused person took place before the coming into force of miscellaneous provision trial by judge alone, Act 2023. The registrar of the Supreme Court shall cause to be served on the accused person and notice informing him that he may at least 60 days before the date fixed for his trial apply to the court for a trial by a judge and jury, and subject to subsection 8, apply to the court for a trial. The accused person may, subject to subsection 8, apply to the court for a trial by judge and jury, and you repeal subsection 9b and substitute: the court shall, subject to subsection 4 and 5, make an order that the accused be tried by a judge and jury. Now, lay assessors, the legislation explains who are the lay assessors, and as I said before, it's their discretion to refuse to be tried by lay assessors. It says the High Court may respect of any indictable offense except an offense punishable with death, in particular indictable offense, and it tells you the list involving fraud, proceeds of crime act, misbehavior in public office, perverting the cause of justice, Anti-Terrorism Act offenses, Anti-Gang Act, Trafficking in Persons Act, and so on, and economic sanctions, and it goes on and on. You've heard it before from other speakers. And the fact that the Attorney General may, by order, subject to affirmative resolution, amend the list of offenses referred to in subsection 2. And it gives who are going to be lay assessors, and maybe we need to look at that and see if there's something that we need to do. So the question of judge alone is nothing that is particularly new all over the world. Australia, South Australia has had it since 1984. And it says, provides an accused request and prior to the time set for his trial, and he must have obtained legal advice. And I would suggest that this provision of legal advice be actually written into our law and see how it's going to be provided. Maybe through the legal aid and advisory authority, if he doesn't have a lawyer before the trial comes up, because sometimes a lot of time is spent waiting to get a lawyer and so on, and sometimes they're trying to see if they have to commit a crime to be able to pay the lawyer. So if it is that we can assist by people getting that advice, it will be very helpful. So there have been pros and cons. Many things have been written about the pros and cons of the jury trial, whether one is better than the next, what are the results, disadvantages like lack of diversity and limited review in scope if you have the judge doing it, no protection against abuse of power, no limited accountability. And in terms of the judge alone, you say there's more privacy, less expensive, there's more fairness. So judge alone, there have been, a number of people saying, yes, it is better that the system be used. But in both cases, you have had problems. Sometimes you have a judge and jury, and there's a perverse verdict. And we remember that some years ago, one of our judges was so infuriated with a not guilty verdict in a murder case that he banned the jury for 15 years because he found it was such a perverse verdict. And We've had instances where judges have made pronouncements and it has aroused a lot of ire in the population. There was a case some years ago where the judge gave a light sentence to a young man who had raped a young girl, and the Trinidad public was so incensed that I counted 80 letters and comments on the issue in our press. 80 letters, and that prompted the Honorable Chief Justice of Trinidad and Tobago at the time, Chief Justice Michael de Lavasi, to reveal that the issue of sentencing was one of the matters to be addressed at the forthcoming judicial retreat. Now the jury is still out at a session led by former head of the appeal court in Jamaica, Justice Dennis Morrison, Court of Appeal judge and head in president in Turks and Caicos. He made the point in the lecture he was delivering by Impact Justice that when we're talking about abolishing jury trials, we have to bear in mind that we are talking about something that has existed for a very long time and has been revered in very many contexts. But the overriding consideration, he said, for any criminal trial must be that it's not only fair, but also seem to be fair. Jury trial has traditionally achieved this goal by ensuring public participation in the system of criminal justice and thereby broadening the basis of adjudication. To that extent, its cardinal virtues remain unimpaired by the passage of time. A jury trial is therefore likely to remain a significant feature of the Commonwealth Caribbean criminal justice landscape, certainly in relation to the most serious offenses of murder and treason. But in everything that we do, I would like to advocate that there be a system of continuing education. We have had a number of instances where we have looked at studies all over the world, and we realize that judicial bias, gender bias, is something that is very real. It makes no sense burying your head in the sand and thinking that because you have a trial by judge, it's going to be something that is dispassionate. They are not swayed as a jury by all of what's out there in the public domain. But a number of studies have shown that gender bias is something that we need to overcome. And there has been some training in the judiciary, and a number of sessions have been held, a number of training sessions, but it needs to be ongoing. It needs to be ongoing so that people become aware of the biases and try to overcome them. Because that makes for lack of confidence in the judicial system. Recently, Ira Mathur had to write, as on 23rd of April 2023, about one of the judgments in the court. And that was a judge-alone trial, where the judge said that the person temporarily lost his self-control. And in fact, he stabbed his wife 18 times. And the judge said stabbing her, it made his behavior reasonable, excused him from murder, and it downgraded to accidental manslaughter. And she was killed, you know, and it leaves a bad taste in people's mouths, you know, and the feelings. So we really need to work more on getting a better justice system. There are pros and cons to both judge-alone trial and also the jury system. But if we are to get buy-in in this legislation, it means that there's some work to be done, some more work to be done, and the suggestion that was put forward earlier of sending it to a joint select committee, I believe it's a good one. I don't think we're ready yet to try and bring this into the public domain. Thank you, Mr. President.
Senator Varamadi Singh.
Thank you, Mr. Vice President, for allowing me to partake in this discussion today. I heard various reasons proffered for change. I heard members of the opposition, members from the government side, and also esteemed members from our independent bench, noted attorneys also giving their opinion. I heard also there are factors why we may want to do these changes that we would want to make to, in the criminal, the Jury Act and the Criminal Procedures Act, changes that would somehow give us a cost factor, a saving, and also give us the time factor, the expediency in hearing cases. And we all know that our system, our judicial system, our whole process of getting someone when they commit a crime to get them in the system to face trial, it takes a lot of time. And again, this goes against the grain that, that persons say that justice delayed is justice denied. So therefore, that whole concept, anything to quicken the pace of justice is something I would have, try to see how could we move to help that system, because there are persons out there, victims out there, who would be noting that there were persons who would be out there who would have committed crimes, heinous crimes, and some in jail, and now with the some murderers allowed to get bail, some may be outside. So certainly we need to do better, and the expediency is something. So changes occurred in 2017 where the judge alone trials were legislated for, and in that instance we looked at a new concept, moving away from the 12 jury member trials to cases where there was judge alone. And I think Justice Gillian Locke was the first judge who actually partook in one of those trials. And we had cases, I think it was either 47 or 49, I think heard mention from the year 2017 to now. And I heard the advantage of having that, especially when we had the incidents of the pandemic, and it was more challenging to get persons together. So it did benefit us during the pandemic years. So I look at the balance. The balance would be, really speaking, looking at three issues: the cost, one, the speed of having trials, and then the democratic principles involved, because I've been hearing that trial by peer is a more democratic procedure to go rather than the judge alone. So looking at the cost, again, I have heard Senator Sagram Singh's comments where she said the ripple effect occurs when a member has to come to study, to leave, to go pick up their children from school. Again, we have the levels of productivity. Persons have to leave their jobs to go and serve this service. And again, if there is a cost factor involved in terms of the productivity, persons leaving their jobs, having to hire babysitters, definitely even the cost factor of here and feeding the members of the jury, sequestering them, all these things are factors that I'm looking at in our financial times, that we have difficult financial times. We have to look at this balance, look at the cost factor. So cost factor is something, one way I'm leading to say, hey, this may be beneficial. Then I look at the time factor. So I already mentioned justice delayed is justice denied, and the atrocities of the long wait in persons having to wait, it's something that we need to improve. But I heard Senator Welsh, who is a practitioner of the courts, bring up the point that the delay is really in the build-up of the case, and not after the trial, not after the jury or the trial has started. So this again is a significant factor, because if the delay is really the pre-trial, it means that we have no choice to try to see that if we could speed up this, The previous AG did promise us more courts and more judges, which we got, more masters, and he has to be praised for that. And he has to be praised for that delivery. But again, we have to look at other factors. We have to look at staffing for the DPP, who will have to institute this proceedings. We have to look at equipment for police, tools for the police to go and investigate cases, to get things going, to come to court sometimes, and it might be challenging for them if they don't have vehicles. So in the sense of speeding up the court cases, I know it takes some time to get the jury together, but I also took note of Senator Welch's announcement that it is really not after the jury has been chosen. So therefore, I must say, for a long time, we need to improve that, but we may do it without having the factor of not having a jury, 12-member jury or just judge alone. I looked at the case of democracy. I heard members say there will be an erosion of rights. And Senator Welch, again, did say it sticks out as a sore thumb, this piece of legislation, if passed. His language, strong words, a new radical position. And, so we have to figure, would persons feel deprived if justice is not allowed, in a sense, to choose their manner, either judge alone or to just have trial by their peers? So this is something, would a person feel aggrieved that I am not getting justice if there is, it's forced upon me and not a choice that is given by my attorney weighing the pros and the cons? So therefore, I think in terms of persons being cynical of the judicial system, this it's a cost we may have to pay for maintaining the democracy. It's a matter of choice for the person to choose. And I know that exists now, so I would, in a sense, be hesitant to remove that choice if it comes to this. So let's look at the judge-alone trials now, because this is something that we're looking at. So if I heard it that a judge alone sitting may not be maybe from a privileged background. He may have his priority bus pass, he may be from a certain area, he may not know what's going on in society, living among the common man, living among persons who would have been very experienced in the conditions, who may know why did a man reach that level to commit a crime, or who may feel empathy with the victims because they are also the community that is under siege. So there's a benefit of persons actually sitting and taking part of this process, this part of process which occurred before. So persons who may think that the members of the jury may not be smart enough have to realize they are judging mainly on facts, and they have done it for years. And even if we looked at the fact that we are saying that a judge-alone trial, which is something that we have to look at, magistrates sometimes, they sit alone. So therefore, you have a magistrate sitting alone who may be hearing certain matters, and he may determine if those matters could go on to the High Court or just be dismissed. So it already exists in the lower court. So I've seen that. But there were cases, and there were cases, I remembered, right here mentioned in this chamber, where it was made mention that a magistrate had freed someone in a case where that persons were allegedly dealing with drugs. And after that, persons out there in the community did make some sort of objection, and the DPP himself had to say he found that strange and had to object. So even if a magistrate is sitting alone or a judge sitting alone, and I heard Senators Ahi's comment about a recent judgment where someone accused for rape got released, and because of that, it also caused some concern, should a judge sit alone? So therefore, a judge sitting alone, we have heard, maybe not in tandem with the community. They may have, people may look at the those judicial officers as having friends in certain places, and that can go both ways. And I want to bring up this point because there is a perception, Mr. President, that let's say you may assume a judge is sitting in a case and the prisoner gets away and people make an allegation that that person may be friendly with the judge. It can swing the other way. If I come through this system and I am a junior attorney in the DPP's office, and I know the hardships in the DPP office, and I'm now sitting as a judge, would I have a sort of biasness towards the prosecution team or towards the DPP? Now, I'm not saying the judiciary would have that, but the judiciary themselves had a retreat in Tobago about 3 years ago where they looked at ingrained bias or bias among judges. And psychologists attended and they actually give their opinion about some judges there, how they can move away from this bias that could occur. And it brought to the point too that if a judge has the ability to say, you know, I am not allowing a trial by jury, because, you know, let's say the defendant comes and says, I want a trial by jury, it gives a message that I don't trust you, judge, so I want a trial by jury. So the judge may feel a bit, you know, angry, the judge may have a certain biases, and the judge may, you know, people may say, would the judge now in his deliberation be somehow controlled by these thoughts? But we can get around that. We can get around that. I think that if let's say you have a judge, there were precedents stated in the past where the Chief Justice came down and sat in the High Court with judges. So if you're looking at the fact that one judge sitting alone may be influenced, that's one way we could solve it, where the Chief Justice could come and sit in any court he wants, and you may have two minds meeting in that deliberation. Or if you want trial by judge alone, who knows, the future may evolve in such a way that it will be 2 or 3 High Court judges also sit on matters, which is again trial by judges, and any decision there would be better, but could now go to the appeal court if it's, you know, a challenge further. So there are ways where the law could evolve if it causes some disquiet later on. So I was clear before that in my my announcements in the Senate that I support the death penalty. Now, I support the death penalty provided there's good DNA backup, there's good CCTV cameras, there's good eyewitness. So you have a more complete situation where if you're going to put somebody in death row, you would feel more satisfied that all the evidence is there, because sometimes eyewitness evidence may not be that reliable. But if we have this, and we still have the death penalty on the law books, let us say a judge now is going to hear a case. Sometimes that judge may be a bit, you know, a bit laid back, pushed back in this sense, because he may not want to say that he's the one sentencing him to death. He may rather hide behind the cloak of a jury making that decision. So sometimes the judge themselves may think differently if at the end of a judge trial he said, well, I'm sentencing you to death. You may have that deliberations and sentencing people to the death penalty may be coming to question. I feel more comfortable too where you have the 12 persons are involved in the process. So you would have that greater input that was mentioned before. I must say, Mr. President, the trial by jury, and I heard Senator Ahi made a very nice comment when she says size matters, and you know, so size do matter, in the sense that how are we to know if the 12 is better than 9? How would we know if why not 5? Why not 6? How did we come to this? And historically, we would have realized that if we are going to question the jury size, we would have to get an idea, why did it come to 12? And you see, there's a reason why we have 12 persons, because the Welsh king, Morgan of Gia Morgan, established jury trials in 725 AD, decided upon the number linking the judge and jury to Jesus and the 12 apostles. Why are we tied into a Christian concept? We may have to say, why 12? Why not 11? Why not 9? So this is something we have to look at the science behind it. And Senator Vera did mention something about mathematics. And I have an article I want to quote with your permission, sir. The mathematics of jury size. It is a statistical model which shows several interesting properties of the US jury configuration. It was done in 2012. It was by Gress Gorsick. So they looked at the fact that could different jury sizes improve the quality of justice? This is what they were looking at. And they were looking to identify potential ways they could improve. And even in the states, some states, United States, some areas like Florida and Connecticut, they actually started to use smaller juries, and smaller juries of 6 or 9 persons. And however, in 1978, the Supreme Court ruled that a 5-person jury is not allowed after Georgia attempted to assign 5-person juries to certain criminal trials. So to the mathematician, to the scientists, they didn't, they couldn't swallow that division. Where do we take 5? Where do we take 6? Where do we take 9? Where do we take 12? And there's a mathematician called Jeff Suzuki, who is from Brooklyn College in New York. He actually did that study. And he presented this research. And he found that the model suggested that smaller juries are more likely than larger juries to convict when the defendant appears less certain to be guilty. All the juries he modeled are very likely to convict when evidence suggests that the defendant is almost certainly guilty. But for slightly less certain cases, differences become clear. And he found, if it appears that there is an 80% likelihood that the defendant is guilty, then Suzuki's model suggested that less than 10% of the 12-person jury would unanimously vote to convict. But a 6-person jury would unanimously vote to convict over 25% of the time. And when he looked at the 9-member jury, he said it would be 60% of the time. So therefore, size, in fact, does matter. He also looked at the concept of the judge alone trials, where he, in a separate study, they analyzed surveys completed by judges before juries delivered their verdict, and comprised what the judges taught to the jury's decision. So they're looking at the decisions juries made and what the judge said before and what he taught after. And it was finding that the verdicts agreed in about 80% of the time. And he found that in about 1 in every 5 trials in his study sample, the judge and the jury came to different conclusions. So no system is perfect. No system is perfect. The debate still goes on, but at least of the conviction rate according to the size of the juries, the judge's concept of who should be guilty, and what. So those are matters out there. And so I'm hearing, the 12 jury members, we shouldn't touch that. That gives a greater degree of ability to know what's happening in the community. But you see, if we are looking at the juries, and some of the criticism was juries may have the pre-trial publicity. The juries also may be threatened because you are living in a small community. You may have certain criminals who may be able to know where you live, where your children live. And you see, those are problems of the jury tampering to influence maybe something that one will say, let's move to a judge alone. But you see, we could move beyond that. We are now talking about CARICOM. Why can't we get members of CARICOM states to come here and to sit in certain crimes that you have, you're judging facts, that you are having these persons come here, so there's less likelihood of persons being able to damage their families, less likelihood of those persons having that fear of that criminal, less likelihood of pre-trial publicity. And so this is something we have to look in the future where we may be able to tap in to our nationals in the CARICOM to come and serve here to give us a fairer system. So again, what would I look again to see how am I making this decision? When I'm making my decision how to vote here, I also want to see not just what is said in these chambers with all these brilliant minds, but I also want to see what does independent opinions outside say. Now, recently our country had a debate on who got silk and who didn't get silk. I must congratulate my colleague, Senator Vera, right? So, congratulations. Yeah. And I am told that it is the senior, I hope you don't think I'm saying you're old, senior persons in the profession, more stable collective members of the bar who obtained this honor. So, when I looked at the Law Association of Trinidad and Tobago, now headed by a recent silk recipient, Mrs. Lynette Sibaran-Sweet, Senior Counsel. When I looked at the Criminal Bar Association, headed by Israel Khan, Senior Counsel, I have to take their level of the opinions that they give me with some grain of salt, because here we are bestowing that honor upon them as clear thinkers, studying law, studying fields. And both these organizations admonish this piece of legislation coming here today, both of them. So right away, even though I may have my own reasons, my own biases, why I may want to go into certain cases, I listen. And I listen also to what the independents, silk recipients who had certain organizations who got the input had to say. And I'm thinking that if these persons had reservations, I may also be tempted to say that I would have to I would like to go in further to see what is their reservations, what is their opinion, what is the fact that what they would want to come out of this, because they are the independent minds out there, sometimes divorced from politics, who can give a clearer picture sometimes what's going on. So in conclusion, I think we basically have to realize that we have to do better in terms of the timing of trials. But I'm saying we have other ways to do that. I'm saying the cost factor is there. We may have to pay a price for democracy. And I'm saying that the fact is, I think that the trial by jury should still be a choice. It should still be a choice, not just of the individual who's going to face that music, to let him feel that, listen, this system that is going to judge me is something I had a choice, and this is what I think is the fairest way. And I think that choice should still be left to them. I humbly suggest a Joint Select Committee to be given a chance with stakeholders to look further into this and to give us, a more reasonable time to study this before we come up with another bill. Thank you.
Senator Bisram Singh.
It is my privilege to be here, and I am grateful for the invitation that was extended to me. I am not here this afternoon to be a jurist, to reiterate the importance of our jury system and the civic duties of jurors. I am not here either to provide any statistics and make comparisons with other jurisdictions. I am here today as a practicing criminal attorney. I have had the privilege and opportunity to practice in the Magistrates' Court, in the High Court, doing both jury trials and judge-alone trials. And I would like to start by the first point with consultation. The Honorable AG indicated that letters were sent to the Law Association, to the Criminal Bar Association for their feedback on this bill, please. And today we have both the Law Association and the Criminal Bar Association responding, indicating their displeasure in this bill. If you are ill, you go to a doctor for a diagnosis. And sometimes you would go to a GP to get a referral to go to see a specialist. If you have a toothache, you would go to see a dentist. You're not going to go by a lecturer or a teacher. Similarly, these are persons who are in the criminal justice system. And we have both the Law Association and the Criminal Bar Association indicating that this bill they are not in support of, they are not in agreement with. In the past, legislation was brought to speed up the criminal justice system. However, the very opposite was achieved. We implemented legislation that did away with preliminary inquiries. Why was that done? Same considerations. Too much time being wasted, a backlog of cases is costing too much money. So previously, in a preliminary inquiry, you would have witnesses come into court, giving their evidence in a matter, and then being cross-examined. When the new legislation was passed, what that did, it did away with the witnesses coming to court to give their evidence. So before, you would have a witness being in court for 6 hours, maybe 2 hours in evidence in chief, and being cross-examined for 4 hours. The legislation that was passed tried to reduce that. Too much time being wasted in court. There's a backlog of cases. So what was done? The introduction of paper committals. So what we have now, rather than the witnesses coming to court to give their evidence in chief, their evidence would have been by sworn statements. So they only come into court to be cross-examined. That sounds nice. It sounds like a reduction in time. But that is not what is happening today in our criminal justice system. What has to happen today in our courts is that the police has to go locate these witnesses, have to get them to swear to their statements. That has to be done before a justice of the peace. Then those statements are given to a prosecutor at the DPP's department. Then and only then is the defense given those statements. So before, when you would have a preliminary inquiry taking about 2 or 3 months to finish, we have now extended the period of time in which these matters are being done. Because now you have, for preliminary inquiry, from the time the person is charged and brought to court, a disclosure is not given to the defense right away. We have to wait an upward time of 5 months before we are in possession of these statements. So we try to cut down the time of these witnesses in court by a little 2 hours, and now we are left waiting 5 months, upward of 5 months, to get statements in this matter. That does not make any sense. Similarly, with the implementation of granting bail for murder accused, That was a very good piece of legislation. However, just yesterday, I had a matter before the court for an application for bail for a murder accused. This application was filed in March of 2023. The matter came up for the very first time yesterday. And that matter has been adjourned to September. So we're introducing things, we're introducing legislation with the intent to speed up everything, to deal with the backlog, but there's a disconnect because in reality, in practice, that is not how it works. The reason why these matters are taking so long is because of the limited manpower. We have, yes, we can now apply for bail for murder accused, hoping to reduce the population of the remand prisoners, hoping to speed up things. However, the prosecution, the DPP's department, is severely understaffed. We have 2 or 3 prosecutors to deal with these hundreds of applications for bail so that they are not getting the time to do it. Biosocial reports are being ordered by the court, but because of the backlog of that, the limited resources of that, it is not being done in time. There is a disconnect. Similarly, the plea bargaining, great initiative. However, a response, when you write to the DPP's department to start or initiate a talk with respect to a plea, you get a reply in months. Sometimes you are there waiting 4 or 5 months to get a response from the DPP, and I am not blaming DPP.
Thank you very much. Mr. President, on a point of order, 46.1, there's no bail or plea discussions.
So, Senator, on the point of order 46.1, which speaks to relevance, I am listening to what you're saying, and as much as you've just started your contribution, what we do in this chamber is you need to connect it to what is before us. What is before us is specifically dealing with the trial by judge versus trial by jury and the amendments as proposed to the 2 acts that are before us. What I'm hearing you doing is trying to make a connection between some of the arguments put forward by senators before us and indicating based in other procedures as it relates to the judiciary how that may connect. Problem is that you are skirting relevance when you do that. So I would ask you to tie it back specifically to what is before us, which is why that standing order was raised.
I am so guided. The relevance is this. The aim or purpose of this bill is an intention to expedite the criminal justice system. This bill is not going to expedite the criminal justice system. The backlog has to be dealt with. The problems that contribute to the major delay in the criminal justice system needs to be addressed. And it is not with implementing judge-alone trials. When judge-alone trials started in 2019, the COVID pandemic saved it in the sense that jury trials were suspended. So accused persons had no choice but to agree to do it if they wanted to have a hearing. And in the statistics that were provided, whether it be 49 judge-alone trials that were done or the 59 judge-alone trials, we need to get the statistics with how many of those matters were appealed. I personally know of 2 matters which were appealed, and an appeal in a sense would take even longer. So is it that these judge-alone trials are really working? In a jury trial, you have the HDC House. They have different experiences from us, the common men, and that is why they are so integral to our society. And if it is that the numbers are reduced, the 12 is reduced to 9, the 9 is reduced to 6. I heard the Honorable Senator Vieira talking about the risk of jurors being influenced. Yes, there is a risk of jurors being influenced. But don't you think the larger the number, the less that risk will be, or that risk will be mitigated because you may have biases and prejudices canceling each other. Now, the Honorable Senator Sagram Singh was saying that there is a cost attached to getting jurors here, but we have not been presented with any cost. I don't know that our taxpayers' money is paying for babysitters for jurors. I don't know about that. I have not had the experience in the last 9 years of my practice where there were any late-night deliberations by any court, so that is not even a factor in considering the expense. What needs to be done is to address what is causing the real backlog in the criminal justice system. Implementing this judge-alone trial is at the very end. You need to come up with things for crime detection, crime prevention, staffing the DPP's office. Not only just introducing more magistrates, introducing more judges, because if you appoint more judges and you appoint more magistrates, you still have the issue, not enough prosecutors. We still have the issue. Why is it that indictments take so long to file? Persons are in custody for at least 3 years minimum before their indictment is filed. So I don't see how this bill introducing judge-alone trial and making that the norm, how that would expedite the criminal justice system. The number presented to us was 59 matters from 2019 to now. But 59 out of how much? How much persons are in remand for murder? They don't want it. They don't want it. This bill does not seek to address the issue, and this bill would fail at expediting the criminal justice system because it does not address the real issues at heart. Mr. President, I thank you.
Senator Timal.
Mr. President, whilst I welcome the opportunity to contribute to this debate on the bill before us, I must admit I entered this debate with some degree of temerity because, references have been made to the question of the subtleties and the intricacies of this bill, and the need for particularly reflection from legally trained minds. But lay assessors is based on the entire principle of laypersons being engaged in the justice system. And for the purposes of this debate, it seems as though I would be speaking from that base of being a lay assessor. And the first thing I want to mention is when Senator Lakshmi Dayal started her contribution, she spoke about the fact that we were not afforded the opportunity until early this morning to have access or to see the Consolidated Act. And as a layperson, preparing for this debate with the limited time that we were given, you had to jostle between 3 and 4 pieces of legislation, trying to piece together what could have been the time to piece together what could have been substantially reduced if we had access to that, the Consolidated Act, even though it was an unofficial Consolidated Act. And I found that it placed me in particular at a serious disadvantage. Mr. President, the bill before us, in my opinion, it leads to the erosion of lay adjudication and limits, the whole process of community involvement, of lay involvement by the average person, the average citizen in the judicial process. And it impinges on the democracy that is within the justice system that calls for engagement of laypersons. I would like to go straight to Section 3I of the bill, in which Section 19 of the Jury Act is being amended. And a lot of senators before me spoke about this, in that essentially for murder and treason, it's the reduction of 12 jurors to 9 jurors, and then for other criminal matters, reduction from 9 jurors to 6 jurors. Now, of course, the question came up about the rationale for this reduction. And we have heard several senators in their contributions speak about the numbers and why 9, and size matters when it comes to juries and all of these things. And I did appreciate the attempts of Senator Sagram Singh Suklal to bring some rationale, to bring an explanation to us with regards to this reduction. And what I was getting is that, one, there's difficulty in getting jurors. It's a real problem, and the courts do face a lot of problems in getting jurors. The availability and the suitability and the efforts involved in arriving at the 12 jurors or the 9 jurors as is presently required, even though the number may sound a bit small, could be quite an onerous task, according to the Honorable Senator. And then a lot of our contribution dealt with the rationale of cost for the reduction. And yes, it's a reality. It is a reality in the difficult economic times that costs should be a consideration in all matters that come up before us. But what I would like to ask is cost. Should it be a primary reason in this particular matter, or really and truly, should it be a secondary reason? Because when it comes to justice, particularly when we are dealing with people's lives, the highest being crime being punishable by death, whether cost should be such a deciding factor, should be a rationale for the reduction that is being proposed here. And I would humbly submit that cost really should be a secondary matter when it comes to fairness and fairness of trial and maintaining a democratic principle in our justice system. And I would ask the question, if these are the problems grappling the selection of jurors or getting jurors, why have we not looked in any in-depth way of reforming the system of getting jurors? How we go about selecting jurors to start with? You know, what reforms are possible to address some of the problems that were outlined? What reforms? And I would have certainly liked to hear, you know, what attempts, if any, have been made with regards to how we can tackle that problem without having to resort to reduction in the number of jurors. Section 3J talks about or outlines repealing sections 29 to 33 of the Jury Act, which essentially deals with special juries. And the Honorable Attorney General, in his contribution, did say that special juries were never used. But I would have liked to hear from our Honorable Attorney General as to why. Because it was never used, but then why? Because we are looking at repealing special juries, and the reasons why it was never used. Was it just bad legislation? Was it legislation that was divorced from reality, and it was just an exercise in futility? Was it that the judiciary found it almost impossible to implement that legislation, which is why we're looking at abolishing the legislation? And it leads naturally to the question that I would ask. It would seem that if the objective of the bill before us is to move to judge-alone trials, then are we not facing a similar situation with the provision of the option of lay assessors, where lay assessors would suffer the same fate as special jurors? What is going to make the difference that what we are putting, or what we are being asked to put into legislation today is not going to suffer the same fate as special jurors? Because when I look at the provisions of clauses 29 to 33 with regards to special jurors, it was really along similar lines for lay assessors that is outlined in this bill. So what is the particular differences that is going to ensure that the system of lay assessors is going to be utilized effectively and going to be utilized, if at all, in order to address the challenges that we have in the justice system at this time? Of course, a lot of senators have spoken about Section 4A1, AI1, and about where it said the court so directs in the interest of justice. And I would share the views that have been expressed by so many before me. And it's a question of, although constitutional rights not being eroded, but it's a question of fairness, and whether or not this allows for a fair trial, and whether the flipping of this, the wording here, as from the 2019 provisions, whether or not, as Senator Vera mentioned in his contribution, we need to revert back. And I am in agreement with his proposal that we just remove and the court so direct in the interest of justice. Mr. President, just on a point of note, what I note in Section 19, of course, with the reduction in jurors, is that when I look at the Jury Act itself, in Section 19(3) of the Jury Act, there is a clause there in which it says, where in the course of a trial, any member of the jury dies or is discharged by court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members is not reduced by more than one, be considered for all the purposes of the trial properly constituted. It goes on to say, where one juror has died or has been discharged, as aforesaid, the verdict of 11 jurors in a trial for murder or treason, or of 8 jurors in a trial for any other offense, shall be deemed to be an unanimous verdict of the jury. Honorable Attorney General, based on what is being proposed here in Section 3I, I think there has to be a corresponding change in Section 19.3 of the Jury Act, where those numbers have to be adjusted to reflect what is being proposed in this current legislation before us. On a similar vein, Clause 28.1 of the Jury Act also refers to some numbers. And if I may just say that, where it speaks about verdict of 7 jurors and verdict of 6 jurors. And in a similar vein, if the number of jurors being proposed are reduced, I think that the numbers in clause 20, in section 28.1 of the Jury Act, that 7 and that 6 would also have to be looked at and may have to be amended to be consistent with the changes that are being proposed here. Mr. President, I'd like to go to clause 6C that deals with the appointment of lay assessors. It has been found in several jurisdictions that when lay assessors are experts and possess knowledge, training, and experience in the particular subject matter of the indictable offense, then they will all ask questions and relate a lot more to the case being heard. Thus, the selection of lay assessors is crucial. Now, the Act repeals Section 29 to 33 of the Jury Act, and Sections 31 to 32 of the Jury Act deals specifically with the role of the Marshal of the Court in the selection and appointment of special jurors. Mr. President, I would have liked to see at least a similar framework that is there in Sections 29 to 33 of the Jury Act that is being repealed. I would have liked to see at least a similar framework, if not just a skeletal framework, in the bill before us that legislates a framework for selection and appointment, rather than leaving it up to the Rules Committee. But it is actually built into the legislation, so at least from a parliamentary level, there is some degree of guidance, there is some degree of legislation to guide the selection and appointment of special jurors as per the intent that was provided for special jurors in the Jury Act. Now, Section 6D, the qualifications of a lay assessor give the criteria for selection only, but there is no mention of the procedure and methodology to be followed. It is not in the legislation itself. Now, I acknowledge that Section 6L allows for the Rules Committee to generally regulate lay assessors, and in particular to provide for the selection, the appointment, qualification, exemption, and training of lay assessors. But despite this, I would have preferred to see, as I said, a framework, at least a minimal framework, for this to actually be in the legislation as a parliamentary responsibility to inform the Rules Committee accordingly as it was done for special jurors in the Jury Act. Now, Section 6F deals with exceptions and lists persons who are exempted from being lay assessors. And I ask the question, should we also include for persons holding substantive positions in political parties? Should they be included here as well? And I won't go into the reasons for what I'm proposing there or what I'm asking because of the obvious connotations of, political involvement of persons who hold executive positions or substantive positions in political parties and being appointed as lay assessors. Mr. Vice President, I'd like to go to section 6D2, in which we are looking at the number of lay assessors. And the court, it says the court may appoint at least one lay assessor, but more than 5 lay assessors. Again, the question is asked, just as in terms of the reduction of jurors, the proposal to reduce jurors, how have we come up with these numbers? And I ask the question, why only one? Should it be a minimum of 2? What is the rationale? Most jurisdictions, from what I have researched during the short time that we have had for preparation, using lay assessors, they have more than one lay assessor as the minimum. And maybe the Honorable AG could shed some light on the rationale for the selection of these numbers. And Mr. Vice President, my contribution is going to be a bit brief, but I'd like to go to section 6H1 in the role of lay assessors. Now, section 2A and B does not offer the lay assessor the opportunity to decide on the factual and legal issues in conjunction with the judge. There is no collaboration with regards to this. It is not done in conjunction with the judge. But the way the legislation is drafted, it seems to indicate that only the judge has the authority to determine questions of law and fact or evidence in the interest of justice as per the opinion of the judge. Mr. President, I submit that the mixed court would only work best when lay assessors actively and meaningfully participate, and the presiding judge has a key role to play in facilitating active participation by key assessors. And this may not always be the case. The judge has to be proactive in assuring that active participation by lay assessors is possible in that tribunal. For I ask the questions, would lay assessors be allowed to examine the evidence and question witnesses and defendants, whether directly or indirectly through the judge? Would lay assessors be allowed access to the case file to familiarize themselves with the case in hand? What happens when the verdict of the lay assessors are different to the judge? Does the verdict of the judge dominate over those of the lay assessors? Or does the verdict has to be a unanimous verdict? Or does the verdict of the judge trump everything that the lay assessors have to say? Would lay assessors have inputs in sentencing? Or is that the domain and the sole domain of the judge? And then also, would lay assessors also be engaged by the appeal court? Mr. President, I cannot help but reflect on the lack of information coming out from this debate about the extent of consultation that was done among stakeholders. Now, the Honorable AG did mention about consultations, like with the Law Association and other bodies, but then at the same time, we have heard from other senators, that the extent of consultation may not have been that extensive and may not have been, and the results of that consultation may not have been influential to the extent necessary in the drafting of this legislation. And this is why, I am asking these questions. If that lay assessors are going to be in a similar situation in a tribunal, because the way that this legislation is drafted, the lay assessors seem to be essentially just expert witnesses. And why do we have to go to the step of lay assessors when primarily their role is that of an expert witness? Is it that we are arrogating onto the lay assessors a role that they can't really fully, the potential can be fully realized in a trial? And they are going to be restricted, they are going to be curtailed solely by the judge who sits in and determines in the interest of justice what inputs that the lay assessors are going to have. I think it's a very gray area, Mr. President. And really and truly, I'm not sure, well, we don't have the workings of the Rules Committee in terms of the entire setting up of the selection and the training of lay assessors. But I would think that if the lay assessors have to be involved in definitely an appreciation of the legal aspects, they have to be involved in learning to appreciate the evidence under the Evidence Act, being able to come to terms with that. Then the training needs, and also if they are to be involved in some extent in determining of sentencing, the training needs definitely have to extend beyond just being an expert witness. And leaving that up fully to the Rules Committee, I am not so keen on that. I think that there has to be some in the legislation, built in the legislation, some clarity as to the, some further clarity, I should say, as to the role of lay assessors and how it is that the court itself is going, how the judiciary itself is going to ensure that lay assessors have meaningful inputs to ensure a democratic justice system in our country. Now, it is understandable that there will be concern about the ability of lay assessors to grasp complicated legal and evidential issues. There's no doubt about it. In addition, they will face obstacles in accessing the full array of information that will be available to the judge. And also the challenge of having to overcome the judge's control of the hearing and deliberation process. And I am of the view that what is before us does not really address these concerns. And I trust that the Rules Committee would take these into consideration in the framing of the rules that is mentioned in Section 6L. Mr. President, 6L refers to the Rules Committee. But I guess in the context of what we are describing, what we are looking at in this legislation, we are referring to the Rules Committee established by the Supreme Court of the Judicature Act. And I am of the view it should be specified that the Rules Committee should be specified as the Rules Committee established by the Supreme Court of the Judicature Act in the legislation, as per Section 77(1) of the Criminal Procedure Act. Mr. President, based on all I have said before about the framework, a legislative framework, about the role of the lay assessor, to guide the lay assessor, and to guide the court, I am of the view that instead of negative resolution of Parliament when it comes to the Rule Committee, that we should be looking at the affirmative resolution of Parliament in this case. Mr. President, Clause 78, Section 78, also states that the Attorney General can make regulations subject to negative resolution of Parliament to give effect to the purposes of this Act. And I just ask the simple question. We have the Rules Committee of the Supreme Court, and then we have the AG making regulations. From a lay person's point of view, I am querying why the need for both, and whether the Rules Committee of the Supreme Court is sufficient, rather than we legislate for also the AG giving regulations. And maybe in wrapping up, if it's worthy of consideration, the Honorable Attorney General can maybe proffer a reasoning for that. Mr. President, as I close, I'll just like to briefly reflect on one of the points that was raised for the justification of this legislation, and that is the question of the cleaning up of the backlog. Now, it's a fact. We do have a huge backlog of cases, and any attempt to clear up this backlog has to be looked at seriously. But I heard my colleague, Senator Welch, speak eloquently about the many steps before we reach the actual selection of jury and trial. And the point that he made, that a lot of the delays and a lot of time is spent getting to that stage, which contributes significantly to the backlog and to the huge population we have at the remand yard. And yes, I agree with the need to reduce the backlog, but do we do so for the sake of expediency, where we risk the question of fairness of trial? And I ask the question, what about the other means to reduce the backlog? More effective and timely prosecutions, prison reform, systemic judicial reform, and have we ever considered the whole issue of plea bargaining as an option? Because to me, the whole question of the reduction of the backlog has to be a multi-pronged approach rather than laying emphasis on this particular legislation. Although that may not have been the intention, but definitively, I think there are so many other aspects of the justice system that has to be addressed, including the whole question of prison and prison reform, that we have to be looking at all of it in a more comprehensive and holistic manner. Mr. President, I thank you for the opportunity.
Minister of Tourism, Culture and the Arts.
I thank you very much, Mr. President, for giving me the opportunity to contribute to this bill, a bill before us which seeks to improve the process flow in the criminal justice system for trials on indictment. And it seeks to improve the case flow by again amending the Criminal Procedure Act and the Jury Act. Now, the two main clauses in the bill, Mr. President, and returning to the bill, the two main clauses, Clause 4, Clause 3. I'll treat with Clause 4. The amendments to the Criminal Procedure Act seeks to put into effect, essentially, a change in the default position for trial of accused persons on indictable offenses to be by judge alone, the default position being by judge alone. And secondly, it introduces the concept of lay assessors, which is a new type of adjudicator, legal adjudicator in our legal system, to sit alongside a judge, to assist the judge during the trial. And then Clause 3, Mr. President. The bill seeks to amend the Jury Act by the elimination of the class of juror known as special jurors, and of course to reduce the number of jurors for trials on indictment punishable by death from 12 to 9, and for other cases tried on indictment from 9 to 6. Now, before I go into the merits of the bill, I would respond to some of the arguments put forward by the opposition bench and some of the arguments put forward by Senator Welch of the independent bench. It is true, Mr. President, that jury trials have a significant and important place in our criminal justice system and in our jurisprudence. It is true. It is also true that there are several advantages, and Senator Lachmidial spoke about some of those advantages. The common man and allowing an accused person to be tried by a jury of his peers who are the triers of fact in that trial. It is true. But it is also true, Mr. President, that there are several disadvantages to jury trials that have been spoken about in our jurisdiction and across the world. And we have not heard about those today. We've heard a lot about the other jurisdictions. We've heard about a lot of studies from all over the world, but not a lot has been said about our own experience here in Trinidad and Tobago. For example, we speak about the jury system and the jury trial. But with very complex financial crimes, crimes involving money laundering, crimes involving tax evasion, does the common man really have an understanding of those very specialist areas in our criminal justice system? With respect to counter-terrorist finances and the offenses that go along with that, does the average man who traverses the East-West corridor, do they understand the facts, the methods, the means by which persons in our society who are inimical to our society commit those crimes? And not just the crimes, the conspiracies around those very complex fraud matters, those very complex and esoteric areas. They don't. Mr. President, you would see on social media persons going around the country and the common man is being asked some very, very simple information. And if you can take that as a gauge, the common man simply does not understand many of the matters that are put before a case for trial on indictment that can be very complex. And what happens matters that are put before it, for which they must be the trier of fact. For a lack of understanding, would they not find a reasonable doubt? Or is it not reasonable to believe that they would find a reasonable doubt simply because they do not understand the areas that are before them? Let us be real. There are complex matters. We always talk about white-collar crime. We know the Piarco case has been within the system for quite a long time. Perhaps one of the reasons for that would be for the very complex matters that are involved in that case. There are very complex matters. Who in here knows, and I only know it from TV, but in terms of terrorists, the financing of terrorists and terrorism, that people use these PlayStation games to communicate so that they're not tracked or traced by law enforcement. Who inside of here understands the world of Bitcoin and these new currencies and how easily money can be laundered or payment and value can be extracted in the world of crime? A very good example can be exhibited here today, Mr. President. We have before us a specific area of criminal law. I am no criminal lawyer. I've never practiced in the criminal courts. And every time there is an area to be debated inside of here, somebody gets sick on the opposition bench, and there are persons who come in who are specialists in that area. That alone is justification that there are specialist areas that need special persons with the qualifications, skills, and experience to treat with those matters. Senator Welch said, why are we reducing the number of jurors from 12 to 9? Why are we reducing this number from 12 to 9? And I am thinking in my own contemplation, and Mr. President, I do not mean to be facetious. Well, if the matter is so grave, where the punishment is death, why not 50 jurors? Why not 60 jurors? Why not contemplate a system where we have 12 jurors in the court and we have a number at home or sequestered in a room who are able to vote by their phones? What is the magic number with 12? But Mr. Vice President, a lot has been said about the Law Association's letter. So let me quote from the only correspondence from the Law Association that I have before me. Well, I recently got it. I didn't get a time to check it. But I understand that the Law Association was asked to provide an opinion by Senator Mark. I don't know if that is true, and it was provided to Senator Mark.
I categorically deny that. I never asked.
Senator Mark, so hold on, one second, Senator Mark. Are you asking the member to give way? Member?
I will not give him way. I'm just stating what my understanding was.
Members. Senator Mark, have a seat. Senator Mark, have a seat. There's a simple procedure. We've been doing it for the entire day. You ask to give way. It's either the member accepts to allow you to speak or he doesn't. In this instance, he has indicated that he does not. Are you raising on a particular point of order then?
5-6, he's imputing improper motives to me. and I'm asking you to rule accordingly.
Okay, so member, he's raised a standing order of 45-6. Just be careful about what you say and continue.
Thank you very much. I'm usually called the Minister of Standing Orders, but Mr. President, if you reflect upon the standing orders, there is no 45-6 that relates to the objection that the senator raised. However, I am simply stating it is an understanding that I have, because I have had to be shared. I have received the comments of the Law Association of Trinidad and Tobago from colleagues on both sides. I did not receive it. Senator Mark had it. Now, I am quoting from the Law Association's comments and recommendations on the resumption of jury trials, and this, for the attention of Senator Mark, is dated the 21st of May, 2020. And here's what they say, specifically with the reduction. And I quote on page 4, "There is no magic in the number 12 or 9, as the case may be, although there is research which suggests that the greater the number of persons who deliberate, then the greater the likelihood that a correct decision will be arrived at." But, Mr. President, having done a little bit in the area of organizational behavior, you also know that the larger the number of group, there is also the potential for groupthink. There is also the potential for bullying. There is the potential to derail the entire work of the group. So there are arguments both ways, but I am instructed that there is no magic number in 12 or 9. It goes on to say, however, by way of identifying an optimum number of jurors, it is worth noting that the United States Supreme Court has determined that the right to trial by jury, which is enshrined in the U.S. Constitution, would not be guaranteed by a jury consisting of less than 6 persons. So, with that, Mr. President, there is no issue if we take as persuasive, not authoritative, but certainly persuasive, the studies and the judgment of the United States Supreme Court. 6 is a minimum number. So I see no magic in keeping the 12 or the 9. Senator Welch also went on to say that accused persons have been choosing judge alone, and I think Senator Bisram Singh also made the point. Accused persons have been choosing judge alone because of the COVID-19 pandemic. Of course, a big assumption, putting yourselves in the minds of accused persons that the only reason why they chose judge alone was because of the COVID-19 pandemic. And the Attorney General has just advised that this year alone, 19 accused persons elected for judge-alone trials. But if we are allowed in here, or if Senator Welch is allowed in here to make that very big assumption, well then why not equally assume that following the pandemic, the COVID-19 pandemic, which involved the spread of infectious diseases, the COVID-19 pandemic has changed the way we live our lives and the way we will live our lives forever. And why not make the assumption and accept that the COVID-19 pandemic would now render persons who, had it not been for the pandemic, and who would have served on a jury prior to 2020 now feel, well, listen here, I don't want to be clustered up in a room with 12 people, you know. I don't want to be so close to people, you know. I don't know what they have. Because following the COVID-19, we then got monkeypox. Of course, happily, both are, congratulations to the Minister and the Ministry of Health, both are behind us today. But why not assume that those persons are now not willing to serve on a jury and to be clustered and to be within these small confined spaces with 12 persons who they do not know, whose health background, health history, they do not know. And having regard to the court's coercive power to summon jurors, the court is now under a heavy, massive duty of care to ensure that these persons are safe. But does our facilities contain mechanisms to keep persons safe, to keep persons distanced from each other so that there is no spread of diseases, etc., to satisfy these jurors that they do not have to stay in very close quarters with their colleagues, with their fellow jurors? We don't. And I have heard today, and I have heard repeatedly today, which contradicts some of the presentations coming on previous bills. How is it all of a sudden, Mr. President, all of a sudden, that we are now sensitive and alert to judges being biased and prejudiced? How is it all of a sudden that we are terrified and afraid of a judge using a discretion that is centuries old in the interests of justice? All of a sudden, we are terrified and afraid of judges using their discretion without accepting that there are safeguards if the judge errs in the usage of that discretion. You have an appeal to the appeal court. You have an appeal to the Privy Council. But all of a sudden, we are terrified about it. Mr. President, I'll move to this section 4. Because it does seem to cause serious consternation with colleagues opposite. So in section 4, we're amending section 6 by changing the default position. So where a person against whom an indictment has been filed shall, subject to the provisions, be tried by a judge alone unless he elects to be tried before a judge and jury, and the court so directs in the interest of justice. Mr. President, personally, I have no issue with this. It leaves the opportunity for an accused person to elect to be tried before a judge and jury. And I reject Senator Vieira's contention that we should stop at the word jury and put a full stop. I reject that. We're not taking away anybody's rights. There is no right to trial by jury, and you said that in your contribution, through you, Mr. President, to Senator Mark, you said that in your contribution, And you have misled this whole parliament. Come on, we are speaking to the people of Trinidad and Tobago. There is a right to a fair hearing before an independent tribunal, and I am not here to have any discussion with you at this time. But, Mr. President, let me tell you,
I allowed just a little bit the back and forth, but now it's becoming a tad bit too much. Please allow the member to continue his contribution.
I thank you for your protection, Mr. President. Mr. President, we need to understand and put ourselves in our own jurisprudential context, what goes on in this place. The default position is that you will be tried by a judge alone, unless you elect to be tried by a judge and jury. The effect of Senator Vera's amendment or proposed amendment to this section means if somebody is charged on indictment and is brought before the court, he pleads not guilty, but he is charged for conspiracy, for money laundering, some very complex financial crime, the Mossack Fonseca type financial crime, then in that case, he has to go before a jury of his peers, the common man, on the priority bus route. Who on the priority bus route understands, Mr. President, before 2015, I didn't understand what were bearer certificates and people going around with these bearer certificates and getting dividends and being able to launder money easily. I didn't know the scale of these shell accounts across the world and how persons, mind you, Mr. President, in the list of the Panama Papers, there were a number of Trinidadians listed there. There were a number of Trinidadians listed there. So this is not about a crime of passion. I would expect a judge in the exercise of his discretion in a crime of passion to put the matter before a jury of his peers, or a larceny of a motor car, or somebody in Mason Hall looking to thief, macking people sheep and goat and looking to steal all, Senator Mark. I would expect a judge to put those matters where an election has been made before a judge and jury. But if somebody is charged with conspiracy, with terrorist financing, or all the matters listed out, proceeds of crime, fraud, anti-gang, trafficking in persons, Mr. President, trafficking in persons, economic sanctions, the Securities Act, the Insurance Act, public procurement and disposal of public property, the Gambling and Gaming Act, I would expect that if somebody who is charged with one of those complex crimes would elect to go before a jury of persons who are not qualified or experienced or skilled in those areas. And in that consequence, Mr. President, the judge, in the interest of justice, which is a time-old test used by judges all over the world for centuries, I would expect a judge to say, hello, hold on. These are very complex matters, and a jury would not serve in the interest of justice to be appropriate triers of fact in this matter. And therefore, either by judge alone or the introduction of lay assessors. I would expect that. Also, the Honorable Attorney General gave an example of a very grave and serious crime involving, well, I believe it to be involving a drug lord of notorious repute. Persons who can reach you anywhere, potentially putting a jury in danger. Because all you need, as Senator Luchmedial and the other practitioners in the criminal courts, all you need is to know a juror's name, you know. You go onto Facebook, you find the juror. You find out where the children going to school, because everybody has their lives on Facebook. And then you either receive an approach to be bribed or threatened with death. So I would expect a judge in that circumstance to also exercise his discretion in the interest of justice. Now, if members on the other side wish to particularize the criteria for what must be taken into consideration in exercising judicial discretion in the interest of justice, well, that might be a conversation that can be had. But for matters of the complexity that we are talking about, a common jury simply would not suffice. And therefore, we've introduced the concept of lay assessors. Mr. Vice President, I did the bar in England and in the magistrates' court. The magistrates' court is adjudicated by lay persons with the assistance of one attorney at law, someone who is legally trained. There are lay assessors in other jurisdictions across the world. But the concept of lay assessor must be read with the intention of the bill to also repeal this creature called special jury. And there is certainly the need, or rather, there continues to exist the need that the special jury was supposed to have satisfied. However, for whatever reason, whether it is bureaucracy, whether it is within the court, I can only imagine if you attempt to empanel or strike a special jury, these professionals not leaving their big money to come to work, to be empaneled as a special jury, to sit for a month or a month and a half to deliberate over a criminal trial. They may get a similar letter like, they may get somebody to write a similar letter like Senator Thompson Ahi. You may find some of these people in cohabitational relationships with attorneys at law and other persons who are so exempted from sitting on juries. So I would imagine that that is the case, that you're taking persons, professionals, high-earning professionals from society, to put them to sit down in a court where they're not earning the kinds of money. They have mortgages to pay, they have bills to pay. So, for some reason or the other, while it is a creature that is necessary in our criminal justice system, a special jury has never been struck. It has never been used or very seldom used. And the lay assessor comes to do and comes to perform, and we expect to perform a lot more efficiently, the same job as the special jurist was supposed to have performed, or the special jury rather was supposed to have performed. Because the judge himself, while the judge may be an expert in criminal procedure, in criminal law, the judge is not an expert in maritime law, the judge is not an expert in shipping law, the judge is not an expert in these in technology and Bitcoin and mining and all of these different things. So So in those circumstances, the judge is not competent in civil engineering. So in these circumstances, there is the introduction of lay assessors who may sit with a judge and assist that judge in certain, but the judge remains the trier of fact and the trier of law in the trial, in the criminal trial. The judge remains the trier of fact and the trier of law in that criminal trial. The lay assessors are there to assist the judge in complex matters. So, Mr. President, I would respectfully submit that these new mechanisms will work to speed up the criminal justice system, and we're not doing it. This one bill will not be the panacea or the silver bullet for the entire criminal justice system. There are perennial problems with the criminal justice system. And we have been working piece by piece, introducing, amending pieces of legislation to ensure that the criminal justice system works, to ensure that persons have access to justice, and that there is justice not only to accused persons, but also to the persons who are the victims of crime. Because as the administration of justice remains slow to a crawl, it also has adverse consequences on the rule of law. And we are seeing some of those consequences here today in our society. The general observance of law and order by all citizens has the consequences on the rule of law. So we definitely need to work to improve our criminal justice system. And I respectfully submit that this piece of legislation continues the revolution of ensuring that the criminal justice system works well and serves the people of Trinidad and Tobago.
I'd just like to clarify something, please.
Did you ask the member to give way?
Yes, yes, please.
Go
May
ahead,
I, sir?
Senator Thompson.
Sure.
Yes.
Thank you so much. Did I hear you say earlier that in matters where, these are my words, but tell me if that's the sense of it, there's a lot of passion and so on, that in the interest of justice, that the judge, even though, you know, the accused may want the judge to hear it, that in the interest of justice, that it should go to a jury trial? Did you say that earlier in your presentation?
No. I am responding to assumptions being made opposite, that persons are going into the heads of judicial officers, judges in this case, and saying that where a judge faces an election for a trial by judge and jury, the judge would most invariably, in the interest of justice, using his discretion, sit on the
Senator, you have
trial,
5 more minutes.
sit as a judge alone. And what I'm saying is, where there are crimes for which the common man, robbery, home invasions, larceny of motor car, conspiracy with the larceny of animals or cars or some other type of chattel. Those matters which are in the common experience and the common understanding of the ordinary juror using the man on the priority bus route, that the judge in the exercise of his discretion would allow for the election to be made for trial by judge and jury. He would not disallow an accused person from that election. But I'm saying that it is not a right. I am saying so because I believe in our judicial system. I believe in the judicial system. I believe in the judicial system. And Mr. President, Senator Bisram Singh asked a question. Of the 59 judge-alone trials, how many are up on appeal? The answer is 6. The answer is 6. So, Mr. President, I wouldn't go in. Many other presenters have gone into the lay assessors, disqualifications, exceptions, the matter of the voir dire, where the judge alone decides upon the voir dire and decides alone and decides whether he should sit alone. As well, the judge in judge-alone trials, the judge in a trial along with lay assessors must give his reasons for his judgment. So, Mr. President, there are existing safeguards within the legislation. I believe that we can study and we can get context. We can examine what goes on in other jurisdictions all the time, but we need to specifically understand what goes on in Trinidad and Tobago, the types of crime, the complexity of the crime, and our judicial system, our criminal justice system, must respond while not denying persons access to justice, while not infringing on persons' constitutional rights, to ensure that the rule of law is maintained, the administration of justice is done efficiently and effectively, and in that way, our citizens are made safe. Thank you, Mr. President.
Senator Dylan Remy.
Thank you, Mr. Vice President, for allowing me the opportunity to come into this discussion at this late stage in the batting order. After such a vibrant discussion that has happened so far, not just vibrant but passionate, as I was going through this and I heard my colleague, Senator Derup Timal, talk about dealing with the law and the facts, and also many of the lawyers who have gone so far. I am here as a lay assessor number 2 of the 5, and will be dealing with what I consider the facts of the matter. I can't speak about the law, but I can speak about the facts. And in my, when I was reading the bill, I had some questions, and I must put here again, as 2 other senators have done, and I really do think that there must be some adjustment of it. I too was looking at the bills that we were supposed to be amending, and the bills that I had available to me did not have the clauses in it because they were old. And therefore, it is this morning I had to ask questions, and I received the updated bills. So again, time was spent doing stuff that could have been spent otherwise. So I'm asking to, if it is possible. I know we've had in the past, we've had some bills that have been sent to us before, but this was not the fact this time. So, so my questions were, you had a very vibrant debate that resulted in the 2017 Act. and I looked at the Hansard. I listened to some of those debates, and I realized that a lot of effort went into it. And when the Special Select Committee of the Senate, chaired by Senator Clarence Rambarat and included Senator Sophia Choach, SC, Gerald Ramdeen, among other persons, they came back with a bill that the Senate voted on, and it was also accepted in the House. It was assented to in 2019. We are now in 2023. And so I'm thinking, if you had such a good act in 2017, assented to in 2019, if you are making a change now, it must be for something significantly better. So I looked, I asked questions, and I'm still asking questions, Attorney General, because I am not yet understanding fully. I hear about the speeding up of justice, but I still have not heard. So, okay, I would just like to look at two areas mainly. The intention of the bill to discontinue the use of special jurors and to provide for lay assessors in trials. That has been spoken a lot about about the lay assessors. We don't as yet know why the special jurors were not used. That part of the Jury Act, with special jurors to do what the lay assessors are now doing in terms of their speciality. Why wasn't that used? I'm not going to ask the questions again, but that needs to be answered in my mind. I understand that the lay assessors are to help the judge in complex matters. I get that. And from what I understand, it is something that judges would like to have because it will help in complex cases. I have no problem with that. You have not yet convinced as to the jury, the cost of the, because one of the things that the government has said so far, or the speaker so far, have talked about the reduction in cost. Again, I don't yet understand that you have the selection of jurors being decreased right now to the selection of lay assessors, and the fact that it's going to be less costly. I have not yet been convinced that it will not just be less costly, but you're going to get a fairer system in place. I have not yet understood how that is going to happen. So, and my other comment would be on what I asked: why are you starting with the default? If this 2017 bill act was so good, why are you switching to start with your position, your start-off position, being judge alone? Yes, I understand that you have not removed the option for jury trial, but they have to ask for it rather than the other way around. And I do not know what that means in terms of cost. They may have to, I don't know. As I said, I'm a layman. I'm dealing with the facts. I don't yet know what that means. You have switched it. It was supposedly very good. I don't yet understand. You have not yet given me the facts to make me say, yes, I agree with that. So, as I said, I understand that the lay assessors are there appointed to assist the judge. And the concept of the lay assessors, I understand, is not new. My understanding is that right now the lay assessors are operating in the industrial court on matters, and they sit on tribunals like the equal opportunity tribunals. I understand that the concept of lay assessors, I heard one of the senators talked about them being used in China. So it's not a new concept, and from what I understand, they add value. I have no problem with that. However, the lay assessors are specialized. Will you have enough of them? One. Will you protect them from being contaminated, as you may have had the same thing with jurors? What is there that allows this system to be more efficient than what you had before? I don't yet know. I'm dealing with the facts. I am a layman. The other point I would like to make, the cost and quality of the change. I was reading an article that talked about there was an article about at a third annual Distinguished Juris Lecturer of the Trinidad and Tobago Judicial Educational Institute, the Chief Justice of the Supreme Court of Barbados in 2013, Sir Marston Gibson, presented a paper entitled The Continuing Relevance of the Jury System in the English-Speaking Caribbean. And in it he mentioned that during Professor Ramesh Diosaran's seminal work on trial by jury in the Caribbean, some of the reasons advanced for the abandonment of trial by jury was bias, personal involvement, and corruption of jurors. So, just as you have said before, there have been disadvantages in the jury system. How are you preventing the special assessors, the lay assessors, from being corrupt? The Law Association, or other members of the Senate who have spoken so far have spoken about it. The Law Association did submit in their statement that they sent to the clerk today that an accused was entitled to public trial, and the reduction of the number of persons may have an adverse effect on the fairness of deliberation. I am not going to at all discuss 12 and 9 and those numbers. What I'm concerned with is just making sure that whatever system is in place is sustainable and offers fair trial to whoever the accused is. I am not going to be very long again, because I think most of the points that I had to make were made already. So I would like to just make sure that as we are looking at the systems that you have provided here, that yes, you are dealing with backlogs. And one of the things that was mentioned in one of the concepts that was mentioned is the concept of the public's confidence in the judiciary. And whatever is being put in place must have the confidence of the people. And I am right now being swayed to the concept of having the bill reviewed a little more before we put it to the vote. And I'm saying that because based on what happened in 2017 and what was presented and what came out after robust discussion within the Senate, I would like to suggest that something like that be done so that you get more buy-in rather than what is happening right now. We want to see, I certainly want to see, that whatever is put in place works. Because yes, we have issues that need to be handled right now. And I am not saying that this one law or one act is going to significantly change the systems. I still remember sitting down here and debating the marijuana, that marijuana bill, and we were told, you're removing so many thousands of cases out of the magistrate system, and I do not know what has happened to that, but all I know, we still have a big backlog. So all I'm saying is that whatever we put into place must be robust enough and make a difference in what is going to happen. So, Attorney General, as I said, the switch, you have to convince me as to why you're switching the default position. And even though the lay assessors, as far as I understand it, are going to be of use to the judges, how will you protect them? All the issues about their selection and stuff like that was mentioned already, but how do you protect them from the same system of contamination that you had before? I would like to know that whatever we do here makes a difference, and will be willing to support whatever makes sense to me as I look at the facts, not the law. Thank you.
Senator Drayton.
President, for this opportunity to weigh in on this very important bill. We are all familiar with the phrase, justice delayed is justice denied. All of us. Reforming the criminal justice system at a time when crime and criminality is at its zenith is akin to changing the boards of a leaking boat or ship while on the high seas. Do you run the risk of a leak getting bigger, causing the boat to sink, and loss of lives to those on board? Or do you attempt to exact repairs on the vessel, also running the risk of increasing the vulnerability of that vessel? Either way, the risk is high, but something must be done. You see, Mr. President, this bill is attempting to resolve several issues and challenges that we face, all of us, on a day-to-day basis. None of us, no citizen, including judges, can say that they are divorced from the experiences of crime and criminality in our society. This bill, the Miscellaneous Provision Trial by Judge Alone bill, moved by the Honorable Attorney General, seeks to change the boards of a leaking boat, Mr. President. At a time when those on board, our citizens, are asking for justice, something must be done. However, our actions must be measured and resolute. And it's my hope today that they are, because our citizens require nothing less. I listened attentively to all of the contributions so far because I think it was important to hear the different views and to distill them. I recognize that there's the balance of what is fairness, what is just, what is accountable, while at the same time asking questions about judicial efficiency, effectiveness, and of course, the final element, cost, which is included in efficiency. So it's a balancing act, Mr. President. That being said,
This bill seeks to make changes to substantive practices and processes, amending the Jury Act by removing special jurors, as you heard from all the other colleagues before, and increasing the exemption of persons to be jurors, as well as the number of jurors. 2, inclusion of lay assessors replacing special jurors as mentioned. And of course, this question of what is the default position, judge alone or trial by judge and jury. Before I continue, Mr. President, I wish to note the views expressed by the judiciary in Newsday article titled "Judge Alone Trials Take 2/3 Less Time" by Julian Neves, Wednesday 15th January 2020. And I quote, "Appeal Court Judge Charmaine Pemberton said the 6 judge-alone trials since the passage of the legislation in 2019 took 1/3 as long as cases determined by judiciary." And she was speaking on that same day at the opening of a 2-day workshop on judge-alone tier fact trials at the Hyatt Regency Port of Spain. Additionally, Justice Pemberton indicated that the Honorable Chief Justice was also in support of judge-alone trials. How do you reconcile this statement with views expressed by Law Association? How do you balance the fact that there have been criticisms of judge-alone trials? It is our task to make that determination, and hopefully as I go through the rest of my contribution, which will be short, I hope that we will be able to come to some kind of conclusion. So let's look at the act itself. Sorry, the bill. The first part of the bill is to amend the Jury Act, as I mentioned before, repealing the definitions of special jurors, which we spoke about earlier, as well as to delete reference to magistrates and clerks and add judicial officers as mentioned. The big ticket item here, however, is the reduction of the number of jurors from, as you heard already, 12 to 9, and there's a debate whether size matters, as well as from 9 to 6 for the trial of any case except in the indictment for murder and treason. Now, while the Honorable Attorney General indicated that judge-alone trials don't infringe on constitutional rights to a free and fair trial, it would be interesting to understand the rationale for this default position being switched, and more specifically, the reduction in the number of jurors. I don't think any of us by now, reinforced by several other colleagues, have had a sense as to why. The only reference that was made by the Honorable Minister in the Ministry of the Attorney General, who spoke to cost. So let's look at this whole issue of reduction in the size. The NCSC, which is National Center for State Courts, as some of us are familiar with, researcher Erica Boyce produced an article titled "Time to Reflect: Has Research Changed Regarding the Importance of Jury Size in 2021?" And I quote, Boyce said that the most recent research continues to highlight the complexity of this issue, and her report presents that complexity in these findings. 1, some research says that reducing the size saves money for courts and for litigants with lawyers, but other research says the savings are minimal. Have we done that level of cost-benefit analysis? Was that presented to us? I can't recall. 2, jury service is sacrificial forcing jurors to leave their wages and time from family. So smaller juries mean fewer people and have to make those sacrifices, fewer people, having to make those sacrifices. But other research says people who serve on juries develop a greater appreciation for the justice system. So smaller juries mean fewer people will experience that appreciation. 3, it's easier to reach consensus in smaller juries. I think some of my colleagues mentioned this. Some research shows, but they're less likely to include diverse viewpoints, and larger 12-person juries often possess a better collective memory when they adjourn to review testimony and evidence. 4, smaller juries are often less diverse and less likely to accurately represent their communities. And lastly, Boyce concluded that the future research should rely on court and juror data as well as predictive models. Essentially, we're here debating reduction in numbers, etc., but the truth is we don't know. We don't have the data to support it in our jurisdiction. We don't understand the effect. And if there's anything, if we're making the case for cost, efficiency, and the like, we should have something to go by. Perhaps it may be prudent to conduct the relevant studies or preliminary research in order to make better judgments. I just wish to note that, and I think this was noted before, that Senator Lachmidial spoke about the importance of juries, and I concur with the importance of juries being judged by peers. But I do note that in Clause 4A, Roman numeral 6, is judge alone, but not restricting, which is something I think Senator Vera and some other senators noted, that this, and Senator Mark and others noted this too, that it is their belief that this legislation is saying do away with judge and jury trials, and it's not. So I concur with learned Senator Vera, who agrees that in this legislation is not saying it's doing away, it's changing the default. My issue, however, is what's the justification for the default position? And I think that leads me to another point. Because you see, I kind of have a sense as to perhaps, I don't know whether it is the thinking, but it is a fair assumption that the kinds of crimes that are committed today are substantially different from those of years gone by. The criminal activities are more complex and tiered. And therefore, a good segue would be if the default is judge alone, then the segue would be into lay assessors. So that the judge is supported by these experts, and as the Minister of Tourism, Culture and the Arts said, is supported by technical personnel who understand the complexity of crime. But this is just my assumption. I'm not aware what the government's position is, but I suspect that that may be the default, the reason for the default position, rather than the opposite. Which then, as I said, is a good segue into lay assessors, which has been discussed extensively. But I would say that from my experience in another place, this is extremely important for judges. I can just give you a snapshot. In the arena of financial crimes, as we were talking about, in financial crimes, the final goal is really to take the profit out of crime in simple terms. But that means you have to recover assets. from the process of disclosure right down to the end of recovery, which some of you may not be familiar with, there's a very in-depth and complex process. And we are speaking about money laundering, some of you mentioned it before, terrorist financing, tax evasion, etc. In the region, there are a handful of judges who are experts in these areas. And I'm talking about in the region. Of course, prosecutors may decide to go so far as to get additional assistance. The defense does the same thing. Who assists the judge? So lay assessors play an integral role in being able to assist judges because judges are constantly being sensitized. But are there limits to how much sensitization could be done on a range of areas and issues? Should a judge be a specialist in terrorist financing, proceeds in crime, right down the line to cyber issues? No, they can't be. And therefore, this is what I believe to be a unique, interesting, supportive way for us to do that one thing which we are really scoring badly on. Read any of the mutual evaluation reports for Trinidad and Tobago, as well as the rest of the region. We're doing badly in prosecuting financial crimes. How do you enhance that? So while I understand that this legislation is useful for those specialist areas, I do understand the concern about crimes of passion and that type of thing. And that's fair. But I don't want us at the same time to not see the importance of why prosecutions are in fact very low within the region. It's really because of technical capacity. And in some instances may be fair. I don't know much about this, therefore I may not want to sit on a case like this. I may not want to prosecute this. And I can tell you that a range of international organizations and members in the donor community and regional institutions have been building out the capacity of law enforcement to go after these complex issues, at least over the past 4 years, because I have been a part of that. So if we are building out our capacity to investigate, if we're building out our capacity to prosecute, why can't we build our capacity to ensure that judges have the best advice and support to deliver judgments? That's what this lay assessors is about. So my position is very clear that I understand that within the context of my area of expertise. And I don't agree with spelling out after you have proceeds of crime, you want, okay, do you know what a customer information order is? And you go down the line, the skill set associated. I think that can be determined. So I don't necessarily agree that the skills and expertise should be identified. I think it has to be fluid. So it can't be identified in legislation, but of course in the process, it could be. Do we need to specify for each offense? I mentioned that already. Do we need to have assessors with special training in the administration of justice, which is a part of what's here in the bill? That's a query, and I would like to hear from the Honorable Attorney General, just why do you have that there if you have a judge? So there were questions related to protection, I think Senator Remy spoke about, and that's important. But I do believe that there's a higher level of integrity for certain specialists kinds of professions, whether you're involved in fraud investigations or that type of thing. There's a certain level of ethical code and practice that you subscribe to, and therefore comparing that to, let's say, a jury who may be a bit more susceptible to bribery and these kinds of things, I don't think that you would have that as readily in that profession. There's right. So with respect to in the bill itself, the new section 6, section 6C2 Roman numeral 15, there's that list. And of course, it's listing involving fraud, proceeds of crime, etc., etc. And then the final element here says, under any written law in relation to the prevention of money laundering, combating of terrorism, and proliferation financing. I would ask the Honorable Attorney General, why isn't corruption listed there? It should be. So that that's one amendment that I would like to suggest in terms of inclusion on that list. I think that while this bill provides useful first steps, there is the concern as to whether all views have been distilled from necessary stakeholders, and that is clear, or it is clear rather, that views have not been distilled. There are key questions that are obviously unanswered from the debate, and I think there are more questions than answers, such as the real justification for the default position of judge-alone trials, fleshing out of the role of lay assessors, and I would also add here, in terms of lay assessors, in the literature, when you were to read some of the studies on lay assessors, they are also in the same level as judges, and decisions are usually taken based on a majority vote. This is a consideration that we should include, or if it's not included, provide supporting evidence that is contrary to the vast range of literature, because unlike some of the other colleagues who mentioned case studies such as China, it's a massive amount of information on European jurisdictions and how it's been done in common law, European jurisdictions, and the like. So I would say that kind of analysis is required. And of course, finally, the whole question of why decrease the number of juries when the best practice suggests otherwise. I heard the 6 versus 9 versus 12 argument. I believe if it's a sticking point with the numbers, just leave it. Because we don't want to really miss the big picture here. And the big picture is really to address crime and criminality in Trinidad and Tobago, and to figure out what are some of the tools that we can use to help those stakeholders in the criminal justice system. So let's not miss things because of these minor computations of number of jurors. So without further ado, Mr. President, I said that I was going to be short, so thank you very much for allowing me this opportunity to weigh in on this very important piece of legislation. Thank you.
Senator Nakid.
In the name of God, the most gracious, most merciful. Mr. Vice President, I thank you for allowing me to join this debate. And I'd like to start by assuring the Honorable Minister of Tourism, Culture and the Arts that after his contribution, he can be assured of being spared any controversy of senior counsel in the future. His contribution was perhaps the most trite, elitist contribution. I don't make no aspersions to the gentleman. I talk about his contribution. He mentioned, Mr. Vice President, at least 5 times the East-West corridor in the most disparaging of manners. Like if people from the East-West corridor have no idea of discernment. Like if every single piece of evidence in a trial is of an esoteric nature, can only be understood by just a few people.
6-6. He's imputing the proper move.
Senator Nakid, you have just started your contribution, and I do understand that you would like to respond to the minister, but please do so within the standing orders.
And I appreciate your guidance, and I think I have. I think what he said was quite disparaging towards the East-West corridor, and it's my opinion. That is so. I represent the people of Trinidad and Tobago, and I feel so my duty to defend them. I will do so.
Senator Nakid, you've made your point on that line. Can you please move on with your contribution?
I was. Thank you, Mr. Vice President. He also mentioned about the disadvantages of jury trials and so. And of course, democracy is hard. Democracy is, by its nature, it's a very onerous process. It should not be something that should be frivolous and we look and seek expedition at the expense of justice. I think the same self-mentioned people of the East-West corridor who suffer under this government at the pump, suffer under this government at the supermarket, suffer under this government in all sorts of ways, they can at least expect some justice when it comes to judicial matters. And I think it is only deserving that we give them that. They pay taxes just like any of us. So we should not look to the East-West corridor, which, by the way, Mr. Vice President, which the Honorable Minister spoke about, represents most of their constituencies. These are the people they look to for votes. And to speak like if they do not understand or they can unable to understand.
46-1.
Senator Nakid, relevance is being applied as a point of order here. Can you focus on the bill at hand? Yes, but you are going down. Yeah, right. I understand that you are passionate about the citizenry along that line. However, you need to move on to your point that you need to make.
Well, the point is, thank you, Mr. Vice President. The point is, I want them to know, on that side, that the citizenry is watching. And they are aware how this government truly feels about them. That they can intimate that the people of the East-West corridor are unable to sit at jury trials and make sense of what is presented to them. And that is why we have lawyers and judges, Mr. Vice President, to explain the case. So it's not like it happens within a bubble. lawyers and judges are there to make sense of it to the jury. So I found it quite disconcerting. I found it uncomfortable, unnecessary, that someone should speak about what we would consider even their own constituency in that way. Mr. Vice President, when we look at the contribution of the Attorney General, and I think all will acknowledge, skeletal in nature, skeletal. He would have been happy for the intervention of Senator Mark to add some substance to what he presented. And he touted as a success, without a scintilla of evidence, that 59 requests were made. But what were the nature of those requests? What was the effectiveness of those cases? This is a government that continues to do the same thing over and over, Mr. Vice President. They come, they give us words without deliverables. Not one case or one statistic was presented that we could grip into. Not one. And I think many of the senators alluded to that. So what we would like, Mr. Vice President, is not this duplicitous sort of talk where we have to decipher or make sense of nonsense. And I think that serves as a microcosm to exactly what we are here to debate. Because I hear about how many jurors we should have. I mean, and when you listen to the Minister of Tourism, he said, why not have 60? Mr. Vice President, this is a practicing lawyer, from what I understand, someone who possesses a law degree. But the practice of 12, as a senator stated, has been in the precedent for centuries. That is why we have 12 and not 60. And that is what this government fails to understand. They would like to remove something that works, like they did with the laptops, and they would like to implement things that do not work, that is untested, untried, unproven. And that, in other words, is what we call chaos. What exactly is going on over there on that side? They have not made one proper legal representation as to why we should accept this bill. As a matter of fact, when one is to decipher and interpret many of their contributions, well, to be honest, 3, we have to ask ourselves, are we supposed to come because of the simple majority and just rubber stamp something that is really lacking in terms of legislative substance? It is poor legislation, Mr. Vice President. And I'll tell you why. Even the goodly Senator, Sargram Singh Suklal, when asked about it, she spoke about the semantics of it. She spoke about how they would consider it and maybe change the legislation and the wording. Mr. Vice President, this is emblematic of this PNM government. As has been said repeatedly, they come here to seek consultation. When here is to present legislation and we make amendments, the consultation that should be had is bypassed. And not only bypassed, it is presented as actual consultation. I said here one time before that consultation seems to be the Achilles heel of this government. I would like to take that back. They are not interested in consultation. They're only interested in pushing an agenda that seeks to consolidate their power over all processes. And this must be disconcerting to the population. So don't tell us about semantics. Let us know why you have decided to come to the Senate with legislation that is poorly drafted. I heard the contribution of Senator Vera, who quoted Milner, who also bemoaned, he said, who bemoaned the inability of the average person to go through evidence and so. And I asked myself, are some of the people in this chamber, are they aware of the life experiences, life conditions of the people that they represent? And I'll give you an example that pertains to the bill, Mr. Vice President. So we have a jury, 12 people. And as been stated before, and I think Senator Thompson-Aye brought the evidence. She brought the evidence. She quoted jurisdictions that showed why 12 was better than 9, better than 6. And that is what we were looking for from the government. They brought no such. I continue. So a jury of 12, which gives us the diversity, the life experience, possibly the cultural relevance to an accused. We have them there. And we have a judge. And I'll give you an example that is anecdotal, but true, of a case given to me by, well, who I consider probably the best criminal attorney in the country, the esteemed Wayne Sturge, where he said, I'm glad they find some jocularity with that. He would wipe any of them under the carpet on that side. So Wayne Sturge, he gave an example of a case where a young boy who attended one of the so-called prestige schools in Mova, and an alleged gang member running from the police was running through his yard, because I'm sure on that side they are not aware that in some of those so-called hotspot communities, some of those areas that even they represent, the people there live cheek by jowl. So when you run through one yard, you reach another yard, all the houses connected. And an alleged gang member was running through his yard. He saw an open door and threw a package of drugs through the door. No one was there. Just threw it through to get away from the police. Later, the police on a search found the drugs, charged the boy who was there at a prestige school. Charged him, Mr. Vice President. How are you going to bring that case before a judge who lives, most likely, a life or in an area, not on the east-west corridor, as the Minister of Tourism said, but lived in an area where he would have to run through his garden, jump over his pool, go through some of the gazebo in his yard, but could never understand that it's quite possible that a gang member can run through 10 different houses in the space of 30 seconds, throw a package of drugs into a house, and the police charge the people in that house. At that time, it was the boy. How could he understand that? Maybe a judge can't. But 12 people in jury, they would have the relevance. They would have the cultural knowledge. It would be significant to them. They could relate to it. But they come on that side to tell us that no, the judge, he can distill not justice in a way that a jury couldn't. And that's the problem we have with this government. It is not only a government of elitists. It is a government that doesn't take into account the circumstances and situations that they have placed these people on the corridor, that they find themselves in. So it's a complete bypass. In other words,
46-6.
Senator Nakid, I ask that you continue your contributions based around the bill at hand and the changes and the amendments accordingly.
Mr. Vice President, I heard everyone here speak to the merits of jury as opposed to judge.
But
I am given
you're veering way off of what the bill is. We have had a very long day so far. Everyone has gone through the clauses, but yet you're yet to focus on the clauses that you need to be relevant to, please. Can you stick to the matter at hand?
between the judge and the jury. What is the merits of both?
You're going way beyond. Your last point was made very well, but this time you're going way beyond the clause.
Mr. Vice President, I only hope that they would get up and help the people like they get up in this chamber. So, Mr. Vice President, as I said, the contributions that we hear, where it is assumed that somehow the poor and working class are just incapable, are just too duncy, that this is a job for the educational elite. In plain talk, in other words, we'll have a certain class of people not only benefiting from the patrimony of this country, we'll have a certain class of people dispensing justice in this country. We in the United National Congress will never accept this, and we reject it. And when you see them on that side, grinning, like this is a joke, like this is no problem for them, I can assure you, Mr. Vice President, we will fight this tooth and nail to the end. This will not see the light of day but in court. There's no joke for us. This is no joke for us at all.
Senator Naked, I ask that you temper your comments and stick to the bill at hand, please.
So as I continue, Mr. President, instead of bringing to this honorable chamber real legislation, how we can improve crime detection, this abhorrent PNM government brings only legislation that seems to punish poor and working class people. Always. Mr. President, the bill, in summary, seeks to do 5 main things. First of all, remove the entitlement to a jury trial, relegating this to an option where you now have to grovel and beg for what has been an entitlement for hundreds of years. We heard before it seeks to reduce the number of jurors in a criminal trial for murder from 12 to 9, capital cases 9 to 6. And here we come to, this bill seeks to replace the honorary citizens with lay assessors. Now, Mr. Vice President, I have a problem with this. I have here, and I said before, we can use this Senate chamber as a bit of a microcosm to what we have in the court system, where we have so many diverse opinions and we don't agree with all the time with each other. It's quite clear. That's why we have an opposition. And it's the same. It's that contentious nature of what we have here, where we arrived at possibly the best solution. What is so hard to understand? Why would you place that? And I know some of you over there must, on that side, must have a conscience. I'd like to think most of them must be worried about the poor and working class people of Trinidad and Tobago. So then the question becomes, has thought been given to the lay assessor, except, in my opinion, in the cases of complex fraud, as has been stated here? Why is there the assumption that the lay assessor would possess the necessary power of discernment that will supersede the ordinary citizen? I want you all to know that justice is for all. It's just not for the elite. I want us to be patently clear. We cannot pretend to represent constituencies where that seems to be churning out at this point people who we call killers and shooters, when we treat them in this disparaging manner, when we do not account for their level of education, we disparage them. Mr. President, we had half of our people in the schools fail. I will not go into the constituencies in which they fail, but then we come here without solving that and bemoan that they are not able to sit down on a jury. How is that possible? So we have people who create the problem, exacerbate the problem, and then criticize the problem when they are responsible for the problem. And if they find something funny in it, for me, on my side, it's sad, because I grew up with these people, Mr. President. I played football with these people, Mr. President. And let me tell you something more. They might have worked in bottling factory, Carib, match factory, but all of them, if you have a conversation with them, all of them bright as a bulb. You can have a conversation with them for hours on the block about politics or anything. So I resent the assumption that they don't have the knowledge. They don't have the wherewithal. But this is the common man. If you go in remand yard, Mr. President, who's there? People that we know? Our sons, our daughters? No. So how can you claim to come and speak to them, not only disparagingly, but to totally try to eliminate them from the process of justice? It is abhorrent, it is unfair, it is reprehensible, and it is indicative of this PNM government. And we of the UNC do not accept it. Mr. President, I am thankful for the timely release from the Independent Criminal Bar Association and the Law Association. I think it encapsulated all those who have serious concerns about this legislation. I won't go into detail, but what I would like to bring is some things that took place before. I do agree with the Criminal Bar Association that this is another piecemeal erosion of fair trial protections guaranteed to the citizens, and they've certainly seen enough of their rights being slowly eroded by this government. I like the allusion to the fact that the Attorney General, the former Attorney General, made it clear that the intention was to eventually remove trial by jury, which he said in one of his contributions, from the landscape of our jurisprudence. And someone mentioned it, but I'll go into more detail. There are actually only two distinct times when the citizen, the ordinary man, especially in the poor and working class, who doesn't have, like most of us do here, maybe access to proper banking facilities and the opportunities that we can afford our children, whether it be in education or health. But he has that opportunity, Mr. President, when it comes to the elections. He has that opportunity. And he has that opportunity when it comes to being part of that justice system for people who probably look and come from his area, who look and understand where that juror came from, as well as how he understands them. Why would they take that away? What reason? And when I say what reason, they haven't given us any. And I think that's what some of the senators here on the independent bench ask. What reason to change something, though problematic as is the democratic system, works? Surely, as we've heard from many of the senators, the problem is not with the jury system as far as the expedition of trials are concerned. That's not a problem. As I mentioned before, it's the proper detection, police service not coming to trials, a whole lot of issues that has nothing to do with this. So why this? And here's what my opinion is on the matter. I looked very carefully, Mr. President, and bear with me. In section 6C, 2, subsection 3 and 4. And here is where I believe, as is my right, the mischief is not there's no attempt to alleviate the mischief, but as a matter of fact, it's an attempt to bypass the mischief. Because I looked at this, and I have to give a hypothetical case in order to make my point, Mr. President. Section 3, subsection 3, is misbehavior in public office, and it has to do with the lay assessors. Section 4 is perverting the course of justice. So let's say, hypothetically, because there's no case before the court, so there's no reason to be accused of bringing up something sub judice. Let's say there's an independent institution who, by their constitutional mandate, has to issue a report. That report has to be relayed to a second independent institution who has the constitutional mandate to relate to the Parliament. A completely different entity undermines that process. Complicit, when that happens, in misbehavior in public office. Are you telling me, according to this legislation, the ordinary citizen cannot comprehend the scope of that misbehavior in public office? Are you telling me that a lay assessor will be more equipped mentally to understand what misbehavior in public office is? I say no, Mr. President. And this is why I feel this whole legislation, this is the focal point of the Honorable Attorney General. Is this Attorney General anticipating that someone will be charged with misbehavior in public office?
So, Senator.
Question.
No. Whether it's a question or not, it can still go down the line of imputing improper motives. Just by the question that you're asking, you are creating a scenario that's suggesting a particular activity by the Attorney General, which is not allowed under the standing order. So I just ask you to be careful about the statements that you're making and the reasoning that you're putting behind it. Continue.
Let me rephrase, because I first gave the premise that this was a hypothetical case. I know nothing that is happening, as certainly no charges have been brought against anyone. I'm just giving the hypothetical, Mr. President. So I will not put the onus on the Honorable Attorney General. I don't want to give him the burden of remembrance. He seems to have a problem with that. What I would do is ask the question in a different way. This, I understand Proceeds of Crime Act, all the other subsections, anti-terrorism, okay, the argument can be made. Economic Sanctions Act, okay, if you want to be elite at your finest, in your pomposity, okay, I can understand. But if, Mr. President, you look at something like misbehavior in public office, there's certainly nothing complex about that. Someone has an independent institution, he has a constitutional mandate, rules are there, regulations are there, and it has to be carried out. Point final. Correct, Mr. President? So there's nothing complex. There's no lay assessor needed. There's no expertise needed. Why would subsection 3 and 4 be there? What of perverting the course of justice makes a lay assessor who, no doubt, Mr. President, certainly comes from a circle different than the circle of my boys in Mongdo or Lavantil or Tinapuna, but certainly not any the wiser. So my question, instead of asking the Attorney General to answer the question, my question is if the Attorney General in his wind-up can explain to this honorable chamber how can a lay assessor, what skill and expertise that he has preeminent over my boys on the East-West Corridor, as the Honorable Minister called them, that gives them the right, more so, to adjudicate a case of misbehavior in public office or perverting the course of justice. Why would that be there? I look forward to the Attorney General in his wind-up answering that question. And then again, Mr. Vice President, you know, the lay assessors, the qualifications, to be honest, are not any qualifications that we couldn't find with an expert witness. So when they speak about cost and cost, first of all, for me, when you talk about cost, when it comes to justice, I find it not only unnecessary, not only trivial, but it really has no relevance in a forward-thinking democracy. You can talk about costs when it comes to entertainment, to a crime symposium, maybe, but certainly not when it comes to determining whether a man or a woman goes to jail, gets the death punishment, capital punishment, or not. So to talk about we have to pay for food and for travel, it shows you again that this is a government that when it comes to the needs of the people, is truly of a government that is lethargic and lazy in its thinking. So, Mr. President.
Senator, you have 5 more minutes.
Thank you. Mr. President, I would like to leave by reminding this government that has saddled us with the highest murder rate we've seen in years, that have saddled us with probably the most straitened economic circumstances. I'm wrapping up.
So as you wrap up,
Yes.
just make sure you keep it tight to the
I'd
bill that's before us, and just
Okay.
wrap up.
Thank you, Mr. President. I'd like to remind this government, given all that I've said, given all that I've told them about their lack of proper work in drafting legislation and implementing it, to remain at least focused on the needs of the people. And if you cannot do so, do the right thing. All of you on that side. Ask your leader to demit office, absolve Parliament, call elections, and let us show you how to do it. I thank you, Mr. President.
Senator Dianarine.
Thank you, Mr. President. It has indeed been a very long day, so I will be very brief in my contribution. Mr. President, so far, I've listened to the contributions, particularly to the contributions from the government, to seek out their justification and rationale for this piece of legislation. And still, just like Senator Dylan Remy, I still do not feel very comfortable. And as a result, I see that it is very important that I stand here and put forward my views. My views may very well be asking for further clarification on the rationale for this piece of legislation, and it may also be putting forward my understanding of the legislation, which may or may not be correct, but it puts forward my ideas and understanding to give the government an opportunity to explain further on this piece of legislation. So far, this bill, in my view, appears to be gradually eroding the jury system. All sections of this bill with respect to special jurors are being repealed by way of Clause 3. I have a concern about this. Right now, the purpose of special jurors are if you have a particularly complex matter, example, complex fraud, or other complex cases, something of that nature. It will call for persons of a particular skill set to explain things to the jury. That is the purpose of the special juror. What this bill now does is to repeal those sections, but introduce what we call lay assessors who will only sit with the judge by way of Clause 3 again. It is a provision for the judge. The lay assessors are not coming to assess the jury. What happens now when you come up on indictment, the default position is judge and jury, or you could elect for judge alone. This was made clear by everyone who spoke previously. This came about by amendment to the law in 2017. Now, this is being reversed. But it is not simply that you can elect to have judge or jury. The law goes on to say, and as many persons quoted before, and the court so directs in the interests of justice. This is something that the judge must exercise his discretion to determine whether it is in the interest of justice, and I'm referring to clause 4 here. Just like previous senators on the independent bench, my question is why? Why this reversal? Why the need to make the default position judge alone? Because how I see it, Mr. President, is that if you have a complex case, for example, fraud, and you want a jury trial, because there is now no provision for a special juror, automatically you're in a situation where the judge would have to say, well, in this case, I do not think it is in the interest of justice to have a jury panel because we don't have jurors with the core competencies required. Bearing in mind, the ability for the special juror is being repealed in this legislation. And so the judge in such a situation, in exercising his discretion, could therefore reach to the conclusion that, a judge sitting with 1 to 5 lay assessors is where the trial should go, and therefore so direct that this be a judge alone trial. So by default, you end up with a situation where when complex cases arise, a judge alone trial becomes the default in the interest of justice. This discretion being exercised is based on the judge alone, and the parameter being used is, and I quote again, in the interest of justice. Mr. President, I feel like this is being done in such a way that on one hand, you are facilitating the judge with a mechanism to give him or her lay assessors that is in the interest of justice. And yes, it may improve the overall administration of justice if lay assessors sit with a judge. So add that, no problem. But why are we taking out the special jurors? A jury now could never be assisted with that kind of impetus on a panel when a complex case arises, and automatically the default trial option becomes a judge-alone trial in a complex case. So we are weakening one mode of trial, that is the trial by jury, and strengthening the judge-alone part of it. From a policy perspective, Mr. President, it seems to me that the rationale to deal with the backlog in cases is gradually to erode the jury system with the hope that we eventually converge to a situation of judge-alone trials. Only. The perception of the government, it seems to be, is one which views the jury system as a clog in the wheel, which I am not entirely sure is the case. The jury system, as Senator Welch indicated, comes at the tail end of the process. That's when the trial starts. At present, from my understanding, everything is geared up so far towards the abolition of preliminary inquiries where all witnesses come and are cross-examined at the inquiry stage, which is not about innocence or guilt, but about determining whether there is sufficient evidence. What currently obtains is that when you go through the preliminary inquiry system, which takes a couple of years after you get charged, sometimes 2 to 4 years, you then have to get the notes from the preliminary inquiry transcribed, and it becomes depositions, which will then be used in High Court. But the transcription period takes another 2 to 3 years. Then it has to go to the office of the DPP. He has to review everything to determine whether you should be indicted for what you are committed for. The indicted person then reaches up to the High Court for takes another 3 to 4 years. So yes, the administration of justice indictable proceedings will abolish these preliminary inquiries. Then you are making the trial by judge alone the default option. This then means that the backlog is left with the office of the DPP? Yes, there was an increase in the number of courts, but we can't just increase the number of courts. You have to increase the staff in the office of the Director of Public Prosecutions. I do not buy this, Mr. President, I do not agree with this argument about high cost and too much demand on resources to get jurors. Persons can apply for exemption and the decision is adjudicated upon by a judge. This simply is the system. And if it has become so burdensome, then you need to take a step back and reassess why people do not want to do jury duty. It cannot be cost and be looked at as a cost-saving measure. I checked the draft estimates for recurrent expenditure for this fiscal year. And there is a line item under the judiciary called traveling and other costs for jurors, $3 million. $3 million is what it costs to do the feasibility study for the Toko Ferry, Toko Ferry terminal. So it is on average the cost of a feasibility study. Can't we just find ways in which to redirect expenditure to ensure that this critical function is carried out? Mr. President, the purpose of having a jury is to provide an impartial group of individuals who can evaluate the evidence presented in a case and deliver a verdict based on facts and the law. While sourcing jurors can be a rigorous process, it is necessary to strike a balance between ensuring a fair trial and addressing practical considerations. The ultimate aim is to assemble a panel that can fairly and impartially determine the facts about the case. So it is part of the process for a fair trial. The bottom line is that when this is done, the bottom line is that when the administration of, when preliminary inquiries are abolished, persons will be reaching up to the High Court faster. The bottleneck is right now at the magistrate court where people are waiting for their preliminary inquiries to get off the ground, and at the office of the DPP. The policy approach seems to me to be one to push a judge alone agenda. So courts will be judge alone and everything will move fast. In 2017, when judge alone was brought, even though there was skepticism, you couldn't fight it down because a person had a choice, a free choice. Now, it is not an unfettered choice. It can still be chosen, yes, but it is still something residual for the judge to find or determine which is in the interest of justice. And the last thing I want to see as I wrap up is I want to quote on page 164 of a book called The Decline of the Jury and Its Strength. The name of the book is Trial by Jury by Sir Patrick Delvin. And I quote particularly from page 164, and it says, "Each jury is a little parliament. The jury sense is the parliament's sense. I cannot see one dying and the other surviving. so that trial by jury is more than an instrument of justice and more than one wheel of the Constitution. It is the lamp that shows freedom lives. I thank you, Mr. President.
Attorney General.
Thank you very much, Mr. President. Mr. President, I have been very interested in the discussion which we've had today, and let me acknowledge immediately that I have benefited from the discussion, in particular the contributions which have come from the members of the independent bench. And as always, I am the richer for the contribution which comes from that bench. If we were to start immediately with an immediate comment that I would make in response to Senator Deonarine, even though I had not intended to speak to it in any detail, and I still will not, it was very significant that Senator Deonarine, in one of the last things that she said, referred to the Administration of Justice Indictable Proceedings Amendment Act. That is the bill which I will shortly be bringing to Parliament, to this Senate, by which we are going to ask this Senate to abolish preliminary inquiries and to move indictable proceedings straight to the High Court under the jurisdiction of the masters and then to the judges of the High Court. And the timeline projection that we have on the speed which that will accomplish is that we will move from the present circumstances in which some of our preliminary inquiries are yet complete and still at year 15 in the Magistrates' Court, to being able to progress from the committal to the start of the High Court trial in less than 6 months. The relevance of that to this debate, Mr. President, is fundamental to the discussion that we are having here today with respect to the trial by judge amendment bill that is before this House. In this sense, we are not here today on this piece of legislation, this bill, as a standalone, single panacea to solve the challenges that we have in the criminal justice system. We can only take the legislation one at a time. And this piece of legislation will be tied inexorably to the other legislation which is going to be brought to this House, on which persons have been working very hard, and there have been consultations by which we are hoping to bring our criminal justice system into a condition of sufficient reform that we will not be languishing in the condition that we find ourselves in now with progressing criminal trials. So immediately to answer one of the concerns that has come from the independent bench, this is not a standalone piece of legislation that we are asking this House to pass this evening. It is one of a series of pieces of legislation that we will be bringing to this House. Mr. President, another question, a legitimate question, and of course, in another place, there was a time when the judge might say to me, Mr. Armour, I'm not sure that I understood what you said, and I would always say, my lord or my lady, the fault is all mine. So the fault is all mine if I did not make it sufficiently clear when I opened today why we are bringing this bill to this House, why we have brought this bill to this House today. I spoke to it, but I did not sufficiently communicate it. I said in the very beginning of what I opened with earlier today, I am pleased to report to this House that we now have a proven operational system of judge-only trials. Correspondence from the judiciary, letter dated 22nd March 2023, tells us that from the 1st of February 2019 to January 31st, 2023, there have been 59 completed judge-alone trials, 35 remain pending. On average, during the year 2022, 2 requests per month were made for judge-alone trials, while 13 requests were made for the month of January alone. What I should have gone on to say, Mr. President, is that that is the platform from which we have been having, we, the Ministry of the Attorney General and Legal Affairs, has been having consultations with the judiciary, among others, but principally the judiciary. And it is the platform from which we have been encouraged by the judiciary to use a proven system that has evolved since 2019 to today, where it is demonstrably clear that judge-alone trials are enabling the judiciary to move the pace of criminal trials at a rate that previously has not existed with the judge and jury trial. We are not asking this House to abolish judge and jury trials, and I will come to that. But what we are saying is that here we have something which is demonstrably proven to be working. Let's improve it. And that is why we are before this House with the amendment that we are asking this House to accept by Section 4 of the bill before this House to introduce Section 6 of the Criminal Procedure Act, which says we will start with the judge-alone trial as the default option, not to replace judge and jury trials, but as the proven platform from which we are getting significant results. Already in 2013, in 2023 January, we had 13 requests for those trials. Of the 59 which were brought to the House, I beg your pardon, of the 59 which was started, we have had only 6 appeals. So 53 of those trials have been accepted by all parties of having done the job, and we are moving forward.
Mr. President, I beg to move that this Senate do now adjourn to Tuesday, May 16th, 2023 at 10 a.m.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you, Mr. President. Mr. President, the first matter that I would like to prosecute this evening is the need for the Minister in the Ministry of Finance to address what I have defined as the inconsistency in information provided to this Senate and information contained in the CLICO's 2022 financial statements on CLICO's shares in Methanol Holdings International Limited. Now, I would like to bring to your attention a development. I think I might have. I think I just left something. Yes, sorry about that, Mr. President. Mr. President, it was on the 15th of November, 2022, when I raised a matter on the motion for the adjournment on the whole Methanol Holdings International Limited matter. And during that particular matter, which I raised, on the whole issue, Mr. President, concerning the valuation of the shares of Methanol Holdings International Limited, and the whole question of not having an independent valuation of those shares in Methanol Holding, which is about, at that time, 56.5% or thereabouts. The minister in the Ministry of Finance is on record as informing this Honorable Senate at that time, in 2022, the 15th of November, that the final valuation for this Methanol Holdings International Limited shareholdings would have been completed or was completed in 2022 and shall be reported in CLICO's 2022 financial statements. Now, Mr. President, we have a copy of the 2022 financials dated December 31st, 2022. And even though the Minister of Finance had given us an undertaking that that independent valuation report would have been contained in this financial report of CLICO ended the 31st of December 2022, what happened? There was no independent valuation report, as the minister promised in this report. What we did have, Mr. President, is an in-house valuation by CLICO, when we were told by the Honorable Minister that an independent valuation would have been contained in the 2022 report. And this is where we have a lot of concerns and there's some confusion. Mr. President, I want you to look at the CLICO Insurance Company report, December 31st, 2022. And if you go to page 73 of that report for 2022, the minister told us that the independent valuation report by Duff and Phelps would have been contained in this report that I'm reading from. You know what was in this report in 2022? I quote, this is CLICO. In 2022, the company determined the fair value of its shareholdings in Methanol Holding International Limited using a combination of both the income and the market approach. This is what we were told in the report, that the company, CLICO, determined their own valuation strategy and mechanism. You know what was the valuation CLICO put the shares at, Mr. President? $337 million US. That is for the 56.6% shareholding of CLICO in Methanol Holding International Limited. You know what we discovered? There's another valuation report that puts the valuation at $357 million US. The question that we are asking, Mr. President, what is the true valuation report that the government used to determine the sale of the 36.5% shareholdings, with 17 going to NIF and 19.63 going to Corporation Sole? Was it the independent valuation report by Duff and Phelps, valued at $357 million US? Or was it, Mr. President, the in-house valuation conducted by CLICO?
Senator, you have 2 more minutes.
So, which is valued, thank you, Mr. Which is valued at $337 million US. A difference of almost close to 700 to 800 million TT dollars. So what we are asking, Mr. President, for clarification, we would like the minister to tell this parliament which valuation report was used to sell the shares of CLICO to NIF and to sell the shares to Corporation Sole. Was it the in-house valuation report, or was it the independent valuation report? And in closing, we want copies of the shareholders agreement. We want a copy of the sale and purchase agreement. We want a copy of the share valuation agreement. And we want a copy of the independent and actual final valuation report, so that Trinidad and Tobago would be able to transparently see what they got in exchange for the sale of shares to NIF and to Corporation Sole. This is the issue, and I would need clarification on behalf of the people of Trinidad and Tobago. I thank you, Mr. President.
Minister in the Ministry of Finance.
Thank you, Mr. President. Mr. President, unfortunately, this is not the question that Senator Mark posed to the Ministry of Finance. And I shall repeat the question, the official question, for clarity. The need for the Minister in the Ministry of Finance to address the inconsistency in information provided to the Senate and information contained in CLICO's 2022 financial statements on CLICO's shares in Methanol Holdings International Limited. There was no mention of valuation or valuation report. The question was quite vague and confusing. If Senator Mark were to ask a more focused question in the future, we have no problem in researching and responding to his pointed question.
supplementals when we're dealing with matters on the adjournment. I now invite you to raise the second matter that you have on matters for the motion on the adjournment.
This issue.
Senator Mark, the Minister in the Ministry of Finance, gave a response within the allotted time that he has as it relates to this procedure.
The government is involved in a major cover-up.
Senator Mark, I'm on my legs. And you understand the procedure that when I'm on my legs, that there is to be silence to allow the chair to speak. Again, move on to your second matter on the motion for the adjournment.
$700 million involved. Mr. President, let me go on to the second matter. Mr. President, the second issue I want to bring to your attention and the country's attention is what I call house padding and voter padding by this government. Mr. President, the government, when they took what I call the tragic, the unfortunate, or should I say the deliberate decision to close down Petrotrin. You know what happened, Mr. President? Without any consultation with the OWTU, the PNM took a decision purportedly to do what, Mr. President? To distribute land to Petrotrin workers. What happened, Mr. President, is that in Felicity, where the workers, the farmers, I should say, were farming, the LSA, which is the agency that is executing government's policy in this regard, bulldozed the land, the farmers' crops. And that took place sometime in April of 2023. What I would like the government to tell us today, this land that the farmers were on, that they, the government, the Prime Minister, who addressed the Parliament on December 17, 2018, in a statement to the Parliament, indicated, Mr. President, that the land in Felicity was earmarked for agriculture. This is what was told to us. He said in his statement, that is the Prime Minister, these lands are in Chatham in particular and other areas in Felicity. And he went on to say that this land would be used for agribusiness. So in 2017, the land in Felicity, December 17, 2018, the government told us was for agriculture. Yet still the LSA have bulldozed the land to establish 630 residential lots, and purportedly for the Petrotrin workers. They never discussed that with the OWTU. That was the representative union of the workers of Petrotrin. Unlike Caroni, when it shut down, all Trinidad had an agreement with Caroni to distribute lands, residential lots, and agricultural lots for the workers. In the case of Petrotrin, PNM to house pad and to voter pad, they decided on their own, without any discussion, consultation, or agreement with the OWTU, to do what? to share land in Felicity, to give out agricultural residential land in Kaipichaima. If you see, it's as if the PNM has taken a decision to just vote apart and house pad in an effort to give what they said land to Petrotrin workers. Who asked all you for land? The Petrotrin workers asked all you, but the representative union said they made no such request. And you cannot go and speak on behalf of the Petrotrin workers without speaking to the OWTU. So you went behind the back of OWTU and you give land to Petrotrin workers? No, you can't do that. You have to talk to the OWTU. So, Mr. President, the reason why I've brought this matter today is because the LSA, Land Settlement Agency, and its chairman, some chap called Innis, they bulldozed the crops of workers and farmers who were using the land in Felicity. I would like the minister to indicate whether the land that the farmers were on with live crops, mangoes, edos, pumpkin, whatever crop you could think about, they had it on the land. And they send bulldozers and they destroy all those crops. For what? They claim, Mr. President, they want to build 630 homes on that piece of land in Felicity. But, Mr. President, did the Prime Minister tell an untruth? Did he lie? Did the Prime Minister lie to the Parliament when he said on December, or did he tell an untruth?
There's a point of order, Senator Mark.
46.4. Might he temper his language, please?
So, Senator Mark, as
yes,
you're well aware, the language that you're using...
That is why I say untruth. I withdraw. Yeah, Mr. President, I am saying that in this statement, the Prime Minister is on record as saying to the Parliament that the land in Felicity would have been used for agriculture. How come the Prime Minister didn't come back to the Parliament and tell the Parliament, I have changed my mind? It is now being used for house padding and voter padding. Why didn't you come back and tell us that? Instead, you bulldoze the lands that the farmers were using, and what? 630 lots. And, Mr. President, the reason why I've raised this matter with you and through you to this Parliament is to get from the government.
Senator, you have 2 more minutes.
Yeah, to get from the government whether this land in Felicity is state land or is it land owned by former Carney, and those lands were allocated to the sugar workers. And if it is not state land, then the government must explain to the farmers why they did what they did. So this issue is a very serious one. The PNM government, Mr. President, has decided, as I said, to go behind the back of the OWTU and create their own arrangement with the workers, the former Petrotrin workers. And let me make it clear, I have no problem with workers getting land. I have no problem with workers getting land anywhere. All I'm saying, Mr. President, is that I have been in consultation with the OWTU, and I have been advised that arrangement is between the PNM and the workers of Petrotrin. They never consulted, they never spoke, they never discussed. There is no agreement between the OWTU and the government to provide lands for the workers of
Petrotrin, whether it is agricultural lands or whether it is residential land. This is P&M on a frolic of their own, using the Petrotrin workers in order to house pad and to voter pad for the 2025 general elections in Trinidad and Tobago. And that is why they went on the spot, the Felicity land, and they bulldozed the land, they bulldoze the crop, and they destroy the farmers' land. Thank you, Mr. President.
Ministry of Housing and Urban Development.
Thank you very much, Mr. President, for allowing me to contribute in this House. First of all, this weekend is a weekend that we celebrate for the mothers, and I like to honor our mothers of Trinidad and Tobago. Mr. President, I would not give Mr. Mark the same response that Senator Mark, that my colleague would have given. What I would say, however, is two things came to mind when I listened to his contribution. One was they start to make excuses for the song licking they're going to get in 2025. And the second thing was Senator Mark is not informed. So what I will do, in response to his contribution, I will try to inform Senator Mark and, by extension, Trinidad and Tobago. Mr. President, first of all, these persons are laying claim to state land without proper authority. There are procedures for accessing state land. There are land use approvals that have been had, and the actions of these people are in violation of all these procedures. To encourage this behavior is to condone widespread disregard and lawlessness. The government has not taken any decision to destroy food crops in Felicity community or in any community, for a matter of fact, in favor of constructing homes. On the contrary, food security and housing are top priorities in the National Development Strategy 2016 to 2030, better known as Vision 2030. In fact, Mr. President, Vision 2030 brings to the fore critical issues of one time, including climate change, the use of renewable resources and water, energy, and food security. The government's plan are further addressed in the roadmap for Trinidad and Tobago, transforming to a new economy and a new society where a key pillar is making food security a reality. Simultaneously, housing remains one of our top priorities in Vision 2030. Theme, putting people first, nurturing our greatest asset with the goal of ensuring that citizens have access to adequate and affordable housing. From its very inception, this government had a clear plan for housing and agriculture. As a small island with limited land space, we are skillfully balancing these two priorities, mindful that we do so if we are to achieve the United Nations Sustainable Development Goal 2 and 11 respectively. Our commitment to affordable housing and food security is also reflected in the far-reaching and wide-ranging government programs in several ministries that are funded in the national budget for fiscal 2022 to 2023. In the motion, should the Honourable Senator be referring to lands earmarked for former Petrotrin workers, where the government prevented said lands from being lost to persons unlawfully occupying Woodford Lodge 2, formerly Felicity 2, to plant crops? The facts are as follows. From January the 27th to the 31st, In 2023, the Land Settlement Agency of the Ministry of Housing and Urban Development invited stakeholders, including the residents of the neighbors to Woodford Lodge, to a public consultation on proposed infrastructure development works at Woodford Lodge. This is done in keeping with the government's policy framework for the distribution of residential lots for agricultural plots to former Petrotrin employees who received termination benefits resulting from the closure of Petrotrin refinery and restructuring of this exploration and production activities in November 2018. The Land Settlement Agency is tasked with the development of residential lots for former Petrotrin employees in different areas, and provision of infrastructure and necessary lotification is provided. Woodford Lodge 2 is one of such designated sites. The nation was reminded of this during the reading of the 2023 national budget, when it said, the Land Settlement Agency is also spearheading infrastructure development of all residential lands with the pre-approved housing plans to be distributed to former Petrotrin workers. 8 sites are now being developed: La Savane, Guayagarari, Nurse Trace, Guayagarari, Glenroy, Princestown, Woodford Lodge, La Romaine, Ponderosa, Golconda, La Philippine, Grand Couva, and Guapo, Point Fortin. The Woodford Lodge site, located at Chaguanas Main Road, Chaguanas, west of the commercial center, is one of the sites for development, which will yield, as Senator Mark said, 630 residential lots and other areas that's designated for commercial, recreational, and institutional use. The general works consist of construction of drainage channels, detention ponds, treated roads with reinforced culvert crossings and pipe culvert crossings. The works also include water reticulation and sewage networks. The site has been subdivided into 5 areas for development purposes, and contracts have been awarded to contractors to develop these 5 areas for residential occupations. Since 2012, the site has regularly been patrolled by the Land Settlement Agency, and all incidents of illegal agricultural squatting reported to the Commissioner of State Lands. The LSA and the Land Management Division of the Ministry of Agriculture, Land and Fisheries have conducted multiple site visits during which illegal occupants were advised to remove their structures and crops. The agricultural squatters, however, did not always comply, and with this advice immediately. As advertised, a public consultation was held on Thursday, February 2nd, from 6 p.m. to 8 p.m. at the Chaguanas Community Center to inform residents of the proposed development works, and it was noted that the presence of agricultural squatters could pose challenges for the project.
Minister, you have 2 more minutes.
Okay. The LSA site was conducted. The LSA site visit was conducted on Tuesday with the land management team, identifying lots. And just to scroll along and just let you all know, occupants were advised that failure or refusal to cease the illegal occupation would result in action taken pursuant to Section 20 of the State Lands Act, Chapter 5101. 1 week later, after the service of the quit notice, we served quit notices, the Commissioner of State Land advised the LSA to take possession of the site and to commence construction activities. The LSA in turn gave an additional period of 7 days to occupants to facilitate the removal of crops and fruit sheds. On April 12, 2023, upon following the instructions of the Commissioner of State Lands and in the presence of representative of the Commissioner of State Lands, the LSA gave right of possession to the contractors and advised them to proceed with their works in accordance with the contracts executed. The Ministry of Housing and Urban Development and the LSA have adhered to all lawful practices with respect to planning and construction of housing units for former Petrotrin workers, and indeed for all citizens of Trinidad and Tobago who seek and qualify for government housing. The Minister of Housing and Urban Development remains fully committed to providing citizens with access to adequate and affordable housing, making cities and human settlements inclusive, safe, resilient, and sustainable. Mr. President, I thank you very much for this opportunity.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, May the 16th, 2023 at 10 a.m. Those in favour say aye. Aye. Those against say no. Senator Mark, well, take a seat. I'm not done. I think the ayes have it. The Senate do now stands adjourned to Tuesday, May the 16th, 2023 at 10 a.m.